In this short video, my team and I are giving you all the resources you need to be able to delete any negative item off of your credit. Quick story time. My journey started in 2021. I made a $3,500 investment into a mentor that led me to learn about credit repair. I never really knew about credit consumer laws before that. Then, after that, I made an additional investment that allowed me to learn about consumer laws. I started my business in February of 2021. Fast forward to June 2022. I left my 9 to 5 based off of the impact of the information. I worked at chemical engineering, 9 to 5 job. I say all this to let y'all know up until now, 2025, 3 years later, still have a credit repair and funding business. My point in telling you this before we get started is that this information is very, very powerful. Don't just watch this information and not do nothing with it. Please do something with the information that I'm giving y'all. I'm giving y'all everything I got. I'm giving y'all everything based off of my experience since 2021, consistently deleting items, right? So hopefully y'all enjoy the video. Hopefully y'all get results. We're going to go through how to read the credit report and then relevant stuff. And we'll probably leave timestamps down below just so y'all can skip around to what you want to skip around to. But with that being said, no matter where you're at right now, if you're deleting items, if you're deleting it for a client, whatever, just know that just stay consistent, stay persistent. Number one is a mindset. We're not doing too much mindset in this video, so I'm just giving you the mindset right here. So with that being said, I hope you enjoyed the video. Y'all have a blessed one. Welcome back to my channel. As you can see, we're about to go over some credit reports. It's going to be a different type of video. I got Ajike. She's in the Cat Credit University. So, y'all can thank her because we're going to just go over a credit report just from like A to Z. Just give y'all like a fly on the wall type of conversation. Ajike, how you doing?
I'm doing well, and you?
Good, good. I'm blessed. So let's get straight into it. So basically, I wanted to do this type of video because I know that there's a lot of misinformation online, and sometimes some people are only looking at just the Credit Karma or the monitoring services. So as you can see right here, we have the actual Equifax report, and this was pulled from annualcreditreport.com. So number one, just like from the most basic thing, you want to be able to pull your actual credit reports. So that's going to be from annualcreditreport.com. And this is under the assumption that we want to go through litigation. Whether we go through it or not, we just want to do things the right way, the correct way. You guys probably see stuff happening with the CFPB, this, that, and the third, people doing the human trafficking stuff. So we want to have a foundation where we're actually using actual credit reports based off of consumer laws. So this is Equifax. We're gonna block out personal information. But so when you look at Equifax, you're gonna start out by seeing the summary. As you can see, the report date is right here. It was pulled on this date. Um, Average account age. When we talk about funding, average account age is very important because if someone doesn't have a lot of age on their credit, the banks aren't necessarily going to trust them. So when we look at length of credit history as well, that's very important as well. And then on Equifax specifically, they give you that high level overview. So if we have a client or if we have our own credit report, we're going to see accounts with negative information. So we're going to see there is 5 stuff. Oh, by the way, if you're watching this on a phone, I would recommend probably put it on a TV or computer because it might be small. Can you see it good, Ajika? Is it good for you, or should I zoom in?
It's a little small.
Oh, okay, let me zoom in. This is the first time we're doing this, and we're doing it just here on the spot. We're gonna figure it out as a unit. Is that better?
Yes.
I bet. I bet. So then you're gonna have your credit accounts. So you see right here, she has a most recent account that was opened on 2024, so September. So when we talk about business funding, a lot of y'all that may be watching this, maybe you're a aspiring business owner or a small business owner currently, you want to make sure you're not opening too recent of accounts. If you have an account that was open within the last 3 to 6 months, you want to kind of wait as you're about to go for your business funding. Oldest account right here is 2013, which is good. So that's going to add age. Obviously, when we remove old accounts, it's going to mess with the age. So you see the credit accounts here. So you see revolving.
Hmm.
Two open revolving accounts, and revolving is going to be like your credit cards, so personal credit cards that she has in her name. They have a mortgage section right there. Installment is going to be like your student loans, stuff like that, personal loans. You got other accounts, and then they have the balances and things like that. So just FYI, we're going to go into um, some of the accounts, but one of the things you want to look for is different balances. So if you're looking at your Equifax, you're looking at your Experian, you're looking at your TransUnion, and you're seeing different balances, and you know that those are things that you could dispute per 15 USC 1681 I A1A. So we're going to request a reinvestigation. And we're going to combine that with one of the laws that attorneys love to use, which is 15 USC 1681 EB. So the maximum possible accuracy section. Obviously, if we see something says 1770 here, but it says 1769, that means it's not maximum possible accuracy. Maximum possible accuracy doesn't mean 99%, it means 100%. So
Hmm.
keep that in mind. So you'll see the personal information here, inquiries, most recent inquiries, public records. If there's bankruptcies, you see the client has none, and then collections, but the client has none. One thing too you want to see about what's it called? Equifax, you see the summary on the bottom. So you have summary, then we're going to get into revolving accounts, mortgage, installment, they got other statements, personal info, inquiries, public records, collections. And my team will block out that name right there. But yeah, so section two is going to be revolving accounts. So it's pretty simple how to read these. One of the things that Equifax has is like a balloon payment. So when you see something like that, just recognize that's one of the things that they like to report as well. But let's just go to one account, for example. So when we look at this Siren account, we see the balance. So you report a balance $0. The table below shows up to 24 months of historical data. So we're gonna you show 2 years of payment history. So you see June 2023, it's $13. So we just want to know if it's our credit report, we're gonna know what our balance was. You see all these zeros reporting. Okay, cool. February is blank because February is supposed to happen. So scheduled payments, and then they have actual payments. But we're seeing some blanks here, right? So this is considered what we would say is incomplete. So if you see some incompletions, then you gotta be aware of that. If we're looking at 2023, they're talking about the balances, balance here. There's nothing here. Even if there was no actual payment made, it should at least report that $0 was paid. But this is an incomplete section. So what I would do, none of this is legal advice. I've gotten, I guess mentorship you could say from attorneys. They could say it's legal advice, but I won't say it's legal advice. What I've learned from them, incompletions are a thing that you can go ahead and point out. So I would take a marker and point this out, right? If it's your credit report or if it's your client's credit report and they know that they made an actual payment, or even if it's just $0, it should say $0 right there. So then credit limit. Okay, so they're reporting it. Amount past due, nothing. Okay, payment history. So this is the main thing that I've learned from attorneys as well. So when you see blank spaces, when you see ND, no data, that kind of thing. So you see no data available for Equifax. It's like this gray thing right here. So no data available, right? So for February 2025, obviously, that has to occur. But no data is available for May of 2023. So if I'm the client and I know that I made a payment there, it should have paid on time. So why is no data available? So if I'm disputing this and I'm somebody that I want to eventually take it to litigation if possible, I'm going to circle that and I'm going to point in my dispute letter under whatever account this name was, as I'm disputing the dispute reason, I would circle May 2023 has no data available when I paid on time. So that's an inaccuracy, that's an incompletion. 15 USC 1681 I A1A, we're basically requesting a reinvestigation. Reinvestigation meaning they were supposed to do an investigation in the first place before they put it on your report. So that's why it's a reinvestigation and not investigation. So per our reinvestigation, we're seeing that there's not maximum possible accuracy. So that's why this no data thing is very important. So account details. So amount past due, nothing's there. Actual payment amount, why is that incomplete? So if I know I made a payment, I'm gonna say, like, okay, why is that, there? So you want to look for incompletions. You want to look for incompletions like the no data available when you know you paid. You want to look for obviously inaccurate information. And this is how you actually go line by line, read the credit report, and dispute it the correct way. So this is obviously Equifax. So then we go to mortgage. Oh no, we're not on mortgage yet. Hold on. So I mean, there's more incomplete stuff. Okay, no, we're not on mortgage yet. So there's gonna be more accounts. So I mean, y'all kind of get what it is there. So when we go back here, payment history again. So I would recommend if you're new to it, I would recommend like go immediately down to payment history because more often than not, payment history is going to have an incompletion or something that's incorrect. If you see 30 days reporting in June, July right away, that doesn't make sense because you can't be 30 days late and then 30 days late again. It had to be 30, 60. Unless it was 30, you were paid on time and then 30 again. But if you see consecutive 30, 30, 60, 60, that's inaccurate as well. So you want to definitely point that out. It's
And I
kind
have
of
a question. And
go
so
ahead.
even there where you
Oh, you want me
see
to go
the
back
check,
up?
yes, sir. So even there where you see the check marks, right?
Yeah.
So even when it's paid down to zero, because I remember the other section you were saying when it at least should show zero. So for here under the check marks, that should also be a check as well. Even if the balance is down to zero, it should still be a check mark
If they made a payment. But if they
if they
didn't,
made a payment.
yeah, no, what I was referencing was that there was nothing like reported right there. Like it was literally
Mhm.
just blank versus saying like $0 was paid.
Gotcha.
Yeah, yeah. As far as a check mark, that's for it being paid. If there wasn't a payment, then not necessarily. If there wasn't a
Okay, that was
payment.
my question.
Yeah, yeah.
Hmm.
Okay. Okay. Yeah, no, that's a good question. All right, so we're in revolving accounts. We can probably go to a mortgage. So you can see too, this is secured credit card. So this is a closed account, so you can, read that as well when you're reading the report. Let me just go by. Okay, so then we're in section 3, which is mortgage accounts. So it says that the client does not currently have any mortgages in file. So if you don't have any mortgages and won't have any mortgages. So then we go to installment accounts. So revolving accounts was credit cards. So then we go to installment accounts. Installment accounts is going to be stuff like student loans, personal loans, things you use to build up your credit, like, this awesome capital. So same thing. So we're going to look at basically our whole history. So January 2025 is being reported 1770. So if 1770 is true, it better say the same on on Experian. It better say the same on TransUnion as well, because of 15 USC 1681 EB, the maximum possible accuracy, right? So we see there's a balance here, balance here, balance here, balance here. So we just want to basically make sure that the balance is what it is. And then scheduled payments, if there's anything blank and we did make a payment, then that's inaccuracy as well. So it's on the client also to obviously know what their situation is. If you have a credit repair business and obviously you want to talk with your client and make sure, do something like this where you're walking with them step by step if you can, and just make sure everything is good. So one thing that we do with our company is within our SOPs. I have my team meet with the client and they go line by line to make sure stuff are what they say it is. So if just on the business tip, if you have a credit repair business, you want to make sure you have that conversation with the client. Uh, So yeah, same thing. Just go back to payment history. So as you see right here, it says May 2024. They have a 30-day late. But I see April 2023, there's no data available. So I don't know if the client made a payment, but if they made a payment and obviously if they made the payment on time, why is there not a green check mark? So that's something that I would request as a reinvestigation. The reality, these credit bureaus are so backed up with disputes, some people doing actual disputes like what we're doing, some people doing the human trafficking, some people just doing a lot of disputes. They get so much coming in they're not going to do an actual investigation. So it works to your favor if you go through and do it the correct way like this and then send it a certified mail as well. So when I'm working with my one-on-one clients, preparing them for litigation, arbitration, or whatever the case may be, this is how I'm doing it. I'm printing out the report, circling line by line and all that. So it's tedious, but I mean, this is the right way to do it. So they got other accounts, so LVNV funding. So collection, obviously, if you guys have seen some of my other videos on the channel, definitely if the debt collector is contacting you, harassing you, all that, you want to take a look into that or get with an attorney for that. And then you see account number here to have the last four digits. Technically, you could argue that this is incomplete because the whole account number isn't there, but I would more so focus on payment history is more of a thing to point out. So you see collections. When we go back to payment history again, so it's collection everywhere. Even though we know it's a collection, why is this June 2024 no data available? That's still incomplete at the end of the day, you know? So even though we know it's a collection, it's still incomplete. So these are things that you want to point out. And you can kind of see as you're pointing out so many different things, they're not going to, when they're already not doing an investigation, they're not going to do no investigation to me investigating all this stuff. So you're just saving yourself by taking the time and disputing it the correct way.
Mm-hmm.
That's LVMV. Payment history again. I mean, I think y'all get the point. And then we're gonna look at Experian TransUnion as well, just to give a different look on what they look like. So they don't have a statement at the time. Personal information. So personal information is very important. One thing I just want to address real quick. A lot of people say, oh, should they call in for personal information? Should they send a letter? And I say both. Within our company, we actually do both. So within our dispute letter, we also want to make sure we have one of everything. So one name, one address, etc., job, all that. But we also call as well after we send the letter. So the name of the game really is just applying as much pressure as possible because these people aren't even going to be doing no investigation anyway. So you want to just do as much as you can. So as you can see right here, they got a current address. They got former addresses. They have former addresses on file. You technically don't have to have them be reporting. And the reality is that some of these former addresses may be attached to some of the negative information that may be on the report. So I would recommend getting all the former stuff removed. Employment history, it looks like it's just one on there. So that is good. You know, that's good. So that one's good. And then hard inquiries. So the client doesn't have any hard inquiries right now, which is, good. So as far as soft inquiries, that's usually somebody looking at their own credit, so we don't need to worry too much about that. And then public records, they don't have any bankruptcies, judgments, liens, or anything. But as y'all see, these crooks, LexisNexis, you would want to dispute with them as well. I already have a video on my channel as far as bankruptcies, collections. I got videos on my channel already. And then, they're supposed to give you your rights under the FCRA, or that's already an additional violation. So, I mean, that's Equifax right there. So, pretty much same thing with Experian. So, Experian is good because, they have, I mean, Equifax does it too, but I like reading Experian more because they have that at a glance just at the top. So, you could just do a quick run through. So, when I'm looking at clients, when I'm trying to get them business funding, I just look at a quick glance. Okay, 10 accounts is good. If I see someone has like one or two accounts, I know they're not going to qualify for the business funding. Zero public records. If I see one, two, three, I don't see three, but they're not going to qualify. Zero hard inquiries is good. We obviously know. I've already put a video on removing hard inquiries on Experian, well, all of them, but Experian is easiest to remove. Just call and remove it. And then the thing I see here, so I would see five names, five addresses, one employer, so the client's good over there. But I'm interested in this five names, five addresses. So I would be interested in having my team call and send a letter, just making sure we have one of everything. So there's various names and there's name IDs attached to it. So that's the thing with addresses too, especially with Experian. Sometimes they make it like a pain in the ass to remove them, but you just gotta persist. Phone numbers, you could try to have one as well. And then Experian, they make it easy as well because they'll mark on the credit report, okay, this is potentially
Hmm.
negative, etc.
Right.
You have a question?
Oh no, I was
Oh,
agreeing with
okay,
you.
okay. Okay,
Mhm.
my bad. All right, and then so we're just getting straight to accounts. So you'll see here account number again. So right here, kind of like what I referenced earlier, this is technically an incomplete account number because it has all this XXX stuff. I don't know what XXS is, maybe it could be somebody else's. So date opened, you want to be aware of that and then measure it with, I already cut out the Equifax report, but measure it with Equifax, measure it with TransUnion, and then obviously you as a person of the credit report or you want to talk to your credit repair client about when they open these accounts because they should know. So status updated. Oh, my bad. This is kind of small. Let me make it bigger.
I was gonna wait. I said when he pauses, I'm gonna tell him.
Oh, okay. No, no, you good. Is that better?
Yeah.
Okay, cool. So balance is right there. One thing I'll say, this is an incompletion. So recent payment, if well, you have to talk to the client. Um, a recent payment. So the client should know if they made a recent payment. If they made a recent payment and it's not reporting, that's incomplete. Monthly payment, if I have something and I've had it open for a while, I should know what my monthly payment is. How come they're not reporting that? So I would go over that as well. And then, okay, so I'm gonna look at payment history per usual. So 30, 60, not okay, so this is accurate so far, 120, 150, and then charge off. Okay, so these are accurate. But I would say, okay, how come November and then December of 2024 are not reporting? So that's what I would say on there. But as far as this 30, 60, 90, 120, I mean that's accurate reporting, but we already pointed out some incompletions up here, so they still have stuff to investigate or reinvestigate. Scheduled payments. Okay, so $0. And then they always have the address of the creditor. So again, potentially negative right here. So it points it out to you. So balance, you see incomplete. Recent payment, incomplete. 30, 60, 90, closed. Okay, so this was open in what, July? Okay, so July 2021. These are accurate, accurate, accurate. 30, 60, 90, close. Okay, I mean, payment history is reporting as it should, but there's still some incompletions that you could point out for the client. Account closed July 2022. Yeah, so it's closed July 20. Wait, it said account closed July 2022. Okay, so this is inaccurate. I'm tripping because they said account closed July 2022, but they marked them 90 days. They marked the client
Mhm.
90 days late on July 2022, and then they were closed August 2022. So somebody's capping. Down here is capping,
Mhm.
or up here is capping. So I mean that's just one thing. I mean you just gotta talk with your client about that. But yeah, so you see how little things can just get misconstrued, and then that's something we want to be aware of again with 15 USC 1681 EB. So really, you just need these two laws as far as everything you're doing. Um, People that's watching may have seen on my channel the 4 hour masterclass. I did 2 hours of FCRA, 2 hours of FDCPA. But when we keep it super, super simple, you just need 1681E section, 1681I section. Just bounce on those two laws as you're going about these inaccuracies, incompletions, and inaccurate information. So absolute resolutions, INV. So this looks like a collection account. I would tell the client, just be aware of, the debt collector contacting them. Date open was here, 2024. It's incomplete account number. I mean, you request a debt validation. They're usually not going to have everything in the entire purchase agreement. So We've talked about that on the channel before. You guys can go look at old videos of that. I'm gonna assume you guys know how to remove a collection. You see the balance there, balance updated. I don't know if there's a recent payment, but they gotta reflect that. And then they said it was opened. Hold on, when was it opened? Said it was open September 2024. May, June, July, this August, September. But it doesn't mark it as a collection here. It only marks as a collection starting October, so it is already incomplete. So I
Mm-hmm.
would point that out as well. And one thing I've talked about in the past, specifically with collections, if you're trying to go about, I mean, it's not legal advice. If you're trying to go about suing the debt collector, one thing you got to be aware of is when you're doing your FCRA disputes versus you're contacting them and letting them know not to contact you about the debt. Because under the FCRA, when you send a dispute, the credit bureaus are supposed to contact the debt collectors. So if they're following their job, then the debt collector is going to contact you. So then, if it does go through a legal route, the debt collector could be like, "Oh, the credit bureaus told us to contact them." So just be careful of the process that you're doing per item. That's just some extra sauce for anybody that wants to take a different route on that. And then we have a firm, so it has a 30-day late for the client. So it says past due 30 days. But I mean, y'all see some stuff here. So paid close, date open February 2024, February, March, April, May. Status updated. When was it closed? June? Does it say anything different? Okay, it doesn't really say anything different, but there's some 30 days past due as of June. Okay, I mean that looks like it's reporting accurately. It's just some incompletions.
Mm-hmm.
Okay, and then this Austin Capital. I know we saw that on Equifax. So again, as you're going through them, the easiest thing to do would be just to print them all out. But obviously for the sake of the video, we gotta have a screen share for y'all. So same thing. My favorite thing really is just to go to the payment history and then just see some stuff that doesn't add up. So this was open in May 2023. So May 2023, was it closed? No, it's open. Okay, so okay, no, this payment history is actually reporting accurately. So because February is about to happen. Okay, I mean this is actually reporting
So the issue with that one is there's a late payment
secured
notice on
loan. Yes, status
it. Okay.
updated. Recent payment 49 as of January. Highest balance. It's a secured loan. Okay, has a 30-day late. So in this case, because so based off what I'm seeing right now, the payment history looks like it's reporting accurately. I don't know if the client was actually late or not, but let's assume the client was late. We still have 15 USC 1666B under our belt as far as sending to the creditor and making sure that they actually follow regulations to report that late payment. Because in order to report that late payment, it's under the 1666B law, but within 21 days, they're supposed to mail you something. So we would basically do what I had said in that video that I posted. I think we posted it recently. I know it's in the university, but we would go about it with the 1666B route. That's if the client was actually late. I don't know if your client was late or not, but
Okay.
if they were actually late, this one looks this account actually looks the most reporting accurate that I've seen so far. So I would point that out because I mean you still can exercise that right under 1666B, and that's what we've done for some clients as well. Yeah, it looks like well, I don't know if balance is so I would just I would compare with the different credit reports and then just what the knowledge of what your client knows based off of that account. So I don't know if they would
Okay.
log into their thing or whatever, but yeah. And the LVMV funding, so collection accounts, so same thing, just what I said about the collection before. So this ND, no data. I like looking at that. I like circling that, highlighting that because you can't tell me there's no data. So that's inaccurate. I mean, that's incomplete. I mean, technically inaccurate because it's supposed to be a collection, but that's an incompletion there. They got self, balance, not reported. That's incomplete. When was this opened? Oh, 2021. Okay, so June 2021, May, June. Okay, so that's cool. 3060 closed. When was it closed? It says it was closed January 2022. Okay, so I mean, that's reporting accurately. There's just still some incomplete information over there because I don't know what the client's payment was. They're not reporting their balance. They put the original balance, but they still supposed to report that information because it's supposed to be, maximum possible accuracy as well. So I would point that out. Account paid from collateral. So I'm hoping that y'all, as you're watching the video, you can kind of see how you would read your own report or your client's report if you got a credit business. This one doesn't say it's not a negative account, so I won't even play with it. That's not negative. So yeah, you want to see like Experian, I think they'll report the negative accounts first. Or I might be thinking about TransUnion, that accounts with adverse information. But that's how they report. As y'all see, the client had no public records. They didn't have any hard inquiries. Soft inquiries are when you pull your own report. So I wouldn't I would just tell the client not to stress out about that because it's just like when you're looking at your own credit. And then obviously they have to give you your rights under the FCRA. If you pull your credit report and this section isn't in there, then you better take it to an attorney. But they always gonna have it. Pretty sure their templates will have it. So then the final report that we're gonna look at is TransUnion. So hold on. So I see this one's like from 2022. So I would assume this is not gonna be as
It's
accurate as the other
accurate.
ones. You said what?
Yeah, you're right. It's not as accurate because it's not.
Oh, okay, no problem. So I mean,
Yeah.
we could still read it, but one thing I would encourage y'all to do is make sure your client sends you like the most recent for every single one. Just for this, but this is just for demonstration purposes. But if I was doing it as like a client, I would see that date, that credit report date that was created, and then we would make sure we get something more recent. So again, names, addresses, hella addresses, hella phone numbers, one employer, and then they basically have there's a word bank or a key or something for you to know what's what. So when I have stuff that's unknown, I would circle that because why don't you know? You know what I'm saying? So, and then they have a bunch of other things here. So if you don't know what something means, they have the key right here for you. So they got hella. Okay, yeah, that's what I was talking about. So TransUnion, they'll report your negative stuff first, so accounts with adverse information. So this particular client, one account with adverse information, this Atlantic one. And it's a secured account. See how it's reporting. Looks accurate so far. Okay, let's look at payment history. Was this account opened? It's opened. June 2021. So balance past due, blah, blah, blah. Rating okay. So it says 30-day late here. Okay, so this one's actually reporting accurately. just off of first glance, to my knowledge. So I would, so in this case, I would look at different balances. If the client has different balances on compared to other reports, obviously this one's going to be different from the other 2025 ones that we were just looking at. But they even got last payment made, payment received. So it looks like they were reporting pretty accurate on this one. But it's an old one anyway, so I wouldn't put too much emphasis on it. So this Comenity Bank one, same phone number not available. Um, Transferred was charged off, so it's a charge off. When was this opened? This was opened. Oh shit, 2008. Okay, so they're gonna have like the last 2 years. So these are already inaccurate. I mean, incomplete, which will go under that same situation because if the client knows that they made a payment or technically that they were late because it says 30, 60, 90, 120, this should say 150. But if they were continuing to be late. But all this X, X, X and all that, that's unknown, which is gonna be an incompletion. Oh, this shit too small, huh? Or no?
I mean, I could
Okay.
actually see it, but thanks
Oh,
for
okay. All right.
doing
Cool.
it.
Cool.
You
Okay.
good.
Yeah. If you're watching, hopefully you've been able to see. I already told them to put it on a TV or something. Like, don't
You
watch on your
did, you
phone.
did.
Yeah. 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 Okay. That'd be all right. All right. So I think we went over Comenity already. I think we did. Unless it's a duplicate. So yeah, look at the main thing. The main thing is y'all probably know I like looking at is payment history because a lot of times they tend to like fuck up on the payment history. I see some incompletion stuff. Amount paid is incomplete. So, I think y'all get picture. I don't want the video to be too long. I think y'all get what it is. So payment history again. So scheduled payment here is $29, but they don't have a scheduled payment here. So that's obviously incompletion. They got a scheduled payment here. They don't got one here. They don't got one here. They don't got one here. So those are incompletions. Navy Fed, unsecured, balance 1970, charge off. They ain't got no balance. So that's definitely weird. That's incomplete. So I mean a lot to go over here on TransUnion. I think y'all get the picture. So this is how you read a credit report. This is how you point out what's on there. And what I would say after you point out what's on there, I mean you could highlight like if you're using maybe Adobe or something. I would recommend just printing it out, having a pen circling it, and then just explaining what's going on. You could put violation of 1681 E or 1681 I or whatever, but you want to explain it in your actual dispute letter and just kind of point out like just point out colloquially what was going on, like your dispute reason. This account was incomplete. It didn't have a past due amount. I'm just using that as an example. Obviously, they have a past due amount there, but just explain in your letter what's going on. So that's why, like, when people are using templates, a lot of times it's gonna be catered to your own situation. So you don't want to just rely on just template and not doing nothing. I guess you can consider a template listing the account and the dispute reason, but did you have a question?
Mhm. I did actually. And so when we see these inaccuracies, we're basically saying, like, for instance, like the collection. So we're basically saying because there are inaccuracies within this report, we want this collection account removed off of our credit report, basically. Okay.
Yeah, because under 1681 I A1A, I mean, y'all can look it up. It's not something that I made up. It was here before I was even alive. But under 1681 I A1A, it says that once they do that reinvestigation, it's supposed to be corrected, removed, deleted, etc. So it's on you in your letter to like instruct them. Okay, this needs to be deleted because this is inaccuracy. It's an inaccuracy. The
Hmm.
reality, they can't just correct the account, but you want to tell them to remove the account, especially if it's a collection, obviously.
Hmm.
But the thing about with a collection, for example, the thing about it is we're not just at the mercy of we just can only send letters to the credit bureaus. We can also send a debt validation to the debt collector as well. So for you or just anyone watching it, I wouldn't get too worried about like, oh, if they just corrected it, the payment history or something. It's still a collection. It's
Hmm.
still you're still they're still supposed to reply when you're asking them about to validate the
Hmm.
debt or whatever. So just remember that it's not just like a one trick pony type of situation. You can always send to multiple parties. When we talk
Hmm.
about the CFPB, I mean, people can still make complaints, but let's assume the CFPB, you can't make no complaints no more. Obviously, this is the foundation. These are the letters as far as pointing it out and just allowing it to lead to a type of litigation, whether that's arbitration with like Experian or so. I got a couple of clients in that right now. I'm helping, whether that is going through small claims or if that's going through federal court. So you just
Hmm.
want to make sure that you have your proof, and your proof is going to be in your actual report. So if you're watching this video, you don't want to fuck it up. Remember from the beginning part that I said, you pull the actual credit report, which is the annualcreditreport.com one. Yeah, you can pull what's it called? Identity IQ and maybe Credit Karma and stuff like that. But you don't want to get in a situation where they're just like, oh, that wasn't at like actual data or just these loopholes and stuff because I know what I know about these laws, and I've had successes helping people with litigation and stuff like that. But at the end of the day, I'm not an attorney, so it may be certain things that I'm missing. But I've always been told, I've heard from attorneys, get the annualcreditreport.com to try merge over here. So that's what we've always done. If it ain't broke, don't fix it type shit. So I would just
Hmm.
recommend I would just recommend continuing to do all that. So anybody that's watching, start annualcreditreport.com, especially if you're thinking about like you might want to sue on the back end. Even if you
Hmm.
don't, it's just good practice to do.
Right.
So then we got the good accounts. So you'll see with TransUnion, they'll have this accounts with adverse action, and then adverse accounts, and then they'll have satisfactory accounts, which are obviously good accounts. So we'll have that. And you might see some of the good accounts will have incomplete information as well, but if you don't remove it, don't worry about it. So
Right.
then I think that's the end of it. Yeah, inquiries. So the client actually does have inquiries, and then they have their soft inquiries. So the client has some inquiries on their actual TransUnion, but they don't have any on the Equifax or Experience. So then you should, like I say, you should see your rights on the bottom. So you see the summary of your rights are always gonna give you that in their template. So I mean that's how you read these damn credit reports. Hopefully this was a helpful video. Jika, did you have any specific questions? We can go off camera if you have like personal questions, but I guess any
I
questions on
don't.
camera? Okay.
Now on camera, and this is just for the sake of, being on the cam so other people can see it.
Okay.
I remember in the past I did ask you a question. What happens if you have an account that has multiple late payments on it, but it's not a collection, it's not a charge off? Do you say, but it's a closed account, like you in good standing, so to speak. You know what I mean? Like, what do you do with that? Do you say, hey, I just want to remove this account altogether, although it's not a charge off and it's not a collection? Or do you keep it because if you actually fix, let's say it has like 10 late payments on it, you fix the 10 late payments, but you want to keep the history of that account because if once you get the late payments removed, I mean, it looks really good. How would you
Yeah.
go?
10 late payments is crazy. First of all,
I'll just
nah, I know for example's sake. That's a tricky situation because you got to think about the fact of what you said, something that's been on there for a while. So I would have to look at the report and see, do they have some other relatable accounts that are long paid? Like student loans, for example,
Mhm.
I know that a lot of times they're usually the oldest account for somebody, but sometimes I'll have multiple student loan accounts. So if it's just like one particular account and they have other accounts that have a good amount of history, then I would say just go ahead and remove it. But if it's like their only account that has that good payment history, I've never had an account where it was like more than three late payments and then we're just going late payment by late payment. I mean, I've had students take on that type of situation, but it just takes a minute. But
Gotcha.
if it's like more than three late payments, to be honest, we usually just go for removing the entire account
Gotcha.
because it's gonna be a battle, you know. So
Mhm.
I think it's one of those situations where you got to just sit with the client and just explain to them the different scenarios and just the fact that the easiest thing to do is going to be to remove the entire thing. So I would look for kind of like how we read here, I would look for those inaccuracies and just tell them to remove the entire account. You could always ask them to correct it, to pay it on time. And if it's like if it's one late payment. So when I spoke about earlier in the video, the 15 USC 1666B. So we had a client, they had one, I think they had one late payment on their auto loan. So we use that to get it corrected. But if they had like maybe five, six and all that, I would have told them to remove the entire
Mhm.
account. So in that scenario, that's a tricky scenario. Then
Mhm.
we get into the complexities. If it's student loans, should they remove it because now they don't qualify for FHA, things like that. So you just got to be
Mhm.
you just got to be careful and have the dialogue with the client. Because if you do remove it and that's the only old account that they have, then all right, it's like they got to build and build
Right,
again.
right.
So that's one of those situations we've avoided, but it is a realistic scenario for some people. So
Mhm.
that would essentially be my answer.
Gotcha. And I was
Yeah.
throwing that out there because that's something I haven't really seen talked about
Hmm.
in the credit repair space. My next thing that I want to say was, so in short, when it comes to litigation, going over the credit report, excuse me, seeing the inaccuracies, and basically just going to file within your local area for small claims, of course, paying the fee for that. And so basically, when you're in litigation, you're just literally going over the inaccuracies, right? And stating the codes basically in those actual like case situations.
What do you mean by when you're in litigation? Are you talking about like in the actual like
Yeah,
court
in the
date
actual, yeah.
or the process to get there?
No, when you're actually in your appointment, the actual day.
Oh,
When
okay.
you
So I mean,
have the other lawyer representing the company,
yeah.
and then you have like someone there that's kind of like a judge, so to speak. Like, is that how you all are doing it? Where you're just saying, okay, I have these inaccuracies here, and these are the codes that support the fact that these are inaccurate, and I would like it removed, and I would like $1,000, whatever you're trying to go for in small claims. Is that pretty much in a nutshell what happens the day of?
Yeah, so in my situation, helping people that doesn't happen. It always gets resolved outside. Of course, so everything I'm telling you that we're doing is what we're doing. We're keeping the green return receipts and all that. And then once we actually file, specifically in small claims, once we actually file that small claim suit, then that's when we're basically receiving an email from like the credit bureau, like TransUnion, for example, them saying that okay, this is what's happening. Let's take a look at it, and then they typically just settle out. That's for small claims.
Gotcha,
I
gotcha.
know I've a couple clients for arbitration with Experian. Kind of same thing. It takes a longer time. And then something like a federal court, I would recommend working with an attorney, but that would just be like a back and forth paperwork for the most part. But it's
Mhm.
not necessarily, I mean, I guess every situation will be different. I did have a client in the past. They came to me, I think like a couple of days before their court date, and they were just asking for consultation. But I couldn't help them at that point, because it's like a couple of days
Gotcha.
beforehand. So that's the one client I had that actually went to court, and I think they just brought like their paperwork and other stuff. But When done right, I would say that it's going to be settled outside of court, and then they're going
Hmm.
to give those deletions, mail the client their new credit report after the deletions, and that whatever the case may be.
Okay. Okay.
Yeah.
I'll hit you in the chat if I have any other questions, but I don't have anything right now.
Okay, so I'm gonna close out the video. Hopefully this video was helpful. Make sure y'all like, comment, subscribe, do everything. If you're in the Cat Credit University, make sure you contact or network with a GK as well. And with that being said, y'all have a blessed one. We're gonna go over the only law, consumer law, that you need to get any negative item deleted from your credit report. So make sure you watch the entire video because we're going to give y'all the sauce and how to go about it. So, all you need 15 USC 1681I procedure in case of disputed accuracy. That's the section that we're in. We're going to cover 15 USC 1681I A1A. Before we get into it, remember the whole purpose of credit is to use it. So I want y'all to use these laws not only to clean your credit, but you want to be able to leverage your credit, which means going to get your personal funding, going to get your business funding, and leveraging to be able to go get a house on the personal side, if that's what you want. Go get that vehicle that you need if that's what you need, right? So just understand the whole purpose of credit is to be using it. I see sometimes some people that watch my videos, they get so like in tune with obviously, like reading the laws and all that, but you gotta use it. It's to be used, right? If you the information is cool, that's cool, but I'm about practicality. How can you use it to move forward? So yeah, 1681 IA1A. So we're gonna break it down. Subject to subsection F and except as provided in subsection G. I'm going to highlight this. If the completeness or accuracy of any item of information, right? So, what does that mean? And why is this law so powerful? Because we're talking about any item of information, meaning when they didn't say if a collection, they didn't say if a charge off, they didn't say if child support, if a bankruptcy, right? They said any item of information. When you're reading a law, that any word means there's no restriction on what they're talking about. I was about to say FDCPA. The FCRA doesn't define like okay, if the collection is complete or accurate, right? They said any item of information. This could be personal information as well. This is why 1681 IA1A is super, super powerful, and it's a deadly weapon that's going to help you if you do what I say and you stay pressing them, right? So we're talking about completeness or accuracy. Let's even highlight that too. So completeness or accurate. So let's make it a different color. So completeness, right? When you look at your credit report, you're gonna see like an account number and it'll have the stars, right? And like how Experian does it. That's not complete. So that's already incomplete. When we talk about accuracy, I'm pretty sure there's some inaccuracies on your credit report. Every credit report got some type of inaccuracy. So it's on you, the consumer, to do what you need to do to question that. The dope thing too about the 1681I A1A law, we're requesting a reinvestigation. Let me even focus on that too. So reinvestigations, right? So the reason why it's a reinvestigation is because before the item was placed on your credit report, they were supposed to do an investigation in the first place, right? So that's why when we request something, it's a reinvestigation because they're supposed to have reasonable procedures in place to make sure that items were already accurate before we even requested our reinvestigation. So understand what's going on when you're reading this law and what's supposed to be in place. If you really like zero in on it and really understand the process and the procedure of what's supposed to actually happen, literally says procedure in case of disputed accuracy, meaning you disputed accuracy, you know that this law is a powerful weapon and you can use it to your advantage when it comes to not only getting the item deleted in maybe 1 or 2 rounds, but having that evidence for litigation if you need to go ahead and sue the credit bureaus. So remember, every credit report is going to have an inaccuracy. Every credit report is going to have something that's incomplete, right? And then obviously something that's unverified, that's like a third criteria for getting the item deleted. So the completeness or accuracy of any item of information contained in a consumer's file, right, which is your credit report, consumer's file at a consumer reporting agency is disputed by the consumer, right? So this is you, the consumer. So you're sending your notice, your letter to dispute the items of information that are incomplete or inaccurate, right? And the consumer notifies the agency directly, so like via mail or indirectly, it don't matter, right? However you notify them of such dispute, the agency, meaning Experian, TransUnion, Equifax, and them whole ass bureaus, shall means that they have to do it, right? So they're supposed to do it. Shall, free of charge, conduct a reasonable reinvestigation. This is a sauce, though. They never conduct a reasonable reinvestigation because if you don't know, they have third-party people like people in third world countries like India, Philippines. They just are just gonna press a button that says like, okay, it's verified or whatever, right? That's not a reasonable reinvestigation. A computer system, you're giving me a code and you're just saying verified. The reason why what's the reason why they do it? The reason why they do it is many reasons, but the reason why they do it, one of the main reasons is because think about it, it's millions upon millions of consumers. We could say billions, right? But it's so many consumers. So many people are disputing items of information at so many times. How are they going to be able to do a reasonable investigation or reinvestigation for everybody? It's not going to happen, right? And then an additional thing y'all got to realize is money. What do I mean by money? Everything is about money. Them reporting the negative items, they're getting paid to report these negative items, right? So these banks or whatever, negative items that you may have or your client may have on their credit report, the people are paying the bureaus to be able to report that information so they can, hold that against you and all that. So it's not in their best interest to do a reasonable reinvestigation because they're going to lose money as a result. But on top of that, too, the reason why they're running around like they POC is because the fact that consumers are not suing them on a mass scale. That's why my channel is so important because y'all are being empowered with the information to be able to go ahead and get them to that next level. Furthermore, those of y'all that aren't cheap in your personal development, you invest, you understand that you have access to powerful information. If you're just a free watching subscriber, I appreciate that. If you take action, but if you're just watching my content, you're not doing nothing with the information, you're literally the reason why your family is not further along in life, right? So I say that to say, don't watch my information and then go do stupid stuff by not taking action. Take action with the information I'm giving you, right? If you're gonna be cheap and not invest in yourself, at least take action with the free information I'm giving you. So that's a main reason why the bureaus are making a lot of money because people don't press them. People just gonna send dispute letter after dispute letter after dispute letter, right? And that's dumb to me because you already know that they're not doing a reasonable reinvestigation. Well, if you didn't know, now you know. So now you have no excuse. So they're supposed to conduct a reasonable reinvestigation to determine whether the disputed information is inaccurate and record the current status of the disputed information, right? So that's one thing that they're supposed to do, or delete the item from the file, right? So this is where your deletions come in play. In accordance with paragraph 5, before the end of the 30-day period, blah, 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 right? So that's what they're supposed to do. This is what the law says. This is not something that Michael Benjamin said that, the credit bureaus are supposed to do. This has been said before I was even alive, right? Before I was even a thought, you know what I'm saying? So keep that in mind. One thing I wanted to cover too is this is why it's important not to necessarily send multiple disputes while you have a pending dispute, because anytime you send a dispute and then you send an additional dispute within that 30-day period, that'll be categorized as new information and give them a grace period, an extension of 15 days, right? So that's what this law is basically saying. So keep that in mind when you do send out information, or if you're doing it for your client. if you always want to ask your client before they become a client with you, do you have any pending disputes? If they do, you got to reset the whole process, right? Or just wait until that pending dispute is done. Because you don't want to get in a situation where they're categorizing something as new information. So keep that in mind. All right, so determination that dispute is frivolous or irrelevant. I wanted to just talk about this real quick. I already gave y'all the law that you need to go ahead and get results, but this is something that's BS too. And I want y'all to be aware of that because sometimes what'll happen is the consumer reporting agency will terminate your reinvestigation. They'll say some nonsense, right? But this is a key right here. If the agency reasonably determines that the dispute is frivolous or irrelevant, they have to reasonably determine that. What does that mean? They have to do a reasonable reinvestigation. So you saying verified, you saying, I think this is not you or whatever, that's not a reason to mark my dispute as frivolous or irrelevant. So that in itself is a violation. So I want y'all to pay attention to that part because I know sometimes what I hear is that consumers will be in a situation where they send out their dispute and then the consumer reporting agencies are now saying that they can't process it because of whatever BS reason that they want to give, right? So you can't just say that the dispute is frivolous or relevant if you didn't even if you didn't have proof that you did a reasonable reinvestigation, which they won't have proof that they did. So keep that in mind. This could be a potential exhibit to help your case if you do want to go ahead and file a lawsuit against these people. So with that being said, if you want like a specific letter written with the 1681I A1A law for you, just like plug and go. We literally have our university, Cat Credit University, where you'll have other like-minded individuals. You can see what they're doing as well. And that's a $39 a month investment at the time that I'm recording this. And it's just a dope community to be a part of because not only will you get access to that letter as well, but we give you multiple high income skills such as like, the business funding, suing debt collectors, obviously the credit repair, and just how to remove any negative item and, more information on the litigation aspects. So with that being said, hopefully this video was helpful. Make sure you like, comment, subscribe if you got value from it. If you're cheap and you don't make no investments in yourself, I hope you at least take information. I hope you at least take action on the free information. Those of y'all that are my tribe that I make the videos for, that are willing to make an investment in yourself, I'll catch you in the university. I look forward to seeing your wins. I look forward to helping you get to the next level, aside from just removing these negative items, but also empowering you even more. So with that being said, y'all have a blessed one. The credit bureaus always say verified, but they don't actually show you how they verify the information. I'm going to show you the one law that you need to go ahead and get that negative item deleted. Watch the entire video. So we're going to go to section 15 USC 1681I, procedure in case of disputed accuracy. The specific law that we're going to use 1681I number 7, right? So description of reinvestigation procedure. A consumer reporting agency, which is the credit bureaus, shall provide to a consumer a description referred to in paragraph 6B III by no later than 15 days after receiving a request from the consumer for that description. So when you send out your initial notice, the disputing information, the items of information, which you should do pursuant to 15 USC 1681I A1A, which is what I recommend, they may be like, oh, verified. Nobody's verifying your damn information, right? Y'all got to realize too, if you don't know already, these credit bureaus are getting paid to report this negative information on you. So it's not in their best interest to report accurate information. So they're gonna make it like a hell of a ride to get that negative information deleted. But what I'm showing you here, 15 USC 1681I number 7, is the legal backing for what's gonna help you have it on paper as far as the legalities to get that negative item removed. Is it a guaranteed item will be removed? No, that's not the case. You got to think about it. It's the same thing like if you're driving right now, you're texting and driving. Technically, you violated the law, but you just didn't get caught. So it's the same thing with the credit bureaus. This is why it's important not only to understand 15 USC 1681 I number 7, but also understand exercising your rights, right? Suing these credit bureaus once you have that claim that's presented. This is considered a 1681 I claim, right? So you got to understand in the congressional findings section of the FCRA, it talks about the fact that they're supposed to maintain reasonable procedures. So as you study more, it'll make more sense. Some of this may be reviewed for some of y'all, but 1681 I number 7, this is where you want to spend your time when you're being told verified, and they just tell you that without like actual explanation. You know what I'm saying? So keep that in mind. So like I said, it's referring to 6B So let's go to 6B. So notice of results of reinvestigation. Remember, it's a reinvestigation, meaning they were supposed to do an investigation before they put the negative or inaccurate, unverifiable information on your credit report in the first place, right? So 6B. So basically, it's saying that they're supposed to include this part. Notice that if requested by the consumer, a description of the procedure used to determine the accuracy and completeness of the information shall be provided to the consumer by the agency, including the business name and address of any furnisher of information contacted in connection with such information and the telephone number of such furnisher if reasonably available. So they're supposed to provide to you this information in terms of how they actually confirmed the information, right? But this is a spoiler alert. They don't do all that because they just hire people from overseas that just click a button and say it's verified. So when you get told verified, you always want to use, in my opinion, 15 USC 1681 I number 7, because you'll have the legal backing of what you're requesting from them that they're not going to provide to you, right? So you got to remember under the FCRA, when you make a demand, it's not like they have an option that they can just choose not to address what you're saying, right? When you see the term shall, it means that they have to do it, right? So hopefully this is helpful. Continue watching my videos, take action on what I'm saying. If you want an actual template in terms of how to actually put everything, you know, together, we do have a university, Cat Credit University. It's only a $39 a month investment at this point. I'm recording this. It could be higher by the time you tap in. So with that being said, watch this video, watch more of my videos, but most importantly, take action. Y'all have a blessed one. An item was reinserted on your credit and now you don't know what to do. Watch the entire video. I'm gonna walk you through and I'm gonna show you a specific letter on removing that reinserted item. This is not gonna be the video where I'm giving you all the certifications on why you should listen to me. You can go to my YouTube channel and figure that out. We're gonna give you all the sauce. So let's get straight to it. None of this is gonna be legal advice, by the way, so just keep that in mind. I got on the cat. If you don't know my company, Consumer Ammunition Tactics, I could buy all the designer in the world that I want, but I choose to represent my company because I mind the business that pays me. So we gonna give y'all the sauce. So if you implement what I say, you're gonna be able to buy all the designer you want, buy all whatever you want to buy, right? If you implement the information, because it's a high income skill. Our mission is simply to help fund $1 billion to small business owners. So if you're a business owner, you're an aspiring business owner, you help fulfill the mission when you get these items deleted or re-deleted in this specific scenario. So just ultimately understand that the whole goal is really to help y'all get as much business funding as possible and just help you start growth scale businesses, business owners, stimulate the economy. So that's why we represent that. So when it comes to a reinsertion, we want to really focus on 15 USC 1681 I, procedure in case of disputed accuracy. So that's the section that we want to really focus on. So you want to focus on 15 USC 1681 I 5B and its requirements relating to reinsertion of previously deleted material. I'm not coming on here telling you something that I just stumbled across and I didn't know if it worked or not. We literally have done this within our own company, right? And I've mentored people in terms of them removing previous deletions as well. So just keep that in mind as I'm giving y'all the sauce. So the I section, You want to focus on II. So notice to consumer. Basically, it said if any information has been deleted from a consumer's file is reinserted, the CRA or Consumer Reporting Agency shall notify the consumer of the reinsertion in writing no later than 5 business days after the reinsertion, right? So that's basically what has to happen. If you don't know, if you're new to consumer laws, you got to understand that there's a lot of regulations that go into this, especially the FCRA. I would say the FDCPA is more for, I'm not gonna say it's more for someone that's like stupid, but the FCRA is more like regulations and processes and procedures and stuff like that involved. So as you're reading the law, just really understand that the law is on your side if you understand how to use it. So, additional information, you could just read this as well if you want to go to the specific law. Like I said in this video, I'm gonna make it super simple for you. I'm gonna walk you through a letter that we literally use within my company, just so y'all can, have that free sauce. Go get your deletion, and then you come to us when you're ready to maximize your business funding, right? So it's just giving additional information that has to be on there when they're providing you with that notice, right? So they're supposed to give you all this and highlights. Y'all can pause the video. Let's just talk about why does a reinsertion even happen. So a reinsertion does happen because sometimes it could have been the way that you disputed it. It could have been a soft deletion. Soft deletion meaning they deleted it. Now they're doing their investigation. After they're doing their investigation, now they're reinsert it. This often happens when people are doing like BS methods like the human or sex trafficking stuff. So just keep in mind that you could have had a soft deletion and it got reinserted. This is why you want to rely on consumer laws to even get your deletion in the first place. We've dealt with reinsertion, but to be honest, just to be transparent with y'all, we don't really deal with it as much with our clients because I'm willing to bet because we're actually using consumer laws and we're doing the justified way of disputing. So keep that in mind. They could have done their long investigation and then they finally tell you verified. So obviously you want to go to the method of verification as well. 15 USC 1681 I number 7. But when we're talking about reinsertion, just, I 5B. So this is why you need consumer laws only to get these deletions. Because if you don't get what you want right away, you understand if you've presented your case in a way of where you can go ahead and go through a litigation, whether you do it yourself or go through an attorney, at least you did what you were supposed to do as far as the 15 USC 1681 I, right? And just making sure that there is maximum possible accuracy per 15 USC 1681 EB. So what are you going to do? So what you need to do, you got to draft up a letter informing the credit bureaus that an item was reinserted and you weren't notified within the 5 business days of it being reinserted per 15 USC 1681 I 5B II. And like I said, we're going to look at a letter of that. So if you want to skip around the video, you can do all that, but I wouldn't recommend doing that because you want to make sure that you get every single aspect of what I'm talking about. So the burden of proof is on them to prove that they provided this information to you in a timely manner, right? To be honest, they're so backed up with so many consumer disputes, they don't even do a proper investigation. So this is why it's a really good angle in terms of if you're just from the beginning trying to do litigation, you want to request a reinvestigation. Reinvestigation meaning that they were supposed to do an investigation before they even put the item on your report in the first place. So reinvestigation 15 USC 1681 I A1A. You're requesting a reinvestigation, meaning that they're supposed to investigate or reinvestigate the items that are in question. For example, this could be incomplete payment history. If you paid on March 2024, why is your credit report saying ND or no data or is it blank, right? So that's incomplete. So it's not just about inaccurate items, it's about items that are incomplete. It's about items that are unverifiable, right? So just keep that in mind. That the whole process of what's going on, these credit bureaus, they're backed with so many consumer disputes that are always happening. A lot of them may be frivolous. A lot of them, like yours, if you're watching my YouTube, it's going to be backed by the laws, by stuff that's actually, the case. We're not going under saying sex trafficking, human trafficking, all that, right? We're using these consumer laws for stuff that's actually legal standing. All right, so yeah, violation under the section, it's potentially a 15 USC 1681 I violation. You could possibly sue them for, right? So just keep that in mind. We'll talk about the elements that you want to have, but I don't need this. I want to go over the template just so y'all can have a guide as far as what to look at. You can basically just pretty much copy the guide that I have here. You can chat GPT it, you can Claude.ai, whatever you want to do, right? So we have the client information, or if it's for yourself, you put your information, obviously the credit bureau's name. The title we just have is that you're in violation of 1681 I-5, treatment of inaccurate or unverifiable information. Remember, it's not just inaccuracies, it could be unverifiable, it could be incomplete information. So just let them know I pulled a copy of my report. I noticed the following account was reinserted. So then you put an account, right? And then one thing I like to add, and this is just to be transparent, this is some game that I got from an attorney. So, these people they live, breed all this stuff. I'm more adept at these consumer laws than the average consumer, but I understand that it's attorneys that live and breathe and like I've been doing this since 2021. It's attorneys that have been doing this like way longer than me, right? So this is where I've gotten some of my mentorship too. I've been recommended that you should just like talk colloquially and reference the fact that these credit reporting agencies, they're not, I mean, these credit reporting agencies and the creditors are not really reliable. If you look at the CFPB complaints against them, stuff like that, right? So I've gotten this game from an attorney, just to be transparent. Everything that I know is not just from me knowing it. I study under people, I pay people to get access to information. That's just how life works, right? So basically, I need your agency to realize that these companies reporting this information are not even trustworthy, right? My credit report is not only it's not the only credit report that has issues with these companies, blah blah blah. So you see what I'm saying? The furnishers of the information are unreliable. So I'm basically saying whatever was reinserted, if it was BOA, if it was Discover, whatever, right? So I would say, okay, go look at their CFPB complaints against them. Go look at the BBB complaints against them, right? You need to do your own reasonable investigation, which we know that the credit bureaus are not going to do. So basically, I'm just framing and giving them context that they can't rely on what the creditor is telling them as far as reporting information. So I'm building up my case if we're going to go through litigation. So now I reference I-5BII, right? So I talk about the notice to consumer. So you want to reference that, not legal advice. And then I basically say I require proof with the tracking ID number, basically that they followed a procedure to basically satisfy what needs to be done for a reinsertion, which they're not going to be able to provide with you, right? And then I talk about procedures to prevent reappearance, and then I basically said that they shall maintain reasonable procedures designed to prevent the reappearance of this information. I require proof that XYZ. So I drafted up this letter myself. I give it to my higher ticket students and we use it for our business, but I'm giving it to you here for free. So there's no excuse for you to not know what to do with the reinsertion. You're watching this for free on YouTube. Not everything's going to be free, but I'm giving you a lot more sauce than some people's paid information. So keep that in mind and don't harass me in my comment section about, oh, he's selling something. He has a business. You go to that scamming ass 9 to 5 and you expect a paycheck. So I don't want to hear no BS about that. Don't harass me. All right. So can I require proof with the tracking ID number? Blah, blah, blah. Y'all get it. And then, yeah, best regards. So this is a simple reinsertion template that you can essentially use and, you know, potentially get that deletion. So I just want to go over the elements that you do want to have just so that y'all can have it in like a easy to remember way. So have letter proof that helped you get the deletion. So obviously, if we're talking about a reinsertion, you got the item deleted before, right? So have letter proof that they did delete it. So have a scanned copy of that, right? You want to have the date as well, because all of this stuff is documentation. So you have the date and proof that the item was deleted. Then you want to have your new credit report with the reinserted item. Have your new credit report with the reinserted item. So you want to have each step. I recommend you go to annualcreditreport.com and get your actual credit report, right? You use all those monitoring services and all that, but the thing about it, like Experience site and those different sites, sometimes you're giving up rights that you don't even know about. So this is why you want to use the annualcreditreport.com credit report. That's what I would recommend to you. And then you're going to inform them that they violated the section for not meeting the satisfaction under 15 USC 1681 I-5B. So specifically, section I was just going over for y'all. All right. So that's pretty much it. The reality is that credit repair methods are always changing. If you want accountability, you want a community where we keep each other updated on current tactics, strategies that are working. We have our Cat Credit University. If this is the first video you're watching of me, Cat Credit University is basically a monthly community that's only $49 a month, where you can tap in with us and get access to our letters and things of that nature. Obviously, $49 is nothing compared to the return on investment in this. And respectfully, if you think that $49 compared to getting a reinsertion deleted is not to the extent of where you think you should invest $49 into yourself, respectfully, get the fuck off my video. I don't want you to watch no more of my videos. You can unsubscribe, get away, and all that. I don't deal with no cheap poor people, and I don't want to deal with any cheap or poor people. So get off my video if you got that weird slavery mentality. All right, cool. So these are your options, right? I'm talking to business owners, people that invest in themselves. I'm not talking to cheap or poor people that think that everything should be handed to them. A lot of y'all that just feel entitled. A lot of y'all that watch videos, maybe you watch some of my videos, you're just like, okay, I saw this happen. Because I watched the video and I didn't take advantage of the opportunity, I should be entitled to the same deal that you were doing back then. We're always continuing to get wins. If you happen to find me at the time that our price increased, you can't go back to an old video and be like, oh, the price was this over here. Okay, this is the new price. You should have been tapped in. You know what I'm saying? This business. You know what I'm saying? So just keep that in mind. If you're somebody that recognizes value, then it doesn't matter what the price is. You just tap in at the time that you tap in. If you're somebody that, oh, I saw it was this price, I don't want to pay because you said it was this price back then when it was months ago when you didn't have the results that you have now. You gotta pay. You gotta pay something. You know what I'm saying? So yeah. So this is the thing. You could try to do it on your own. I'll be real. The issue with that is you've probably already wasted a lot of your time, your energy doing it your way. So let me ask you a simple question. Does it make sense to waste an extra 6 months trying to do it your way, or should you probably do something different? I'll let you answer that question yourself. So if you need to think about it, those of y'all that need to think about it, right? I understand, you may need to think about it, right? Ask yourself how long you've been thinking about it and pushing your credit off. Let's just say it's only been 3 months, right? Do you think if you took action 3 months ago with somebody else, don't you think that you would be in a better position than you are now? Mr. or Mrs. I need to think about it. So answer that. And then if you need to talk to your wife, those of y'all need to talk to your wife about a $49 investment. Ask yourself, would my wife really be mad at me for getting a solution from someone that has a proven track record of helping people fix their credit and getting them funded to the next level? I'll let you answer that. What's the guarantee? Some of y'all favorite ones. I guarantee you, if you don't do nothing, you'll still be stuck in the same situation. And why would you quit before you even start? Only losers ask for that. What's the guarantee that I'm going to get the reinsertion deleted? Right? You've been losing for 3, 6 months, 12 years, however many long. Then when you come across someone that has a proven track record, now you want a guarantee. What about the guarantee of the BS that you've been doing for 12, 13, 40 years? You know what I'm saying? So don't harass me with no guarantee. You know what I'm saying? But anyways, you can join our university in the description if you want to get tapped in. You have the opportunity to use our letters that my students and I are using to get these deletions. But yeah, the only catch is you're not joining and continuing to waste time trying to do something on your own that you've been wasting time and energy trying to figure out. The SEO obviously brought you here. Maybe you searched for this video. Maybe you saw the video and you chose to click on it. You're watching the video for a reason. So now I ask you, what are you going to do with the information? Are you going to continue wasting time? Are you going to tap in? Are you going to figure it out? Are you just going to watch this video and gonna go do something stupid again? So you got to figure it out. With that being said, keep watching my videos if you need to. But those of y'all that's ready to get to the next level, we'll see you in the community. It's only $49. To be honest, you should be getting the higher paid programs, in my opinion, if you want to get to the next level. But we just wanted to do something for the masses, so poor people can't say that we don't do nothing for poor people. That's why we created the $49 a month university to make it accessible to everybody. So with that being said, I hope that y'all have a blessed one. Y'all stay blessed. Keep watching my videos. Most people are trying to get items removed from their credit report through one angle, which is disputing through the credit bureaus. In this video, I'm going to show you a different angle. We're going to be attacking the furnitures, right? Most people don't think about doing it from this angle, so this will continue my series I've been doing as far as helping y'all being able to delete any negative item in 2025 and beyond. Just for validation's sake, I've been doing this since 2021. You can go to my channel, look at the different videos, different playlists, and go from there. I'm not going to sit here all day and convince you why you should listen to me. All right, let's get straight to it. So, 15 USC 1681 S-2, responsibilities of furnishers of information to consumer reporting agencies. I'm going to talk about a specific court case that went wrong and why it went wrong so y'all can have further knowledge on what y'all actually need to do. So watch the entire video. I'm going to have a surprise for you at the end as well. So when we look at it, 1681 S-2B. If you don't know, 15 USC 1681 is the FCRA, the Fair Credit Reporting Act. I'm going to assume you've watched some of my videos. You know what the FCRA is. You know what the FDCPA is. If you don't, go on my channel, go look at the 4-hour masterclass where I broke down the language of both. But anyways, so duties of furnishers of information upon notice of dispute. So the furnisher of the information is the creditor, the furnisher is the debt collector. Those are the furnishers, essentially. They give the information to the credit bureaus to report. Most people, what they do is they'll send their dispute to the credit bureaus, which is good practice and what you should do. But they don't think about holding the furnishers accountable as well, right? So keep that in mind. So you see, they say after receiving notice pursuant to 1681 IA2. If y'all go look at past videos, I've told y'all 15 USC 1681 I, the I section, the investigation section, is a very important section for the credit bureaus. We're looking at 1681 S-2. This is very important under the FCRA for the furnishers. So I'm hoping that this is making sense. 1681 E is also important too, the maximum possible accuracy. So just keep that in mind. So the duties on the furnishers. What are the furnishers even supposed to do? They're supposed to conduct an investigation with respect to the disputed information. So when you, as a consumer, send a dispute, it doesn't matter. It could be a charge off, it could be a collection, it could be whatever, right? If it's a collection, maybe you're disputing the amount, maybe you're disputing, the validity, whatever you're disputing, right? The validation is going to be with the debt collector, but just to give y'all an example, maybe it's a charge off, you're disputing the amount, the payment history, or something, right? You're disputing something. So they have to conduct an investigation. That's fair to you, right? So then they're supposed to review all relevant information provided by the Consumer Reporting Agency, aka Experian, TransUnion, Equifax, pursuant to 1681 IA2. Go look at 1681I and reference everything that they're talking about here, right? Because it's going to be very important for y'all to understand from multiple angles what's going on. They're supposed to report the results of an investigation to the Consumer Reporting Agency. So basically, just as a summary, what happens? You dispute, okay, I need this item deleted. It's actually inaccurate. You point out the inaccuracies. And then what happens? Let's say Experian, they send you a letter or they let you know, like, oh, verified, right? And that whole process, what's actually supposed to happen is Experian, TransUnion, Equifax, they receive the dispute from you. They're supposed to notify the furnisher, right? So that notifying the furnisher is going to be very important, right? When we talk about having a legal standing claim, you've got to make sure that you have reasonable, like, proof that Experian, TransUnion, Equifax actually reached out to the furnisher. And then you're going to see in the case that we're going to talk about, that's a very pivotal part of that, right? So if the investigation finds that the information is incomplete or inaccurate, report those results, etc. It's very just like when you're requesting a reinvestigation from the credit bureaus. So keep that in mind. They're supposed to modify it, delete it, block it, right? So cool. This is the important part. To actually have a claim under 15 USC 1681 S-2B, this is what has to happen, right? So a consumer, meaning you have to alert the credit reporting agency, which is who? Experian, TransUnion, Equifax, of your dispute regarding the allegedly inaccurate information that's being reported. So you send out your dispute letter. Of course, you want to do that certified mail so you have proof that you did it, right? So that's important. Cool. Boom. We did that. So you have to also allege that the CRA alerted the furnisher of the information of the dispute. That's going to basically trigger the furnisher's duty to investigate, right? Because if you don't include this part, which is very important, you're going to have a court case that gets thrown out. And then you have to basically allege facts that shows the furnisher actually failed to do a reasonable investigation of the disputed information. So whatever your situation is, whatever you're actually disputing, the accuracy and completeness, whatever, you got to have proof that they didn't do a reasonable investigation. So anything less than that, if you do decide to take it to litigation, or if you're working with attorneys, like what we do, we work with attorneys at this point, just because my main focus is the funding. If you don't know, our mission is to help fund $1 billion to small business owners. Part of that, obviously, the foundation is personal credit. That's why I do all this consumer law shit and help y'all, with this at least. So, yeah, keep that in mind. So, if you don't have all three of those elements, they're gonna be able to basically dismiss your claim. There's something called Rule 12B number 6. They can hit you with that, right? That you don't have a claim where relief can be granted. It's just like legal jargon stuff. If anyone's an attorney watching this, they know what it is. Or if you're a consumer that's at least hip a little bit, you know what that means. So let's give y'all an example of ideal winning situations. So an example is a court finds that the debt collector, which will be the furnisher of the information, they failed to adequately investigate a disputed debt, and they continue reporting inaccurate information after receiving notice of the dispute. So whatever's inaccurate on that. When the debt collectors get it, they don't get everything fully accurate, right? So over that whole transfer period, which is already a violation of that process, maybe they got information that wasn't accurate. So you sent your dispute, you have all three of those elements that I'm talking about. You sent the dispute, obviously, the credit bureaus received it, and then it triggered the investigation because they notified them, right? So, that helps you. So one practical thing is requesting the I've told y'all this method of verification. So under 1681I, number 7, under the FCRA, that's basically going to help you request a method of verification. So when they say all this verified stuff, if you request a method of verification, they're supposed to let you know what they did to find that. So they gonna say like, oh, we notified the furnisher and all that, right? So that's boom, that's your trigger. So then you can hit it from a different angle here with the furnisher, right? So once you actually have that alleged facts that they didn't do a reasonable investigation, and you'll know that based off of your situation. I don't know what your situation is. I don't know if it's inaccurate payment history. I don't know if it's inaccurate balance, that type of thing. So I don't know if it's not tied to you. So keep that in mind. So a different example, maybe a court finds that the creditor failed to properly investigate a dispute regarding the accuracy of payment history, right? Like I said, reported on a credit report. So sometimes payment history is off. Most credit reports have something that's off. So you just got to look at your reports and analyze it. I always tell people look at your actual credit reports. What's your actual credit reports? Your actual credit reports from annualcreditreport.com. The monitoring services are cool, but in my experience, from what I've seen, you give them reason to be like, okay, that's some third party thing that's not even aligned with the government website. So you don't want to put yourself in a position to where they have some type of leverage. You want to give yourself the maximum leverage. The maximum leverage will be going to annualcreditreport.com, right? I've been doing this since 2021, so listen to what I'm saying, especially if you're new to this shit. All right, so an example as well, a court finds that a furnisher failed to respond to a dispute within the required time frame, right? So look at the time frame as well. If you didn't get no response based off of your letter, right? This is why you want to do things certified mail. So based off of that 30, 40-day time frame, you want to make sure that you're monitoring the time frame as well, because under the FCRA, if they're not doing the investigation in a timely manner, you can trigger that. One thing I'll say too, though, if you do send a dispute, I wouldn't, like, let's say you send a dispute, it's within the 30 days, let's say on day 15 or something, you send something again. You can actually reset that time period and buy them more time. So I would be careful doing stuff like that. Like when you send stuff out, let the full investigation go first, and keep track when you mail stuff certified mail. So, yeah. So consumers cannot maintain a claim under 1681 S-2B based on this is where the court case went wrong. So based on stuff that's filed just directly with the creditor, directly with the furnisher, because it doesn't trigger them to have to be liable under the FCRA unless it's done through where, like I said right here, you allege that the CRA did alert the furnisher. So this is why you always want to request what was the method of verification so that the bureaus can give you that information. So whether the bureaus are saying that, oh, we contacted these people and that's where we got the information, or if they're lying or telling the truth, we just want to have that right there as proof that they claim that they did, right? So you can't just do it directly with the credit card company. So the case I was telling y'all about, it was Daniels versus Capital One. So you can go ahead and Google it. So Daniels versus Capital One, what happened was he sued Capital One and he alleged violations of the FCRA. But basically, he alleged that Capital One failed to provide information as to why it was holding him responsible for charges on his credit card account, which is cool. Capital One restricted his access, blah, 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 without investigating the fraudulent charges. But the thing was, he did it through Capital One. So they concluded that he failed to allege that he alerted the credit reporting agencies of the disputed charge of incorrect information that was being reported. So remember, 15 USC 1681, this is the Fair Credit Reporting Act. Fair Credit Reporting Act issues deals with the CRAs, right? So Experian, TransUnion, Equifax are always going to be relevant when it comes to statutes under 1681, specifically 1681 S-2B. So keep that in mind. So just again, an example of an ideal winning everyday situation. So a court finds that a debt collector failed to adequately investigate a disputed debt and continue reporting inaccurate information after receiving notice of the dispute. Remember, these things have to be in order, right? So maybe you also sent a debt validation letter and it can validate the debt as well. Because remember, when during the turnover process, these people at LVNV funding, all these collection agencies, they don't always get stuff fully accurate. And you always want to request the entire purchase agreement, right? And I understand that this stuff could be complicated and complex. So that's why I'm going to leave a link in the description so you can grab a free guide I made for you to be able to legally remove collections using these tactics. So with that being said, hopefully this was helpful. Share with someone, or if you want to help someone, and make sure you take action on it yourself. With that being said, y'all have a blessed one. Christmas came early this year. Watch the entire video. I'm gonna show y'all how to delete any item off of your consumer report. I'm gonna just give y'all a little hack, secret, whatever you want to call it. So watch the entire video. If you're new, if you get value from what I'm saying, make sure you subscribe, make sure you like, make sure you comment, make sure you do the whole nine. Share with someone that's gonna help. The economy is how it is, so I want to make sure that y'all are able to be positioned to be able to go get the money you need to get. And this basically starts with your credit. So if you have negative items on your credit, you're gonna want to pay attention. You're obviously gonna want to send notices, letters, but we're gonna walk through the CFPB removal process that'll assist your situation. So I'm gonna share my screen and we're gonna get straight into it. Hold on. It's right here. Let me delete the zoom thing. Maybe maximize it. I'll make myself bigger. Let me get a sip of the tea. Those of y'all that know I'll be sipping on some tea. Let's see what the quote is. They be having quotes on it. So it says we can always start again. So whoever that's speaking to, remember that we can always start again. We're gonna start again right now with our dispute. So let's say you send out your dispute and you want it to be more powerful. Some of y'all may know you can submit a CFPB complaint, Consumer Financial Protection Bureau. So to be transparent, we sell this document, but y'all are getting it for free. So it's literally in the video. So you can do what you want to do with it. But when you get our DIY recession repair remedy, it's only $7 right now. It's a whole course that teaches you how to remove whatever. It'll basically have a funnel where you can go ahead and grab this if you want. But if you're cheap, you're literally having it in a video now. But if you want it as an actual document, just go ahead and grab that. Go to that funnel. So just remember, everything we're looking at is a guide, right? It doesn't necessarily mean that this is the only way to do it. So keep that in mind. When it comes to your CFPB complaint, you got to realize that there's not necessarily a script for it. I'm just showing y'all the way that you could do it. But just remember that everything when it comes to credit, nothing is guaranteed. So you just want to do what you can, and then you'll be able to get to the next level that way. So if you don't know already, you have to create a CFPB account. So the CFPB website is consumerfinance.gov. When you go to submit a complaint, this is what it will look like. You're gonna have to log in. They used to let you submit as a guest, but they don't do that no more. So most companies respond within 15 days. Ready to begin. Start a new complaint. I'm just showing y'all where it's located, but I'm not actually, because you see, you gotta create an account. If you say already submitted a complaint or created your account, you're gonna click here and then just log in. And then you can check the status of what you've already done, or you can go ahead and submit a complaint. But this is basically the CFPB. Some of y'all don't know about the CFPB. Some of y'all know about the CFPB. I just want to show y'all so y'all making no excuses not to get those negative items deleted, so you can leverage your credit, go get the house you want, go get the car you want, go get the funding you need so you can go ahead and start your business, grow your business, or scale your business, right? You deserve the best life, so that's why I put out this information. All right, move myself over here. So yeah, you create your account, and then, so this basically goes through, it follows the DIY recession repair remedy course, and we're operating off of the basis of permissible purpose leading to identity theft, right? So the laws are 15 USC 1681B number 2, 15 USC 1681C-2, which leads to the non-compliance, right? Willful non-compliance, 1681N. If you want to do negligence, 1681O, maybe you've already sent notices, but typically you're going to start with the willful non-compliance because they're not doing what you told them to do, so they're willfully not compliant. They become negligent when continuously, do what it is. So just keep that in mind, that that's basically what our claim is based off of. Your claim is based off of whatever your claim is. So if you have a 1681EB claim, that's going to deal with maximum possible accuracy. So just keep that in mind. That's why I say everything is customized to your situation. So when you go through the CFPB, they're going to be like, what's the complaint about? You're going to select a prompt. This is what I recommend you select. Credit reporting, credit repair services, blah, blah, blah. You're going to select credit reporting. Improper use of your report. They use your report improperly. And then they're going to ask you, have you attempted to resolve it before? You can say no if you're doing like a reset, kind of like what did the T say again? We can always start again. That's no cap. It's literally saying that. So just keep that in mind. So if you're restarting a process based off of what I'm saying now, you can say no. It doesn't matter. You can say no, yes, whatever. But we typically say no because it's our first CFPB complaint that we're doing. Under what happened, write out your complaints, right? You can keep it short and sweet, but the way that we do it, we talk about the actual history of the Fair Credit Reporting Act. So as you can see right here, we just talk about how it says the banking system is dependent upon fair and accurate credit reporting. If you've been following me for some time, then you already understand how powerful that is as far as the history, just knowing the basis of what the FCRA is based upon. So whenever there's a violation under FCRA that impairs efficiency, blah, 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 violation of, like I said, 1681B number 2, C-2, 1681N. And then there's an example here that we use for late payments. So that's right there. We just use Chase Bank as an example. So the burden of proof is on them to show that you were actually late. What would you like the resolution to be? I'm not demanding verification nor validation of these accounts. These accounts listed shall be removed. Those of y'all that know about consumer laws, let me bold that. Let me underline it too. You know that shall means that it has to happen. It's not that it's permissive, right? Something that's permissive is may. It may happen. But shall, it's imperative that it happens. It has to happen. It's not optional. It's required. It has to happen, right? So I'm demanding that the credit reporting agency do what is fair and equitable. Again, we're going back to the language of the FCRA. Remember, this is Fair Credit Reporting Act. 1681C-2, they shall remove the items. And then you can just list accounts that you're actually disputing. And then you can also do personal information if you want. If it's like your first round, So you can put the correct year of my birth is XYZ. Only address is this. Only name listed is this. And then what you're going to want to do, you're going to want to attach your dispute document. You're going to want to attach a copy of your ID. You're going to want to attach a FTC report if you filled one out as well. So just keep that in mind. And basically, this is how you can do a CFPB complaint. And I definitely recommend, as far as removing items, whether you're doing it for yourself or if you have your own credit repair business. If you've been following me and you don't have no credit repair business, at least a side hustle, then you literally just hate money. You hate your family because you know you can be making additional money to go ahead and help them. And it doesn't have to be hard because you could hire people to go ahead and do the disputing for you. So if you've been watching me for an insurmountable amount of time and you ain't take action yet, you hate your family. I'm letting you know. I'm letting you know that you hate your family because we've done giving y'all so many chances, so many different resources as far as being able to fix your credit and get your credit to the next level with the funding. We don't put podcast episodes out with interviews of people that could inspire you. So just say you hate your family at this point if you haven't taken action. Just say you hate your family. Just say you hate yourself if you ain't fixed your credit. You ain't taking no steps to fix your credit. So keep in mind, the information is out there. That's basically what I'm saying. So if you're working that 9 to 5 you don't love, if you do take action, I'm here to tell you it's going to get better. But if you're someone that doesn't take action, you're just watching my videos, watching, no action, I ain't going to hold you. I can't guarantee you it's going to get better. It's probably going to stay the same or get even worse. So keep that in mind. Don't have that poor mentality. Poor people, they love just consuming stuff and not taking action. Poor people love dictating how someone should do something when they doing nothing, when they in the sidelines. Isn't it funny, like, if you look at basketball, like LeBron or Kobe, rest in peace, they're the ones playing in the game. But then you got people in the crowd that want to make their comments. People that wouldn't stand a chance of being in the NBA. So just remember, those of y'all that's like credit repair business owners, you're creators as well, you're creating content. Don't listen to these poor people that's talking crazy in your comments. Just remember, like, these poor people, right? The poor people that, decide to make these negative comments and they're not adding no value to society. They're worried about you. And maybe it's you. Maybe you're a hater watching this right now. If you're a hater watching my channel right now, you be hating on me or you be hating on whoever, you worried about me. You need to be worried about why your daughter, your son thinks that the number 5 is a color. You know what I'm saying? Like, you worried about the wrong things. You're worried about the wrong things. You worried about somebody that is adding value to the community. And then you got whatever issues you got with this. So if you're a hater, just talk to God and just ask God to pray the spirit out of hating from you. And, maybe you'll stop being a hater. I don't know. But yeah, the rest of y'all, I appreciate y'all support. Many blessings to those of y'all. Those of y'all that have that poor mentality, poor people, I can't help y'all. But those of y'all that's willing to take action, I hope this video brings you value and you actually take action. With that being said, make sure you like, comment, subscribe. Y'all have a blessed one. If you need help removing late payments, watch the entire video. I'm going to show you how to delete late payments the correct way. There's a correct way. There's an incorrect way. Let's get straight to it. So you're going to want to look at 15 USC 1666B, timing of payments. I'm pretty sure you've seen people talk about it online, but a lot of times people look at it in the incorrect way. So watch the entire video. It's going to be helpful. Make sure you do what I say. Make sure you like, comment, share, all that. So let's read the law. It's time to make payments. Maybe you don't even know about the law. Maybe you do know about the law, but let's read it. A creditor may not treat a payment on a credit card account under an open-end consumer credit plan as late for any purpose. Let's stop right here. You see that comma right there. A lot of people that do it the incorrect way, they just stop right there. Let's highlight in blue. They just stop right there, right? A creditor may not treat a payment on a credit card account under an open-end consumer credit plan as late for any purpose. And when I was first being familiar with 1666B, the law, I thought that was dope too. I was like, okay, cool. That's all that I need. But if you want to do it the correct way, you have to read the entire law. You have to read the entire law, and we're going to break down how to actually do it the correct way. One thing about credit that you've got to realize, maybe you don't know, is that credit is one of those things where there's so many ways to get to the end of the destination. I always compare it to a boxing match because in a boxing match, you don't know if you're going to knock someone out or someone's going to get knocked out in round 7. You don't know if it's going to be in round 5. You don't know if it's going to go all the way the distance in 12 rounds. So credit is one of those things that you just have to have discipline, consistency, and just put maximum effort that you can put. Just focus on getting that 1% better each and every day. It's like going to the gym too. If you're trying to lose weight, if you're trying to gain weight, you're trying to gain muscle mass, you've got to do those daily deposits, right? So same thing with removing the late payments. So we don't just stop at purpose, right? Let me just highlight that even different. We don't just stop at purpose because most people just stop right there. And then that's what it is. And I'm not saying you can't get results that way. You can get results, but it's like you're going to get results not knowing why you did get results. We're going to read the entire law. I need y'all to understand the correct way is to read the entire law. So it says, unless the creditor has adopted reasonable procedures. If you're familiar with the FCRA, you know that they have to maintain reasonable procedures. The creditor has to maintain reasonable procedures as well. Reasonable procedures designed to ensure that each periodic statement, including the information required by Section 1637B. I included part of it here just to show y'all like what creditors are supposed to give you to satisfy the law. Section 1637B of this title is mailed or delivered. We're going to talk about that to the consumer not later than 21 days before the payment due date. What does that mean in English, Michael? Basically, they're supposed to give you this information and it shouldn't be exceeding 21 days before your due date, right? So it has to be within that 21-day period of when your bill is due. If it's later than that 21 days, then they haven't satisfied the law, so they have to maintain these procedures. So I just, like I said, section 1637B, I put like just a little bit of what's in there. So I didn't put the whole thing. Statement required with each billing cycle. So the creditor of any account, blah, 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 they're basically saying what has to be included. So going back to 1637B, I just wanted to include it as a reference for y'all, just to show y'all all this stuff has to be included, like 1 through, it goes all the way down to like 11. And I think there might be a 12 as well. So you see the total amount credited to the account, the amount of the finance charge, blah, 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 blah. So you can go look up 1637B on your own time. I want to just get straight to it. So I just put most of what needs to be included when they're delivering this information to you, right? So one thing I want y'all to be aware of, anytime you see a late payment, the first thing that you want to think about is it on a closed account or is it on an open account? Because again, with credit, there's different ways to treat different situations. For the sake of conversation, we're talking about on an open account that you want to keep. You want to just correct the late payment. Maybe you got 30-day late or something, right? When it comes to like a closed account and you can go ahead and delete the account, like it's not good history. It's not necessarily good history for you, but it's just that the main thing is that the account is holding you back. You can take a different approach to it, right? So I'm not going to get into all the different laws and different approaches you can do in here, but we've gotten late payments deleted many different ways. So you could just study my channel and try out different things. But yeah, keep in mind that we're talking about correcting a late payment and keeping the account open. So pay attention to mailed or delivered. Let's go back to the law. Mailed or delivered. This is key. We want to be careful with these words. When you're reading a law, you have to be very, very careful. Mailed or delivered. Be very, very careful when you're reading these laws. These consumer laws, shit ain't sweet when it comes to these consumer laws. You know what I'm saying? So they're very, very powerful. So you want to make sure that you're reading it in its entirety and paying attention. Or just pay attention to my videos and do what I say, because I'm doing the work for y'all. All right, so let me move that out the way. So it says mailed or delivered to the consumer, like I showed y'all in the law. You have to remember the burden of proof to prove that they followed the law per 1666B is on the creditor. The burden of proof is on the company to confirm that they did in fact send it to you. And our approach when we're doing this, we're always asking them to prove that they did in fact send us the requirement, like the statement letting us know to basically to satisfy 1666B is my point. So this is why they like when you enroll in paperless billing. So this is where we talk about paperless versus paper billing. So when you enroll in paperless billing, they could basically upload it to your online portal and they could say like, okay, it was delivered to you in that aspect. But the thing is, we make it harder for them, and this is what you should do for yourself, your clients, whoever you're going through with a late payment. We make it harder for them when we enroll in paper billing. When we enroll in paper billing, now they have to mail it out to us, right? And that's kind of where we're going to use our angle to increase the likelihood of getting that deletion or correction, whatever you want to call it. So let's say you enroll in paper billing, which I recommend that you do for the sake of having this work in your favor. Once you enroll, they can claim like, oh, we did send it out to you and everything, right? The burden of proof is on them. Because the burden of proof is on them, I'm going to ask them to provide me with the tracking number based off of the certified mail, right? When we mail out our letters, certified mail, we got to have that green return receipt tracking, right? If you go to a court of law, you're just like, oh, I did my disputes and everything. The opposing counsel, which could be Experian, TransUnion, Equifax, they're gonna be if they didn't see that you did certified mail, prove it, right? So we're doing the same thing that they're doing. So we want to make them prove it. Ask them for the tracking number of the certified mail that they basically sent out. So they're not gonna mail it out certified to you. So they'll just be, oh, we mailed it out to you. But if you don't have a tracking ID number for that, then we can't prove that you sent it to me, right? We can't prove that they sent it to you. So this is the angle that we're taking. This has been powerful for us to get items deleted. Nothing is guaranteed when it comes to credit. I've told y'all this many times. The only thing that's guaranteed is if you don't take action, you're going to continue being in the same situation. So this is something that you can do to go ahead and get those late payments removed. And it's the correct way versus just stopping at purpose when we're reading the law, right? Because we know, but it says unless blah, 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 right? So we want to put the burden of proof on them to prove that they can actually mark us as late per 15 USC 1666B. Hopefully this is making sense. If it's not making sense, then rewatch the video 3, 4, 5, 6, 7, 8 different times. But if you want to improve your credit repair offer, if you're a credit repair business owner, or if you're just a consumer and you want to basically have a community where you can discuss how to delete late payments and many more negative items, if you got value from this, we do have a community, Cat Credit University. It's normally $100 a month, but we're allowing people in for only $39 a month at the time I'm recording this. So you can click the link in the description. Hopefully it's still $39 a month. You can come and get involved with the community. Every month, we're doing accountability calls the way that I was breaking down the law here. You can come and ask your questions live and get them answered. So with that being said, do what I say based off of this video. Hopefully this is helpful. Hopefully you can post your results and hopefully we'll catch you in the community. Y'all have a blessed one. How to delete collections is going to be a no BS guide to watch the entire video. We're going to walk step by step. So let's go ahead and look at my client that we got to 800, just so y'all can see, collections. So you see portfolio over there, Midland credit, portfolio. So you see deletions. You see 807, 812, 778. So almost 800 across the board. All these are collections. And it was basically consumer law that was used to delete these. So let's get straight to it. So time is of the essence. I said this in my last video that I just dropped, but y'all saw what happened with the CFPB if you watched my last video or if you've just been paying attention. Pretty much CFPB is getting shut down and it's gonna be harder basically to fix your credit. This is why when we talk about taking action, it's important that you take action. So Elon Musk actually tweeted this today. So I just saw this today. It says CFPB RIP. So y'all know what it is. Like, y'all gotta seriously take action. So do everything I say in this video if you have collections that you want to get deleted. Because I don't know what, they got planned in the future. You don't know what they got planned in the future. I'm just here to give it to y'all in real time. Pause. I'm here to give y'all the information so that y'all can, be up to date. So let's talk about how to delete collections. So, just like I said last time, you need to change the way that you think and understand that any item of information can, in fact, be deleted. If you cannot grasp that simple concept, then you're not going to delete the collection. If you're struggling with collections right now and you don't believe that, you're not going to delete the collection most likely. So, yeah, like I said, I've literally helped clients with situations where they sued credit bureaus, got a settlement with the credit bureaus telling them not to proceed with the lawsuit, and they deleted the item of information. So that's the proof that you need to understand that the item of information can be deleted. If you watch my last video with the charge offs, we're going to go a little bit more in depth here. I'm going to literally show y'all a letter, you know? So just keep that in mind. Just wanted to make this video a little bit better than the last one. So how to delete collections overview. So number one, the biggest thing you want to be aware of when you're dealing with collections is you want to send a debt validation letter to the collection agency. So this is not to the credit bureau, the credit agency, the debt collection agency. So the debt collector, right? The creditor. And then you're going to send a dispute letter to the credit bureau. So you want to attack on both sides. This is where we've seen the most success. And this is what I've outlined in my SOPs within my company. If you don't know what SOPs are, it's standard operating procedures. When you work a 9 to 5, a lot of y'all probably work a 9 to 5. When you work a 9 to 5, they have certain procedures for how things are done. So that's what SOPs are. So in the SOPs, my team knows, okay, we got to do this. We got to do this. We're attacking both ends. And we're not just sending a debt validation notice. On top of that, too, CFPB complaint. I'm literally walking y'all through how we did all this for my client, right? And with this whole CFPB shutdown thing, y'all better hurry up while you're watching the video while you can still make that CFPB complaint. And then BBB complaint as well. So BBB has been really good for us, specifically when it comes to collections. So, you know, I would implement that within your process. And I'm gonna give y'all a template as well. So anytime you see a collection from a third party debt collector, the first thing you want to do is request a debt validation. And watch the entire video because I'm gonna go in terms of not just getting it deleted, but I'm gonna give you information on if you want to get paid for the collection, right? So it won't be legal advice, but just watch the entire video. Or skip through if you want, it's up to you. So let's look at a sample debt validation notice. So you see right here, this is literally in my university. So it's only $49 a month if you want like all the letters. But this is just a debt validation one, sample one. So, you can go to ChatGPT and create a letter, but I just put it here as an example for my people. So basically a 15 USC 1692G, as you see, we're basically talking about the five things under debt validation law, that we're requesting. So that's what it is. That's just a sample debt validation letter you can look at. And you can literally go to ChatGPT, create me a debt validation notice using the law 15 USC 1692G. All right, let's look at a CFPB complaint template, right? So CFPB complaint directions. So for what's it called? For collections, we do it a little bit differently than how we would typically do it. So you see, select the most appropriate option related to debt collection, what happened. We attach our dispute document, and then we basically just talk about what happened, right? So that's essentially how we do the CFPB complaint for specifically collections. So I'm walking y'all through what my company literally does, so y'all can get the results that we get, right? Because we're not cheap to work with. So this is like I'm giving y'all the information. So let's look at BBB template as well. So very similar. We're gonna basically attach what we got from our CFPB complaint. So you'll go to the option, I like to file a complaint against a business, add the company name, select no for everything. So you could select submit a BBB complaint on their site. You're gonna input your client's information or if it's for you. And then yeah, this is basically what you do. This is how we have it in our standard operating procedures. So that's the BBB template. So hopefully this is helpful for y'all. And then what I would say, as far as like specifically the letter that you would send to the credit bureaus, you could literally go watch my other videos where I'm talking about 15 USC 1681I and create your letter based on that because we're looking for those inaccuracies, right? So I would recommend pulling your annual credit report like I told y'all last time. So 15 USC 1681I, 1681I A1A. If you watched the last video, you know what it is. You know I highlighted certain specific parts of it. And I don't know if I'll make this like its own series, where I talk about deleting the charge-offs, collections, maybe late payments next, and everything else. Y'all let me know. But yeah, we're talking about collections right now. So any item of information shall reasonable reinvestigation. They're not gonna do it, so they gotta delete the item. So again, you need to learn how to read a credit report and just look for common things. So these are your options. The same options you have like from last time, right? If you watched the last video, you could try to do it on your own. It's very possible to do it on your own, right? But the issue with that is you probably already wasted a lot of time and energy trying to do it your way. So let me ask you a simple question. Does it make sense to waste an additional 2 weeks trying to do it your way, or should you probably do something different? The simple answer is you probably should do something different, right? So if you've been trying to like figure it out, you want to continue wasting time or like be efficient. Like let's be real, you know? And then if you need to think about it, ask yourself, how long have you been thinking about it and pushing your credit off? Let's just say for 3 months, let's say 6 months, let's say a year. Do you want to push an additional year? Does that even make sense? That does not make sense, especially if you're coming on this video, right? Do you think if you took action maybe 3 months ago, 6 months ago, 9 months ago, 12 months ago, don't you think you would be in a better position than you are now? Enough, you gotta think about it. It doesn't make sense to continue to think about it. You're not thinking about nothing. I need to talk to my wife. Your wife doesn't want you to have a 300 credit score. You know what I'm saying? So let's just use logic. What's the guarantee? My favorite objection. I guarantee if you don't do nothing, you're gonna be in the same situation or even worse, right? If your usage go up, maybe your credit get even worse. So the thing too about it when you're asking for a guarantee, you're basically quitting before you even start. So I would ask you, why would you quit before you even start? Only losers think like that. If you're watching up until this point, I'm assuming you're not a loser. But if you're a loser, I recommend you click off my video because I make videos for winners. Um, as well as the fact you don't have access to someone that's been doing it for years. That will give you the extra strategy that may be that difference maker that you need. It's like a boxing match, an amateur versus someone that has experience. So you can join our university in the description. The video's not over. Keep watching if you want, more sauce. You got the opportunity to use our letters. I showed y'all the debt validation letter. We got multiple letters in there. The only catch is you not joining and wasting time trying to do something on your own that you haven't done, right? Or that you've been struggling to do, or that you're uncertain about doing, right? Because sometimes some people are like, oh, I'm trying to figure this out, but they don't want to invest nothing into themselves. You're looking at somebody online, somebody that I don't know you personally from nowhere. You're coming into my company, talking to my employees, trying to say that you're trying to figure out something, you're trying to get a result, you're trying to delete this, you want to hop on a call with me. Respectfully, it doesn't make sense for you to hop on a call with me for free. Like, how does that even make sense? All the results that we done got and the way that I'm busy, making money in my business, you know what I'm saying? So the way life works is money, right? So if you're like, oh, I don't see the point in investing $49 a month into myself, respectfully, forget your situation. I don't care about the item you're trying to get deleted. You know what I'm saying? I'm not gonna hop on a call with you for free. You know what I'm saying? So just keep that in mind if you do have that poor mindset, because a lot of people do have that poor mindset and just entitled mindset. And people are just selfish, and chances are you're selfish as well. So I do want you to use my information, but be respectful. If you want access to somebody like me, you have to have money. It's not just free. So part two of the video, let's get straight into it. If you're more advanced, this is for people that's a little bit more advanced. We're gonna go a different route if you want to get paid as well for those collections. But keep in mind, this is not legal advice. This is not legal advice. I repeat, this is not legal advice. Go share it with your mama, share it with your dad, share it with your homies. Let them know this is not legal advice. All right, so we're gonna want to record the call if we do want to get paid because we want to get them in a violation. And there's not always going to be a violation, but there can be a violation. So 15 USC 1692C, communication and connection with debt collection. So you want to look at the law, and specifically, we're going to look at CA1. So basically, what they're saying is that the debt collectors are not supposed to communicate with you with the collection of any debt. Go look up the definition of debt. I'm not going to break that down in here. If you watch my future, I mean, I said my future. If you watch my previous videos, you know what it is with debt. So, at any unusual time or place, at a time or place is known, which should be known to be inconvenient to the consumer. So, whatever is inconvenient to you, you decide that, right? And then they have the time for that. So, that's a violation right there. So, if you know what to do with it, you know what to do with it. At the consumer's place of employment, look at my situation. I used to work a 9 to 5, right? So I used to work as a chemical engineer. I retired that in June 2022. It's February 2025 now, right? So I've been working within my business for almost 3 years now. If a debt collector calls me right now, I'm at work. They're calling me at my place of employment. Now the thing for y'all, I can't tell y'all what y'all situation is. The thing for y'all, even if you're working 9 to 5, let's say you're being called, maybe you're working, maybe you have a business too. So do what you will with that information. All right, so you also want to notify the debt collector in writing that they said if a consumer notifies the debt collector in writing that the consumer refuses to pay the debt, basically they're supposed to cease communication. So for getting a violation, remember this is not legal advice. Getting a violation under CA1, I would recommend that you say verbatim, right now is not a good time to talk. When they call you, say that, record it. Right now, it's not a good time to talk. Why are you saying that? Because you're letting them know that it's inconvenient to you, right? So CA3, we just talked about work. You can literally let them know I am at work right now. So you have that recorded on a line. If they're repeated, if there's a repetition of them calling you and you have a repetition of this, you're building a case. That's not legal advice, but I mean, you analyze the situation. If they ask you when is a good time to talk, tell them, I don't know. Right now, I'm pretty busy, right? That's not legal advice. This is just maybe something I've seen, maybe something I've experienced. For lack of is a lack of a better term, I don't know what to say. This is this is entertainment purposes. Let me just say that. Everything I'm saying right here is entertainment, but do your research and you might see maybe what I'm saying is onto something. So if you miss their call, you can call them back too. And you can say, I got a missed call from this number. Did you call me? And then, you can kind of go from there. So the biggest thing about that, you don't really have to pay too much attention to this part. Don't pay too much attention to that part. But the biggest thing that I want y'all to take advantage of is understanding that when they call you, you don't necessarily have to run away from it. Don't run away from the calls and record the calls. Record the calls because there's violations in those. All right, so you could literally, as far as like refusing to pay the debt, you can handwrite something. You can say, I refuse to pay the debt. Take a picture of the letter for your record and send it certified mail. Send it out, and then, just letting them know that you refuse to pay the debt. So I just put an example right here for Midland Funding. And then let's say you do decide to go that route, the 1692CC route. I wouldn't recommend disputing with the credit bureaus because FCRA law requires that they notify the creditor. So if you tell them to stop communicating with you, you don't want them to have an argument to say like, oh, the credit bureaus told us to contact you, because under the FCRA, they're basically saying, okay, this person made a dispute, let's go contact the creditor. Now, in the back of their mind, they're like, oh, shoot, this person is trying to get us in the FDCPA violation. But Experian told me to contact you, or, because you disputed. So just keep that in mind as well. And then one thing you got to realize is that FDCPA actual damages is where you exceed the $1,000 situation. So statutory is limited to $1,000 per lawsuit. That's a statutory. And then so that means this is not legal advice. If you note 5 to 6 phone calls, it's not necessarily, oh, this is $5 to $6,000 in damages. The statute is limited to $1,000 per lawsuit, right? So that's a common misconception that people have. So I repeat your options. So these are your options. You can try to do it on your own. Issue with that, you probably wasted a lot of time not being able to do it. You can get with me, somebody that has the connections in terms of who's going to help you with this. As if you do have a case, there's not always a case, but yeah, just keep that in mind. As far as deleting the collection, getting paid for the collection, whatever you want to consider with the collection, you can continue wasting time, or you can tap in the link in the description. I just put the same objections here that you may have. So, with that being said, click the link in the description if you want to join us in the university, get more information, get more sauce. And with that being said, y'all have a blessed one. How to delete charge-offs from your credit report. This is going to be a no BS guide. It's not going to be no guarantee or nothing, but we're going to give y'all the sauce. Watch the entire video. Y'all know I got to post my receipts. As you can see, Capital One finally came out the report. One of my clients, you see 131-point increase. And as you see the date right there, hopefully y'all can see it. It was yesterday, which is February 5th. So I put it on my story. I was just saying charge off, deleted, consumer laws, all you need, blah, blah, blah. Cool. Let's get straight to it, right? So time is of the essence. This is why I have to put out this video like as soon as possible. Because if you didn't know, look at the date, February 3rd. Trump's consumer watchdog freezes CFPB activity on first day of job. Basically, they freezing activity on you being able to use a CFPB. It's gonna get ugly if you're not taking advantage of fixing your credit as soon as possible. I'm gonna give y'all the sauce so y'all can delete them charge offs, so y'all can delete, whatever negative item is on your credit. So I've been telling y'all this for years. I want y'all to take damn action. All right. So you can look this up yourself. I didn't make up this article or nothing. So how to delete charge offs from your credit report. Let's get straight to it. So mindset wise, you need to change the way you think. You need to understand that any item of information can, in fact, be deleted, right? Maybe you don't believe that, but you have to believe it or it's not going to work. If you can't grasp this simple concept, it's just going to be harder for you to get the charge off deleted, to be honest. I literally have helped clients with situations where they sued the credit bureaus, got a settlement, and they're telling them not to proceed with a lawsuit and they delete the item of information. So my mindset happens to be naturally different. I will be honest though, this CFPB thing just happened. In the times that I was helping people with litigation and all that, it wasn't with, CFPB got fired and this and that. So this is why right now it's so pivotal for y'all to take action if you haven't been taking action. If you've been sleep on taking action, like I've been telling you, take action, take action, take action, then I don't know what to tell you. So just what we did as far as to get the charge off deleted, to get over 100-point increase, let me tell y'all just like an overview. So we did a dispute letter with consumer law, so I'm going to go over, more information on that. 1099-C request, so you definitely want to do that, over $600. And then CFPB complaint. We did a CFPB complaint, but you saw what happened now with the CFPB. So just keep in mind, these are multiple tools that we did, but it doesn't mean that you still can't get the item deleted. But what I'm letting y'all know, time is of the essence, so it's only going to get uglier. It's only going to get harder. So you need to do it ASAP. Focus on fixing your credit ASAP. Make that your priority if it hasn't been in 2025. And then we did a BBB complaint as well. And as y'all saw, the creditor is Capital One. So, do what you will with that information. So you want to pull your annual credit report from annualcreditreport.com or go to Experian.com. Just get your credit report from somewhere. And then 15 USC 1681I is a foundation of what we're doing in our dispute letter. So reinvestigations of disputed information. I've spoke about this law so many times. Some of y'all are probably that have been watching me. You're getting bored of damn, he keeps talking about this law because it's true, right? So reinvestigations require 1681I A1A. You could read the law at your own time. I'm not even going to waste your time by reading it, but y'all see the stuff I'm highlighting. Any item of information can be disputed. They have to conduct a reasonable investigation. They're not going to do that. delete the item, you know. So that's what's happening. So you need to learn how to read a credit report. So just as far as inaccuracies, common things you can look for, I just put Equifax as an example. Payment history, balances, amount past due, balloon payment. You know, these are different sections when you're reading a credit report. So your options, you have a couple options, right? So basically what we did, we literally sent a dispute letter. We sent a 1099-C request, which to called Capital One. We did a CFPB complaint with the letter and the 1099-C, and then we did a BBB complaint, right? So that's essentially what we did. So me letting you know that I got so much free information on my YouTube. If you want to use the free information on my YouTube, including this video, be my guest and do that. But if you want practical information as far as what to do, we have a university, right? That's where the information is at. But let me give you your options. Obviously, you can try to do it on your own. The issue with that is you probably already wasted a lot of time and energy doing it your way. So let me ask you a logical question. Does it make sense to waste an additional 2 weeks trying to do it your way, or should you probably do something different? Maybe investing in yourself is a thing you should consider doing, right? If you need to think about it, because sometimes people are, oh, I need to think about it, right? You need to think about it when the CFPB just got fired. What kind of dumbass mindset is that, right? If you need to think about it, ask yourself, how long have you been thinking about it and pushing your credit off? Let's just say only 3 months, for example. Some of y'all has been years. Some of y'all been following me for years and you in the same or worse position, right? I'm not talking to you. I'm talking to action takers. Do you think if you took action 3 months ago with somebody else, don't you think you would be in a better position than you are now? Right? Enough thinking about it. Ain't no thinking about it. Click the link in my description, get in the university, go ahead and use the exact letter and go get your charge off deleted. I'm not saying it's going to be guaranteed. I'm not saying it's going to be immediate, but this stuff works. They're making it harder with the CFPB situation. What's the guarantee? Those of y'all that love you, what's the guarantee? I guarantee you, if you don't do nothing, you're still going to be stuck in the same situation or even worse. Why would you even quit before you're even starting, right? Asking for, oh, what's the guarantee of this going to work and all that? That's having a loser mentality. Only losers think like that. So keep that in mind. And then one thing you got to realize, likely someone that's been doing it for years like myself, that's going to give you extra strategy, right? You're not going to just get everything from watching free YouTube videos. That's the main lesson that you should be getting from what I'm saying. That might be the difference maker. It's like a boxing match. Someone that has experience versus someone that doesn't have a lot of experience. Experience is going to be the difference maker. Shout out to David Benavidez, David Morrell Jr. If y'all watched the boxing fight, I like both of them. But if you understood the fight, you saw David Benavidez outclassed him. He has experience. All right, so that's a perfect example when we talk about boxing that recently just happened. So yeah, you can join our university in the description, or keep doing what you're doing. You'll have the opportunity to use our letters that my students and I are using to get these deletions, and the literal letter that was sent to get the charge off deletion. All right, so how much is that worth to you? It's only $49 a month to be in the university. If you can't spare $49, less than $50 in a month, you deserve to have those negative stuff on your credit. I'll be the first to tell you that because you're not financially responsible. So the only catch is you not joining and wasting time trying to do something on your own, and you've already been wasting time, right? And energy trying to figure it out. So link will be in the description. With that being said, y'all have a blessed one. All right, how to delete bankruptcy from your credit report is going to be a no BS guide. Watch the entire video if you want to delete it for yourself, if you want to delete it for a client, friend, family, all that. So we're going to look at people that I help first because we're in this internet age. I literally had a call with somebody today asking me like if I actually do the credit repair shit, if I actually do the funding shit and all that. I really do it. I'm not, these people that are scamming y'all. So just as far as receipts purposes, if you're new, let's go ahead and show, and then we'll get straight to it. So 2023, I started my business 2021. I had a program called CAT Credit Retire 9 to 5 Mentorship, which has evolved into our high ticket program. And then one of my students, he said he removed a bankruptcy for the first time. Obviously, he accredited that to me. 2024, a year after, right? So I helped one of my private one-on-one clients that paid me well. I helped them sue Experian and they got it deleted, of course, and they also got paid $1,000. Obviously, I could just be saying this because y'all are used to people scamming you and just saying whatever. So I contacted my client to send me the screenshot again. And then remember, it was 2024. So you see the date right there, February 2024. So he got emailed settlement negotiations. Obviously, that's Experian up there. And then they said, I hope you've been well. I write to negotiate settlement of your claims against Experian, blah, blah, blah. And basically, as you scroll down, at this time, this is how these dispute items are reported on your file. So you see the bankruptcy deleted. All right. I don't know what more evidence y'all need. So the bankruptcy is deleted, and then the other accounts, as you see, they removed the notations, and then they got paid $1,000 check. And I have that on my IG. If you go to my results tab, but I got so many results, it's like I don't even know where to find it, but it's on there somewhere. So that's a receipt for you as well. And then receipts as well. So before we get into it, right? Because this is the age that we're in today's age. Like, because so many people are scamming, y'all have this weird mindset where you don't believe nothing unless you see all this amount of proof. But anyway, so two of my students in my university, they also deleted bankruptcies with my guidance. So go watch videos I did with them. And so one of them is here, Debbie. She used an affidavit that's literally in my university. And then Janeri right here. So we just posted this. So you can go look at her situation. She used a bankruptcy deletion guide that's in our $49 a month program. So yeah. So let's get straight to it. So hopefully you can believe that, I've helped people delete bankruptcies. So let's get straight to it, right? So number one, you're gonna pull your credit reports. Obviously, you're gonna pull your credit reports. You're gonna request your LexisNexis report as well. You could also freeze your LexisNexis while you're disputing with the main three. It's really up to you. The main thing I want y'all to understand with this whole credit shit, you really just gotta test out different things. Obviously, if you're going through a situation where you want to go through litigation, like my private client obviously paid me money, so I handled it for them. But the mindset you want to have with that is just looking at the next step as far as, okay, I'm going to send this notice. They're not going to do their investigation. Now I'm going to send a method of verification to trap them again. Once they don't do the method of verification, now I'm going to go to the next step and then litigation. So that's basically how I got my client paid the $1,000 and the deletion. All right, so you're gonna send a notice to the bankruptcy court, basically asking them if they furnished the info about your bankruptcy to the credit bureaus, right? So send that certified mail. So some of the things, like, these are simple, like, foundational things that you just gotta continue to remember. Because as times are changing, as they're saying, CFPB is gone, this and that, even though you can still do CFPB complaints, it's certain foundational things you still gonna have to do, right? So one of them I would recommend, you don't have to do it, is sending a notice to the bankruptcy court and ask them if they did furnish info about the bankruptcy. To be transparent, my client that I helped last year, as far as getting that deletion and the check, I believe he said that he didn't receive the notice after he requested from the bankruptcy court. So it's not mandatory. It's just good to do. And then if you do receive it, I would recommend that you use that notice to dispute off LexisNexis or go directly at the bureaus with the bankruptcy court notice. And what you may see is when LexisNexis sends you what they send you, they're basically snitching on themselves, saying that the information in the report may not be fully accurate, So keep that in mind as well. You could also do a CFPB complaint if you want. It's not mandatory. So with your round one letter, this is how I recommend that you do it. With your round one letter, I would recommend requesting a reinvestigation. So per 15 USC 1681 IA1A, after you identify any inaccuracies or incomplete information, obviously we can go back to the what's it called? The congressional findings section, 15 USC 1681A4. You know how it talks about your consumer's right to privacy. Look it up if you don't know what I'm talking about. You can include that in there as well. So it's really up to you. So the main thing I want y'all to remember, which I've already said, you can tackle this stuff multiple ways. It's so many ways to get to it. One of my students did affidavit, as I told you, notarized. A different one sent a letter to the credit bureaus after getting the LexisNexis deletion first. So that's obviously two different routes. So there's multiple ways to get to it, is my point, right? So just because one person got it deleted one way and one person got it deleted a second way, it doesn't necessarily mean that It doesn't because everybody be thinking everything is cap. It doesn't mean that it's cap. It just means that that person got to delete it that way, that person got to delete it that way. If you'll grow to learn. If you do have a credit business, you can do the same thing for two different clients, get different results. Maybe somebody got a deletion, maybe somebody got verified, you know? So just on the mindset tip for those of y'all that have a weird mindset, if you're watching at this point, after all the proof that I've shown you of people that I helped, then I mean, respectfully, you just a dumbass. I don't know how else to put it. But obviously, if you watch it at this point, I'm assuming you're not a dumbass and you understand that this stuff is actual information. I just get irritated when I'm talking to people like the calls that I'll see or just DMs talking about like, oh, are you actually doing this? Are you scamming? That kind of thing. Because it's like I we got so many videos and everything, so much proof. So yeah. Anyways, so after 30 or 45 days, if they're on their BS after round one, the whole verified thing, I would follow up with the method of verification. So 15 USC 1681 I number 7. And I have these specific letters in my $49 a month university. So if you're thinking to yourself, if you don't have experience, like you ain't been doing it since 2021 like myself, and you're thinking, okay, how do I create my letter? It's only so much shit you're gonna get on YouTube, and you just gotta stop being fucking cheap, right? We got a $49 a month community. If you want to go join it, join it. If not, use your brain or use ChatGPT to create your damn letter, right? Don't be these weird people that's just begging people for all this stuff and you expect to get the highest ROI, but you're not willing to invest nothing. I don't like cheap people, you know what I'm saying? So keep that in mind. If you're cheap, I don't fuck with you. So the reason why we want to do method verification is because that'll continue to expose the fact that they didn't get the information from the bankruptcy court. All right. So afterwards, if you do get the LexisNexis deletion, it's not mandatory, but you can use that as leverage to dispute it off Experian, TransUnion, and Equifax. So if it's reporting on one, like let's say you get it deleted on Experian, for example, but it's still on TransUnion or Equifax. Equifax will probably be the easiest to delete, but let's say you get it deleted off Equifax, but it's still on TransUnion and Experian. I would factual dispute using maximum possible accuracy, 15 USC 1681 EB. You can use that. Remember, none of this is legal advice, but keep in mind too, TransUnion works with LCI. I think it could be a different company now. I think it's like G2 or something. Don't quote me, but these things are always changing. So from the LCI website, you could pause the video. This is just what it has. I just wanted to put this just to show y'all like they're tied to TransUnion as well. So keep that in mind. You got the LCI information over there. So yeah, you got that information. So afterwards, what I would do around three, you can send a final notice and or litigation. So for my student, where he got the $1,000 check, I believe we sent 2 rounds and we did litigation. So you can go ahead and do that, right? To be transparent, I got a couple clients. I got 2 clients I'm doing one-on-one here in 2025 where I'm taking them through for one of them has a bankruptcy. I don't think the other one has a bankruptcy. So just to be transparent, like this information is current, is my point when I'm with what I'm saying. This is the same approach that I'm taking. So I just wanted to put this on here, give y'all this free game with the hopes that you get your bankruptcy deleted, you get the bankruptcy deleted for your client, and then you come to us for the business funding. Because the mission is to help fund $1 billion to small business owners. But I hope that this video was definitely helpful. Stay persistent. And that's really the main thing when it comes to this credit repair shit, when it comes to just credit repair game. So stay persistent, stay consistent, just keep at it. And maybe different things. Like I showed y'all 2 different students that got their deletions different ways. So your way may be different. Your way might be verbatim based off of what I taught in this video. But with that being said, hopefully this was helpful. If you do rock with me and you want to get tapped into anything we got going on, I'll have links in the description. But with that being said, go ahead and keep watching the videos, and y'all have a blessed one. I'm going to show you how to delete hard inquiries in less than 24 hours and possibly get paid for doing it at the same exact time. Watch the entire video. Let's get straight to it. So, oh, we're going too quick. So just wanted to go over the fact of, receipts. So this is from my university, Cat Credit University. Basically, just for receipts purposes, I had a student and she was able to do what I say. that I'm going to teach you in this video to go ahead and delete over 37 hard inquiries in less than 24 hours. She did it in 6 hours. So I think y'all should be able to do it in at least 24 hours, you know. So just keep that in mind. You see that she says right there, if you see this, please like or comment. She's trying to get to level 3. If you don't know, have a university, and basically when you get to level 3, you unlock an additional course where I go over how you get paid for deleting collections, like going through the lawsuit with the third-party debt collectors, all that. So plenty of sauce in that university. If you want to get tapped in, I'll have a link in the description. But let's see. So with the hard inquiries, so she said that she did my method for experienced hard inquiries, less than 12 hours. They were deleted. Just wanted to, again, show receipts right there. So hard inquiries mindset, I want y'all to remember, really, you want to attack the bureaus primarily. You can also go to the creditor specifically, but it's not, to be honest, it's not like always necessary, So keep that in mind. I want y'all to focus on the Consumer Law 15 USC 1681C-2. This is the block of information resulting from identity theft. We're going to go over it just so y'all are a little bit more familiar with it if you're not. And then one thing I'll say, don't be afraid to call, because we're going to talk about experienced hard inquiries. We're going to go over that specifically more in depth. But at the same time, when it comes to TransUnion and Equifax, this is even a question that popped up in my higher ticket mentorship. So sometimes it takes the extent of you calling, even though you did everything correct with your dispute letter, your consumer laws, all that. Sometimes you got to just call them and just stay on them about it, right? It's like a lesson in life. You just got to be consistent. So 15 USC 1681C-2, you see this is the block of information resulting from identity theft. So this is basically what we're going to do when it comes to deleting them on TransUnion or Equifax. I'm going to go over Experian, but I just want to leave that highlighted there for y'all just so you know what we're doing. So let's just go over Experian real quick because it's pretty easy to do. And you can literally do this right now. If it's the weekend as you're watching this, wait till Monday or whatever. But basically, this is all you're going to do. Number one, do step by step, like literally do what I say. You're going to be able to get your result. Number one, you want to confirm the hard inquiries are not tied to open accounts. Can you remove hard inquiries that are tied to open accounts? Yes, I've tried it on my own and I've successfully did it. But the thing is, you possibly risk them possibly closing your account. It didn't happen to me when I did it, but I wouldn't recommend y'all do it because, this is a platform. I don't want to recommend that y'all do something like that and then your thing gets closed. You know what I'm saying? So keep that in mind. You're going to call this number, 1-800-493-1058. That's a working number for Experian. My team uses it. My students use it. A lot of people use it, right? They got hella numbers, so you can go ahead and use that number real quick. You're going to enter your social security number on the prompt. They're going to be like, okay, what's your social security? Or your clients, if you're doing it for a client. You're going to enter your zip code. You're going to say you're calling about a dispute. You're going to say it's a new dispute. And then you're immediately going to ask the rep to transfer you to the fraud department. This is literally step by step. Like my baby cousin could do something like this, right? So y'all got to realize like this is very, very simple if you follow instructions. And then you're going to tell the new rep that you get, I have some hard inquiries on my credit report I would like to dispute that are fraudulent due to identity theft. This is going to go back to the definition of what we're talking about under 1681C-2. You can say identity theft. You could say that, permissible purpose. They didn't have your, permission to publish it on your report, which is also true. But let's keep it simple. You're going to list off the inquiries and the dates, and then it'll be deleted in 24 to 72 hours. As you saw with my client, my student in the Cat Credit University, it was deleted. Hers were deleted within 6 hours, right? So that might be your experience. Maybe it's not your experience. So go ahead and do everything I said for that. Your experienced hard inquiries will be gone. Now let's go over 1681C-2. So block of information resulting from identity theft. Except as otherwise provided in this section, a consumer reporting agency, meaning Experian, TransUnion, Equifax, shall, we got to wait there on shall. Shall means that they have to do it. When you're reading the consumer laws, you want to pay attention to each word and language, right? They shall block the reporting of any information. Any means no restriction on information. Any information, meaning any hard inquiry, in the file of a consumer that the consumer identifies as information that resulted from an alleged identity theft, right? No later than 4 business days after the receipt of, and then we're going to go over the information. But basically, as you can see right here, when you send in your information, what you've identified as alleged identity theft, non-permissible purpose, whatever you want to call it, these hard inquiries, these items are supposed to be deleted within 4 business days of them receiving your information. So what do they need? Appropriate proof of the identity of the consumer. So your ID, right? If you want to put a picture of it, go ahead and do what you need to do. Copy of identity theft report. So if you've ever heard of the FTC method and stuff like that, that's what they're referring to over there. I'm not saying fill out any fake police reports or any fraudulent stuff, but they're going to need that identity theft report. The identification of such information by the consumer. What are they talking about? They're talking about the specific hard inquiries. Okay, Amex, June 2023. Capital One, July 2024. All of those. That's what you're identifying for them. And then a statement by the consumer that the information is not information relating to any transaction by the consumer. So, when you're writing your letter, sometimes you put like your reasoning and stuff like that. What you would simply put here is that this is not related to any transaction authorized by me, the consumer. Was it hard inquiry authorized by you? I can't tell you. You have to tell yourself that. So that's how you draft up your letter. You're going to send it certified mail with the green return receipt. Why are we doing that? Because we want to have proof that they received it, right? So you're going to go ahead and do all that. And then once you have proof that they received it, you have the date that they actually received it. That's when you can go ahead and do your 4 business days from there. If it goes past that, then you basically found a violation. I'm not going to get too deep into, what you'll do with that, but if you know, right? So that's how you're going to get rid of those TransUnion and Equifax. People usually have more issues with TransUnion and Equifax, so that's how you go ahead and handle that. So in terms of what I was saying, in terms of how you could possibly get paid, you could literally do this skill for many people. An example offer, you could charge $20 per inquiry deletion. So my student in the university that got 37 hard inquiries deleted, that's basically $740 for making a simple phone call that was going to take the same energy to make to delete one inquiry, right? So none of y'all that follow me on my YouTube page should have any issue making money, because I give y'all so many ways to make money, so many ways to get to it. You could charge a flat rate of $200 to $300 for the service if you just want to go that route. You could do a one-on-one consultation. You could do a one-on-one consultation teaching people how to do it. You name your own price. You can put out a guide or ebook that's anywhere from $27 to $47, right? So just keep in mind, there's so many ways that you can do it. So hopefully this helps. Hopefully y'all actually do what I say. If you're someone that struggles with accountability, we do, like I said, we do have the Cat Credit University where Celeste, she got that result. So if you want to tap into a community where people are posting their wins, people are holding each other accountable, figuring out the current trends of what's working, you can go ahead and enroll in Cat Credit University for only $39 a month at the time I'm recording this. With that being said, hopefully you do what I say and you're going to get your results. With that being said, y'all have a blessed one. If you need help deleting student loans from your credit report, watch the entire video. I'm not giving you a guarantee that they will be deleted. I'm going to give you strategy based on of the fact that I've been doing this since 2021, right? So one thing too, this does not mean that you will not owe the student loans anymore or anything. I'm not giving you no guarantees of anything. But let's get straight to it. I'm going to give you all the sauce so you can do what you can for yourself. So just wanted to post results here. This is what my company did for a client. We will not fix your credit or anything. Stepping into 2025, we're teaching you how to do it. We're giving you the AI software and everything. So just keep that in mind. Don't ask us to fix your credit. You know what I'm saying? So keep that in mind. So this is one of my students as well. Just to show y'all results, because you need to see results, especially if you're new to following me or if you just found me randomly, right? So Gary, he deleted student loans on Equifax and TransUnion after dealing with battled consistency. He did what I said. We have letters and everything. So he just following the blueprint of what I teach. Keep in mind, I've been doing this since 2021. Things change over time. So yeah. He also deleted from Experian as well. So just getting straight into it, one thing y'all got to realize is student loans are one of those things where it's kind of tricky because a lot of times it may be your oldest account. So it's kind of like complex in terms of should you delete it or not, because it could also get you not qualifying for a FHA loan, you know? So there's complexity with that. So I need y'all to really dive deep, especially if you're doing it for a client. You got to have that conversation with them. Do you want to delete these? Because, you know, these are the certain ramifications that may happen. This may be your oldest account, right? So keep that in mind and just understand that. Because I don't want anybody to delete their student loans and now they blaming somebody, you know? So that's prerequisite. So number one, you need to change the way you think. You need to change the way that you think. Any item of information can be deleted. Any item of information can be deleted. If you can't grasp this simple concept, it's just going to be harder for you to be able to delete these student loans. Because it's one of those things like, I know a lot of people say, oh, mindset is fluff or whatever. But with credit repair, with credit, fixing your credit, literally mindset is going to be what helps you get to the next level because sometimes it might take multiple rounds for you to get through. That's why I always say fixing your credit, going through this process is like a boxing match, you know? So keep that in mind. I literally have been in situations helping clients where they got settlement agreements for any item of information, student loans included, where the credit bureaus are like, okay, sign this settlement agreement. We're going to go ahead and delete the item. Sometimes there's compensation attached. So what does that tell you? Any item of information can be deleted. But I understand me being in those situations or facilitating those situations, whether I'm like helping a client or if it's one of my students that's doing what I said. I understand that my mindset with it is going to be different from maybe the average person that hasn't experienced that. But I'm here to tell you, as someone that hopped over the fence and saw that, any item of information can be deleted. So let's get straight to it. Watch the entire video. I need y'all to go to annualcreditreport.com. You can look at the credit karmas and all that, but you need to really understand how to read a credit report. You need to understand how to read a credit report because this is going to be like the sauce or secret, whatever you want to call it, that's going to help you be able to delete these student loans from reporting. So one law is very important. Sometimes people ask me, as someone that's been, you know, breaking down the laws, taught like 4 hours of consumer law mastery, what should they focus on? When it comes to the FCRA, 15 USC 1681I, we're going to get specific. 1681I A1A, reinvestigation, right? So literally read it. Subject to subsection F. This is not what I just put, this is what Congress put, right? If the completeness or accuracy of any item of information, let's look at that. What did I just say above? I said any item of information can be deleted, right? Did I not say that? Did I not say that or did I not say that? Right? Any item of information can be deleted, right? So if any item of information, the accuracy or completeness is questioned, is disputed, right, by the consumer, and the consumer notifies the agency directly, so you sending your notices or indirectly through a reseller of such dispute, the agency shall, the word shall, if you don't know the word shall, it means that it has to happen. It's not optional. Free of charge, conduct a reasonable reinvestigation, which they're not going to do. You know, there's case law for that to determine whether the disputed information is inaccurate and record the current status of the disputed information or delete the item, right? That's what we're looking for. That's why when we have a case and we have the fact that they were willful and not deleting it, we raise that claim, we're able to make them bend down on their knees, like sign the settlement agreement. We don't want to go further, right? Whether it's you're doing it through Experian arbitration, whether you're going through small claims, if you're going through federal court, right? Whatever venue you're going through, if you have that claim, it's not a guarantee, but more than likely, they're not going to want to go further because you got evidence that they didn't do a reasonable reinvestigation, right? So that's what you want to focus on. 1681I A1A. And it's going to be before the end of the 30-day period, blah, blah, blah. But the main thing I want y'all to realize, you want to look for inaccurate items, incomplete information, unverifiable. When we talk about strategy, making things unverifiable, we could talk about, freezing the secondaries and all that, but I'm just talking about just basic, inaccurate information. This is how you can get the student loans deleted. One of my students' examples in the case, it was a duplicate account, right? So is that not inaccurate? Like if you have one account but it's a duplicate, that's inaccurate. If they're being willful and not deleting that, now we're talking about you potentially have a case, right? So keep that in mind. Additionally, one law you want to combine 1681I with, and what we tend to do, what I literally give my students, letters that we use with our clients. So 1681E, compliance procedures. Whenever a consumer reporting agency prepares a consumer report, it shall, remember that word shall that I told y'all about? It's not optional. It has to be done. It shall follow reasonable procedures to assure maximum possible accuracy. They didn't say 98% accurate, they said 100%. Maximum possible accuracy of the information concerning an individual about whom the report relates. So 1681EB, combining that with 1681I, has basically been like our bread and butter for getting these items deleted. The spoiler alert, the sauce, whatever you want to call it, is very simple. These credit reports don't report accurate information all the time. So this is why, we're able to have a case. So this is why you might see an attorney go ahead and able to get a consumer compensation, right? So, like I said, you need to learn how to read a credit report. So common things to look for. I just want to talk about within like what's it called? Like a Equifax report. So payment history might be off. If you see 30, 30, 30 repeated, that's not possible. It could be 30, 60, 90 as far as, being late. Payment history might be no data or something like that, right? That's incomplete. So just keep that in mind. Balances, if the balances are off, that is grounds for sending that 1681I A1A dispute. Question it. You're disputing, right? This balance is off. That balance is off, right? So if you got all three of your credit reports, somebody says $100.31, somebody says $100.32, maximum possible accuracy. That's not maximum possible accuracy. So what we're going to do is we're going to request a reinvestigation, right? So you see how 1681I and 1681E go as a unit? I'm saying it like y'all live and can reply to me. But hopefully, as you're watching this on your TV, your phone, your computer, whatever, you reply yes, you can kind of see where I'm going with it. Or just rewind the video so you know a little bit more about what I'm saying. So that's a common thing to look out for as well. Amount past due. They have a balloon payment situation as well. So these are just things that you gotta look at when it comes to deleting these items of information. I understand that there's multiple strategies. Like I said, I've been doing this since 2021. There's multiple different strategies and tactics you can do. And I talk about, that in my university. I'm not telling you to go say you a victim of human trafficking, like some people be saying. I'm not telling you to do false police reports. We're not even talking about no Metro 2 or none of it. We're talking about consumer laws and getting those items deleted through literally the laws, right? So hopefully this helps in terms of, giving you practical advice. Literally, like I said, go look at your credit report and literally study it. Look at the inaccuracies, right? Look at the inaccurate information. Technically, too, if you should point it out, especially if you're going to go through litigation. But even if you don't point it out, if you're just requesting a reinvestigation, it's on them to conduct a reasonable reinvestigation to confirm that those items are completely accurate, right? I understand that some of y'all may be watching this. You're just like, okay, cool. I'm hearing everything you're saying is sounding good. I don't know where to start though. I don't know. I need a letter. I need to use your AI software so it'll do it for me. That kind of thing, right? You want to use a proven blueprint. I get it. But let me talk about your options because you do have options. So number one, you could try to do it on your own. I've given you this video. You could try to go do it on your own. But you got to understand that if you don't got the experience, if you don't got the context, if you haven't actually done it before, it might be that might be a hard option to do. So the issue with you trying to do it on your own, you probably already wasted a lot of time and energy doing it your way. So I would not like for you to continue wasting your time and energy, especially if you just stumbled across my video where I'm literally giving you the solution to what you've been messing up on. As well as the issue is you might not be patient, right? Credit repair is one of those things where people think that okay, results are supposed to be instant, and I blame part of it based off of how people market by saying like, oh, results in 30 days and all that because that's like illegal when it comes to credit repair laws, but you got to understand that, like I said, it's like a boxing match. There's not going to be a guarantee of a deletion. It's possible to get a deletion quick, but it's not always guaranteed. So keep that in mind. So the issue is you are not patient because of that. And because of that, you don't got like-minded individuals around you that are also going through what you're going through. And that's powerful because when you see other people in a community are in the same situation that you're in, you got people to hold you accountable. You got people to network with, right? You got people to let you know that you just got to keep on going. Like my student right here, Gary, he said, "Don't stop." You see, at the last thing he said, "Don't stop." He had to keep going, consistent, right? He's in a community of like-minded individuals that are all trying to achieve the same goal. So community is important, and just being around somebody that's been doing it for years is obviously important, right? So an additional issue with you trying to do it on your own, you don't got access to a weekly report showing how other people in the community got specific items deleted. That's one thing that we've specifically added to our community. It was by request. I asked how can I add more value to the members in the community. So we just been posting that not only like, okay, if someone posts like, oh, I got an item deleted, but how did you do it? What was the process you took? What did you do? And what laws and stuff like that, right? So we're literally tracking that data. You can't beat that if you're just doing it by yourself, right? You only got yourself versus you got a whole community of people that are all attempting to do the same thing. And with more numbers, you're gonna have more data. It's just a reality, right? The last issue with you trying to do it on your own, you don't got access to someone that's been doing it for years. Like I said, I've been doing this since early 2021. We're going into 2025. So I mean, results are just results, right? I've been getting results for years and years, and it's certain things you just can't like. You can't just speed experience. You can't speed the process of experience. Experience has to happen over time, right? And I just have certain strategy. I have certain situations I've been in that you just haven't been in. This is where it comes into play, like when you look at sports, like boxing, for example. Someone that has experience versus someone that's doesn't have experience. They haven't been doing it that long, right? So it just comes second nature to someone that's been doing it for super long. So yeah, like I said, like a boxing match. Your second option, you can literally join our university, and it's risk free because you can get a 7 day free trial. If you don't like it, you can go ahead and cancel. The reason why I don't mind doing a free trial is because I know it's sauce. I know the sauce is in there. It's literally like our university is literally like giving someone that's on crack, right? So it's like literally giving a crackhead some crack. Like you're gonna be hooked because it's like the information is just it's just gonna get you to the next level. Like I said, I've taken my years of experience and just put it in a university. And you can't get all that, you can't study everything in 1 week. So that's why people choose to pay, that's why people choose to stay. That's a bar. That's why people choose to pay. That's why people choose to stay. You feel me? So I believe it's $49 a month now after the 7 day free trial, but that's pennies compared to what the return on investment you're gonna get. If you scared to invest less than $50 in a month on your personal development when you've been looking on how to delete student loans, you're watching this video for a reason, then you deserve to have those student loans on your report because you're being cheap. Not only are you being cheap, you're being poor because you're passing over the opportunity repeatedly, right? But if that's not you, that's not you. Like I said, it's literally no risk. You have the opportunity to go ahead and use our letters that my students and I have used to get these results as far as for deleting student loans and many items. So you can go look, like I said, you can go look at our weekly reports of when and how other items got deleted. So you can reverse engineer for your own situation, or you can literally just copy what people are doing and see if it works for you. The only catch, because there's always a catch, the only catch is you not joining, and then you don't get the sauce, and then you continue wasting time trying to do something on your own that you've never done before. That is a scary reality. Link will be in the description if you want to tap in with us. With that being said, keep watching my videos. Y'all have a blessed one. If you're trying to remove any negative item, any item from your credit report or your client's credit report, this video is literally for you. Watch the entire video. We're going to go over my secret letter. The secret sauce is going to help you get that deletion. So we go to dispute letters here, and we're gonna look at this affidavit of truth template. So the thing about credit, y'all gotta understand is that credit is so open-ended in terms of you don't know what exact thing you're gonna do that's gonna get the item deleted, but we can have certain things in place to make it more likely that things will get deleted. And one of those things is using this affidavit template I give my students in my community. It's $49 community. But I've had a student use this to literally delete a bankruptcy. I've had a student use it to delete a late payment, collections. We've used it to delete late payments and within our business as well for clients. So I say that to say that this is a very powerful document if you apply it the correct way. Nothing is guaranteed, obviously, right? There's no guarantee because we're at the mercy of the credit bureaus to do their investigation and then, delete it. But at the end of the day, as you know how things are going, if you watch my videos, you know that these people are not doing no investigation. So the law I want y'all to focus on is actually a couple, but one law I want y'all to focus on is 15 USC 1681 I A1A. This is requesting a reinvestigation. This is called procedure in case of disputed accuracy. So if you Google 15 USC 1681 I, you're going to see it says at the top procedure in case of disputed accuracy. I want you to go down to 1681 IA1A. It's going to basically talk about conducting the credit bureaus having to conduct a reinvestigation. And the reason why it's a reinvestigation is because they were supposed to do an investigation in the first place before the item was inserted on your credit report. If you don't know, this is basically how the laws and the credit reporting and all that stuff works. Second law, 15 USC 1681 EB. EB is a maximum possible accuracy law. So you want to make sure that everything is maximum possibly accurate, right? What I mean by that is it can't be 99%, it can't be 91% accurate. It has to be fully accurate, right? So once we understand both of those laws and what the purpose of why we're using them, that's when we're going to bring into this affidavit. And the reason why it's powerful is because we're getting it notarized, you know? So that adds like, I guess that adds that extra pressure, because we could speculate here all day, but at the end of the day, all I know is that this has gotten not only my company results, it's gotten my students results using this template, right? But you make it your own, obviously. So there's 5, 6 different elements. You see 5 right here, but the sixth one is just signature at the bottom with the notary seal. So as we go over it, if you want to grab this, it's literally in our community. Like, stop being so fucking cheap, if you want to grab it or just create your own version of it. So the title, you could title affidavit of truth or whatever you want to title. You could just title the affidavit of fact or whatever you want to call it, right? But don't think about it too deep, right? If you watch my videos, like I'm big on simplicity. So then statement of identity, you don't have to do it how I did it right there for the template, but you're basically just stating your identity, or if you're doing it for a client, the client is stating their identity. Age of majority, you're basically saying the fact that what you're about to say is the truth to the best of your ability, and you can swear on that under oath basically, right? So that's what age of majority is. And then statement of fact, you're basically going to state a general truth. So basically, like you'll see how here I added in the template example, I basically talk about the fact of the purpose of the FCRA, right? I said it's to require that consumer reporting agencies adopt a reasonable procedures, right? We're talking about 15 USC 1681 I A1A. We're talking about procedure in case of disputed accuracy. We're going to use that law as our foundation for getting these deletions. This is why it's so powerful and can work for bankruptcy, charge off, collection, late payment, whatever item, right? Because we're going based off of the inaccuracies. So, um, I basically you can read it there, right? I'm basically just saying that the FCRA is intended for accurate information and they're supposed to adopt reasonable procedures to make sure that there is accurate information. But why are all these damn credit reports not fully accurate? Because they're not doing what they're supposed to be doing. So then affiant facts, you're the affiant. So this is basically the section where you state your own facts. And I recommend if you do have exhibits meaning like proof of violations, it could literally be your credit report where you pull it, and then you see under payment history, you see ND, which means no data, which means that it's incomplete, or you see just blanks where you know that stuff should be there, right? Because everything has to be maximum possible accuracy. It goes back to the two laws I'm saying: 15 USC 1681 I A1A and 15 USC 1681 EB. If you're hearing all this stuff I'm talking about, you're thinking like, damn, this is a lot to take into consideration. I don't know how to do it. I don't have a track record like your company. Then you're gonna just have to pay, right? We can help you do it. It's as a paid service, a done for you service. But we obviously have this $49 community, which is affordable. Like even the poorest of poor people could afford $49. You know what I'm saying? So that's why we made that available. You obviously have my YouTube videos as well. But if you're somebody like our ideal client, which is a busy small business owner, you know that you don't do this shit on the fact of the business funding and the consumer laws. The way that I be doing it, the way that our company be doing it. Then I'll have a link in the description. I'll have a link probably in the comments as well. You can go ahead and book a consultation with my team, and we'll basically analyze your situation, and then we'll see if we can help you get to the next level as far as fixing your credit. You'll see on the application too. This is my segue before I continue. You'll see on the application on there, one of the questions we ask, it might be different later on. One of the questions we ask is letting you know that we're not cheap. Do you have at least $1,000 to invest in yourself, right? That's at least $1,000. That's assuming, let's say, if it's a payment plan or something like that, right? More than likely, it's going to be more costly, not expensive. Costly, it's a cost to get that ROI, right? More than likely, it's going to be more costly than $1,000. We just use that as like a framing just to see somebody's mindset. If you cheap as fuck, we don't want to deal with you. Just watch my free YouTube videos or go get in the $49 community. You know what I'm saying? But I've been putting out all this information for years. We don't do this. We don't work super hard for cheap ass motherfuckers to come and tell us something about our price and when we get people results. So yeah, keep that in mind. So then you're gonna state the rest of your facts in section 5, like I stated. So those facts can literally be like where you pulled your credit report, you see ND, different open closing dates, just pointing out those inaccuracies. If you don't know how to do all this, if you don't know how to articulate it, just grab your money and invest in your fucking self, right? Don't be fucking cheap. I don't fuck with all that cheap shit. If you're gonna be cheap, stay away from our company. Just try to do it on your own. You can continue wasting your time, or you can, figure it out, right? Those of y'all that be talking about, oh, I'm just thinking about it. You've been thinking about it for so damn long. You need to talk to your wife. Does your wife like the fact that you have all these damn negative items on your credit, so now you can't get your house? Now you getting fucked over with all these interest rates? Like, stop all this thinking about it. When it comes to getting to the next level, success loves speed, right? All this, I'm thinking about it. That's not going to help you get to the next level. If you want to get to the next level, you have to take action as fast as humanly possible. I'm not saying that you have to invest with us, obviously, right? Because we're already gonna do what we do, right? I can close people in person. We close people, online. We close people in different scenarios, right? So our business, God is going to continue blessing our business. But my whole goal is that y'all make a decision on something. Don't be those weird people that's having all these objections. I need to think about it. I need to talk to my wife. What's the guarantee? That's a violation under 15 USC 1679B. You know what I'm saying? So these are things you got to understand. And it gets to a point that we got to stop babying people because some of y'all are like, you have a baby mindset. You got these young kids, they're willing to invest in themselves, but you're looking at it from the fact of just being cheap as fuck, right? So y'all gotta really like get y'all life together, basically, is my whole point of what I'm saying. So then we out number 6 right there, right? So then you'll get a notary seal on it. And then basically do your same situation. Send it over certified mail. Credit is one of those things where it's so many different ways you can do things. So if you want to do your CFPB complaint, CFPB, if it's still open, if you want to just go based off of the laws, I mean, the laws are really the foundation. You know what I'm saying? If you want to go through litigation, so you just got a bunch of different scenarios in terms of how you could do it. But I just wanted to create this video real quick just to give y'all something free that you could do because I know that those of y'all that do take action, like let's say you're cheap as fuck and you don't want to invest $49 just to get a simple template and more templates. Look, like Look at all these damn letters here. Let's say you're cheap as fuck, right? I at least gave you this video to where you can go and do what you need to do. But if you're that ideal person, you're a small business owner, you're like myself, you're willing to make an investment in yourself, and you understand the importance of staying in your lane, which means doing your business and letting the experts do what the experts do. We'll have a link in the description. We'll have a link in the comments. You can go ahead and book a free consultation. You'll speak with someone on my team. My dispute department will create your credit analysis. We'll look at your analysis, see what it is. You'll hop on a call with someone in my sales department. They'll go over your situation, feel and just feel like to see if we feel like we can help you, and then we'll make you an offer. If we feel like we can help you, we will make you an offer. If we do not feel like we cannot help you, we will not make you an offer, right? At the end of the day, we're going to continue doing what we're doing. We're just here to help and attract. We're here to, the reason why I do these videos, I'm making myself findable for my unique tribe. If you're someone that's cheap as fuck and you just happen to stumble across this, y'all know how YouTube goes. Anyone can watch these videos. So if you feel the need to make a dumbass comment in my comment section, you can do it. But that just lets me know that you're not the person that's for me. And, you know, I'm cool with that. You know, so if you want to expose yourself, that's cool too. Or you can just watch it and keep it pushing. But those of y'all that's my unique tribe, we'll look forward to seeing you on a call. Hopefully this video helps. And with that being said, y'all have a blessed one. If you want to make extra money, this video is for you. If you're lazy, I'm not going to give you a guarantee that you're going to make extra money, but it's pretty simple enough and easy to make money. So we're going to talk about getting paid using a specific consumer law. And this specific consumer law is under the FCRA. This is 15 USC 1681C-2, as you can see right here, block of information resulting from identity theft. So we're going to break it down and how it's going to help you get paid, get money, get extra money if you work a 9 to 5, if you don't work a 9 to 5. So I have a student here that's in, my university. You see, he posted here. You see, his name is Josh. He said, "Don't sleep on inquiries." So we're talking about hard inquiries. He said he deleted 10 inquiries from someone's credit report. Thanks for the knowledge. Obviously, that's me. I made a smooth $500 today. You determine your price, right? We're in the age where it could be 2025 or later when you're watching this, but I'm dropping this in 2024. We're in the online age where you determine your worth, right? So whatever you charge for the information is up to you. I'm just here to give you the information. Hopefully y'all take action with the information. So let's break it down. Block of information resulting from identity theft. So I want y'all to use this for specifically Equifax and TransUnion. If you don't know how to delete Experian hard inquiries, then I recommend you go watch some of the other videos I've dropped, because I've definitely put out videos as far as how to delete that. But when it comes to 1681C-2, this is going to be more so for the Equifax and TransUnion situations. So except as otherwise provided in this section, a consumer reporting agency, if you don't know what that is, that's Experian, TransUnion, or Equifax. Shall means that they have to do it, right? Let me just highlight that real quick. I also dropped a 4-hour consumer law video, so you can go watch that on my channel. It breaks down the language of the FDCPA and the FCRA. So that's a sidebar. Shall block the reporting of any means no restriction, any information, right, in the file of a consumer that the consumer identifies. So that's important. The consumer identifies it, right? Hold on, let me say consumer identifies as information that resulted from an alleged identity theft, right? What is something that's alleged? This is not legal advice, but something that's alleged means that it's what you alleged. I could allege that during this video, a monkey just was spinning around doing backflips back and forth, and then a lion came through and was jumping up, doing, jumping jacks during the recording of my video. I could allege that. So, do what you will with that information. So not later than 4 business days after the date of receipt, right? So once they receive the information you're going to send to them, which is the FTC report, this is why you want to send it certified as proof. Then they're supposed to actually delete those hard inquiries, right? When you got clients, when you got yourself that's been to the dealership and they running your credit like crazy, you got to keep in mind that this is where it can really be beneficial as far as getting paid using the consumer law, because you can help a lot of people. Because a lot of people don't know the information that y'all know because you're watching my channel, right? So keep that in mind. So let's walk through the four things that we actually need. Appropriate proof of the identity of the consumer. So obviously, you know, your identity, right? Your ID, all that. A copy of an identity theft report, that's going to be the FTC report, right? And then identification of such information by the consumer. So what is that going to be? That's going to be the actual hard inquiries. So we're talking about like car, whatever, right? Whatever the hard inquiry is, and then the date, like August 2022, whenever it was pulled, right? So that's what that's going to be. So you're going to identify all that information. And then you're going to have a lot of people forget number 4, but you got to include that too, like under the law. I'm not saying that you won't get results without including it, but you want to do everything just in case you got to press legal action. A statement by the consumer that the information is not information related to any transaction by the consumer. So when you're forming your letter, just for example, as far as how to tell y'all, obviously you're going to have the identity theft report. That's number 2. But you want to obviously have a dispute letter, which is going to be composed of items 3 and 4. 3 is going to be like, okay, this is a hard inquiry, August 2022. And then often what we do for number 4, we put it under reason. Because when the reason you're disputing something, you could just say, this item of information is not related to any transaction authorized by me, the consumer, right? It wasn't, you didn't give them, permissible purpose or so, right? You could also send a permissible purpose letter to get hard inquiries deleted, but I want to make it super simple for y'all because I've gotten people many results, doing this. So if you're new to me, go to my channel. You'll see there's a lot of receipts, right? So keep that in mind. So that's basically the breakdown. This is the breakdown of you making more money, right? If you want to get paid, master one thing. Just focus on one thing. You can focus on collections, right? I teach my university students to focus on collections and suing debt collectors. Obviously, we're talking about hard inquiries today. Focus on hard inquiries. Focus on targeting people to just have hard inquiries. You could literally go to a dealership, talk to their dealership, form a relationship. Oh, you got like a client list or people that come here that get denied, because of credit or whatever. Help them remove the hard inquiries. You can go create content like how I'm doing. You can literally just focus on hard inquiries. Getting money, getting paid using these consumer laws it's not rocket science, right? Use the information that I'm telling you and go get paid. Joshua is not different from you guys. The only difference is that he invested his $39 to be in the university, but he did it. He took the information. He made the $500, right? We got the Creed cologne chilling here. You know what I'm saying? Those of y'all that know, I like smelling expensive. You feel me? So that's what I'm on. Be 1% better today, by the way. So do what I say. That was rhyming. That's cool though. All right, so let's say that they decline the block because sometimes that be happening. These bureaus that be on BS, they got people from overseas that manage these disputes. They're not doing no proper investigation. Speaking of that, we're going to go to the reinvestigation section. So if they decline to block for whatever reason, I want to point y'all to a law that's going to help you in the reinvestigation section. So 1681I is procedure in case of disputed accuracy. So just literally listen to what it's saying. And I want y'all to demand a reinvestigation. Reinvestigation meaning they were supposed to do an investigation before they even put the information on your credit report or your client's credit report in the first place. So specifically, I want y'all to focus on 1681I3A, right? I don't think I publicly spoke about this specifically before, but 1681I3A, right? So that specific section, it says determination that a dispute is frivolous or irrelevant. So this is like some higher level sauce, but just read it. Notwithstanding paragraph 1, a consumer reporting agency, which we identify as Experian, TransUnion, Equifax, may terminate a reinvestigation of information disputed by a consumer if the agency reasonably determines that the dispute by the consumer is frivolous or irrelevant. Let's break it down simply here. When we go to the congressional findings section, they obviously have assumed this vital role that they have to adopt a reasonable procedure to make sure items reporting are accurate. I'm telling you right now, they don't do investigations. There's case laws on this, right? Given that, let's use logic, right? Given the fact that they don't do given the fact they don't do reinvestigations, they don't have reasonable procedures to do all that, them just saying that we're going to decline the block of information or whatever, that's not a reason to say that the consumer's dispute is frivolous or irrelevant. Y'all don't even have a reasonable investigation in the first place. Prove to me that you have reasonable investigation, right? On top of that, too, a different angle you could take is a method of verification. So 15 USC 1681I, number 7, is going to refer to you the 1681, the 6BIII, 1681I, 6BIII. So you can follow that as well. But I just wanted to break down to y'all the fact that it's a violation if they just declining the block for no reason. If you've given them all the information that they needed, right, which you're going to, right, this is under the assumption you gave them 1 through 4. If you gave them 1 through 4, them declining the block of information, that's a violation. And at that point, you should be preparing a lawsuit to be able to go ahead and sue them for the damages, your credit reporting violations and all that, right? So keep that in mind. They can't just determine, oh, it's irrelevant, it's frivolous or whatever, right? Because they don't even maintain reasonable. They don't do no investigation. I'm telling you, they just have people overseas that just press a button and say like, oh, okay, it's verified, whatever, or we decline the block, oh, it's made an error, So how can you determine that if you don't even do a reasonable investigation? I gave you all the information you needed, right? So that may be some of y'all's situation right now. So keep that in mind as you're going about it. But I say that to say, hopefully this video was helpful for y'all. If you do what I say, you will get paid using this consumer laws. If you want to be like Josh, making $500 a day for disputing hard inquiries for your clients, we do have Cat Credit University. At the time I'm recording, it's only $39 a month. You can join by clicking the link in the description. Come join us, get your wins. It's always good to change your environment and get in a better situation. If you're not ready to tap in with us, regardless, hopefully this free information helps you. Make sure you like, comment, share, turn on my post notifications. I was looking at the analytics before I close out the video. It's at 8.5% of y'all have all my notifications on. It needs to be at least 50% of y'all that have my notifications on. I think it's like, at the time I'm recording, it's like 700, almost 800 of y'all that have it. So I need y'all to put on my post notifications as well. At least do that. If you're not going to invest in yourself, at least put on all my notifications, come watch these videos and take action. With that being said, hopefully this was helpful. Y'all have a blessed one.
The following video y'all about to watch is basically a replay where I was talking about how to fix your credit from A to Z. You don't got to pay nobody, the consumer laws, all that. Just want to show y'all the views that can happen once you fix that credit. So prioritize that credit, protect your credit, and just make sure, you take action based off of the video. If you get value from it, if you want to join our community for $39 a month for additional help, you can do that. But feel free to just use the content that I'm about to show you right now. So, just on the balcony right now, just observing the view and showing y'all what could be possible for y'all too. With that being said, enjoy the video. Y'all be blessed.
All right, it's recording now. How's everybody doing?
How you doing?
Great.
How you doing?
Good.
Michael, you look
I'm
familiar.
blessed.
You look
Do I look
familiar,
familiar?
Michael.
Oh, someone
Yeah,
trying to
you
enter the room right now.
You can
I look familiar?
Yeah, I can't put my finger on it, but I've seen you somewhere.
Seen
YouTube.
someone?
I watch his videos.
Or you watching my videos?
You on YouTube, right?
Appreciate you. I'm definitely on YouTube. We got
Yeah,
damn near
yeah.
3,000 videos.
Yeah,
But,
absolutely.
yeah,
Yeah.
you probably see me on YouTube, maybe as IG. We on LinkedIn, so. But
You
most
did a
people see me from YouTube, so.
You did a like a 2-part series on CFPB, no?
we put out so much content. Maybe I did. I don't remember. But tonight we're gonna go through like the A to Z. I was speaking with Bree as far as a presentation. I don't know what y'all know or what y'all don't know, so I'm gonna go through like a brief presentation, and then we just gonna get straight into Q&A. And I think that'll be the most valuable way to go ahead and do it. But let me share my screen, and we can get straight into the presentation. Hold on. Can y'all see my screen?
Yes.
Yeah.
Okay, cool. All right. Set allow. All right, we're gonna do a web style. I'm gonna come back on camera once we get to the actual Q&A. If y'all want to see me, you can go to my IG, Michael Benjamin, or go to my YouTube. So with that being said, hold on. I just hit this thing. Y'all can still see the presentation, right?
Yes.
Okay, cool. All right, let's get straight into it. So how to fix your credit without being a consumer law expert. Presented by yours truly. So just quick housekeeping rules. I just hope that y'all take action with the information I give y'all tonight. Like I said, we're going to go through a brief presentation, and then we just going to get straight into Q&A, because I think that would be where y'all will get the most benefit. All right, so I just want to know if y'all could just, you could say it out loud, I guess, or if you want to put it in the comments where y'all are tapping in from. I just like to know like who I'm talking to, So let me know, or say it out loud, put it in the comments. I just want to know where y'all actually tapping in from.
My name is Rich. I'm tapping in from Los Angeles, Cali.
Yeah, okay, Cali, that's what's up. Anybody else, if you want to just put it in the comments, as we go through the presentation, I would like to just know where you're tapping in from. But our objectives today, we just got 2 simple objectives. If you've seen my content, if you've seen me online and everything, I like to make things super simple because I don't like overcomplicating things. We got a lot going on in life. We don't got to overcomplicate nothing. So number 1 is we're going to discuss how to build a perfect fundable credit profile. Number 2, we're going to learn how to delete any negative item legally on your credit using consumer laws. When I say any, I mean any item. Like if you read the laws, y'all will be able to see what I'm saying. So we're going to get into that. So what I need y'all to realize is that this can possibly be the single night that changes your life forever if you are not lazy. So just remember that as well. I'm assuming y'all are not lazy. Y'all made an investment in yourselves of being a Breeze group. So I have no doubt that y'all will be able to, take action with the information. So I just want to go through just a little bit of my story because, everyone has a story. So back in the day, I went to college. I graduated with a chemical engineering degree. I was working as an engineer for years while I was taking on multiple failed side hustles. And then I started my first LLC in 2018. Fast forward, I self-published a book in 2019 called The Power of Yet. And then I was doing speaking engagements, as you can see right there. And at the same time, I was always just hungry for information. So I was investing, a lot of money into my personal development, just trying to figure out how do I leave my 9-to-5. Fast forward till now, February 2021, I invested $3,500 specifically in a mentor and many more mentors. But that led me to learning about credit and consumer laws. And I just continued to invest, continue to learn about what I was doing. I started my business called CAT, Consumer Ammunition Tactics, in 2021. I retired my 6-figure 9-to-5 job in June of 2022. And then now I'm just basically, as some of y'all have seen me on YouTube, I'm on a mission to help fund $1 billion to small business owners. The foundation of that is what we're talking about today, which is good personal credit. So if I could literally use this skill to be able to leave a 6-figure 9-to-5 job, I don't know if y'all work a 9-to-5 in here, but you should definitely be able to copy and paste what I'm telling you to do and at least get some results, even if you don't take it as like a business per se. So I just wanted to just put it on the screen because we got to look at some results for deletion of items because I want y'all to realize that you guys are next. I don't know if someone's not on mute, but if y'all can make sure you're on mute, just so, the recording not coming a little weird. So 37 hard inquiries deleted is somebody that literally followed what I said. So the information I'm giving y'all tonight, like This is an average person that literally did what I told her to do. So as long as y'all do what I tell y'all to do, y'all will literally get results. It's as simple as that. Bankruptcy deleted. This is one of my students as well. I'm going to give you information tonight. If you just follow instructions, you'll be able to get results. I had a separate student, one of my students, I helped them basically sue one of the credit bureaus. They got a settlement check. Different student, charge off deleted. Different student, child support deleted. Collection deleted. 6 late payments corrected. So those of y'all that know a little bit about credit, you know, when it comes to late payments, sometimes it might be a situation where you're going to delete the entire account. Sometimes it will be a situation where you want to correct the actual late payment. So we're going to walk through the law and how my student that I just posted right here corrected those. And he said, what, under 4 months. So, and then the CFPB response is there. So, you know, the receipts is right there. Repo deleted, again, different student. I say that to say that y'all could do it too. I like interaction. So if you could drop a 1 in the chat if you believe you can do it too. I just want to see them ones and we'll go from there. So step number 1, we want to make sure we're building a perfect credit profile. We're going back to the basics. Like I said, some of this may be review for some of y'all. Maybe some of y'all haven't really tapped into credit like that. But once we get to Q&A, you know, you can ask me the questions that you need to ask me. So this is basically the pie of your FICO score. There's your FICO score. There's your Vantage score, Vantage 3.0 when you go into Credit Karma. Those are 2 different scoring systems. So just to run through it real quick, 35% is payment history. So pretty much over a third of your score is payment history. So basically, if you got 1, 2, 3 late payments, your credit is pretty much cooked. You know what I'm saying? So that's why you want to pay attention and do what I say so you can get back on track and be able to fix your credit, leverage it to get the funding that you need. I know this group is mainly based on funding. So, you know, you need that personal credit so you can leverage that. 30% is amounts owed. This is basically your debt utilization rate. They always say that average is 30% utilization rate, but I don't want y'all to think as average. You want to look at it like single digits or less. When I'm talking about funding clients, and this is something y'all can use too. When I'm talking about funding clients, I told them it's got to be single digits or less. So when you're looking at your debt utilization rate, think about like 9% or less. Don't look at the average of what people say. So if you look at 35% and 30%, damn near 2/3 of your credit report is structured based off of your payment history and your debt utilization rate. What that means is that those 2 are very, very important. So you want to protect that, whether it's for yourself or for your clients. 10% is new credit. What that means is hard inquiries. If y'all don't know what a hard inquiry is, it's basically whenever you apply for new credit, you get a hard inquiry. It's going to have a month and a year based off of when that was pulled. Like if you go to auto dealership, a lot of times they run the heck out of people's credit. So you're going to get a lot of hard inquiries over there. If you don't know how to remove hard inquiries, I'm going to go over that today. And you can literally turn that into a business. I got students that just literally focus on hard inquiries making money. So y'all could definitely do that too. 15% length of credit history. So you want to make sure that you have a decent amount of credit history. Y'all are into funding, so I'm pretty sure y'all know about trade lines. So you can do that at the end if you don't have a lot of history on your report. And then 10% is credit mix. So you want to have revolving accounts. You want to have installment accounts, which are going to be like your student loans. Revolving is going to be like the credit cards. You want to have personal loans and things like that. So you just want to have a good mix, because someone that has a good credit score doesn't necessarily mean that they have good credit. They just have the score, but your credit score does not matter, which brings me into my next point. I said this like, I want to say 2021. I used to have a podcast that I would upload a lot to. I say your credit score does not matter. I had a lot of people in my DMs just on some what do I mean by that and all that. And that goes back to what I was saying. It's more about the structure of the report, how you structure your credit profile. So just like a high level view as review, or if you don't know about the process, number 1, what you want to do, like this is step-by-step. You can literally screenshot this and just follow it. Number 1, you want to grab your consumer reports. Yeah, you can look on Credit Karma for an example. You can look at Identity IQ, the other monitoring, but
typically I would recommend that someone goes to annualcreditreport.com. I have my team that does the credit repair side of things, and we use the identity IQs and all that. But if I'm taking on a personal client, like I'm doing it myself, I'm gonna get their actual reports. I'm gonna log into their Experian. So you can go to your Experian, their Experian, if you're doing it from a business perspective. But the main point, you want to get your consumer reports. So get all three of them. And then number one, the first thing that you want to do, you want to make sure that all your personal identifiers are updated. So what does that mean? This means removing old addresses, old names, and things like that. You want to basically not look like you're unstable. If you got a bunch of names, a bunch of addresses, and things like that, one, you could look unstable. Number two, some of those items could be tied to negative accounts. So you want to just make sure all those personal identifiers are updated. And then the main thing, which a lot of people may go through, is removing all derogatory remarks. So that could be all the items I just showed y'all earlier that I have students deleting. It could be hard inquiries, charge-offs, collections, etc. And my thing is that consumer laws are the best way to do it because it has legal standing. Yeah, you see stuff about like factual disputing, Metro 2 is out there and all that, but consumer laws is what allows you to actually have legal standing if you decide to go that route and actually sue the company or sue the debt collectors, whatever the situation is going on. And then the step after that, if you have no negatives, obviously you want to build a well-rounded credit profile to maximize your points in all categories. Okay, somebody go on mute. I think I heard somebody talking. But the name of the game is pretty much maximizing the amount of points that you can get. So don't leave any points on the table. Going back to what I said about average utilization rate is 30%. Don't stop at 30%. Try to get to single digits, so you want to maximize your points. So let's talk about payment history because, again, it is 35%, which is over a third of your score. So the reality is you can do goodwill letters, but I prefer, and our company, we use consumer loss. So after the training, you shouldn't have an issue maintaining 100% payment history. It's not going to be like, oh, I send this letter out and it's guaranteed. You may have to do it a couple times. So keep that in mind. So I say that to say, as you go through the presentation, or if you even ask me questions, you should have the knowledge to take control of your consumer report. It won't be overnight, but you'll have the tools that you need to move forward. Debt utilization, like I told y'all, just as a review, 30% is damn near a third of your score. It's pretty much how much credit is being used in comparison to your overall credit limit. Second point, like I said, remember average recommended is 30%, aim for single digits. I'm hearing noise in the back. Can I mute everybody on now?
Tori, that's Tori mic. Tori, you can mute your mic.
Okay, hold on, let me go back.
Oh yeah, you can because you got host. I can't do it.
Okay, no problem. Let me see if I could. Hold on, mute. Okay. Okay, I got it. All right, that was a key distracting me, but no problem. All right, so you want to know your dates. So understanding the relationship between or among your due date, your closing or statement date, and reporting date is very, very important. So your due date, self-explanatory, it's when the bill's due. Your closing or statement date, it's when the date is the date that closes that the billing cycle will be reported to the CRAs. If you don't know what a CRA is, it's a consumer reporting agency. Basically, is the credit bureaus. Reporting date, it's the date that it actually reports to the CRAs. And then lenders, one thing you got to remember, lenders usually do give you a grace period, so you don't always have to technically pay by the due date, but you want to do your due diligence. Basically, the strategy with it is make sure that your utilization rate stays low after you pay by the due date and past that closing date. So it reports as low utilization to the CRAs. All right, so just some things on how to actually reduce your utilization rate if you're suffering from a high utilization rate. Credit limit increase. Obviously, if you get a higher credit limit, you're using less because you got more overall. You could see what you can get with a pre-approval through a place like Happy Money or SoFi. There's other lenders out there. They could possibly pay that debt down for you. You can get a new credit card if everything else is good for you. Again, you're adding more credit. You could be added as an AU onto someone's card. And then this group is about funding. So obviously, if you got a 0% business credit card, you pay that off and
you're taking that stress off of your personal side. Let's say you want to hide your utilization rate. So this is something that I used to speak about back in the day, and pretty much what you can do. So some banks allow you to change your due date. It's not going to be every bank, but the basic instruction of what this is you would divide your credit limits in half and then make them due 2 weeks apart. So like, let's say you got one 10K card that's due on the 1st, you got two 5K cards that are due on the 15th. So they do 2 weeks apart. When the 1st is about to be due, you would take the money off the credit cards for the ones that you have that's due on the 15th. Use that to pay the ones that are due on the 1st. When the closing date and the reporting date are happening, maybe by the 5th or the 6th, it'll report as 0% or low utilization, whatever it is. And then when the 15th comes, you basically just rotate it. So it's like rotating balances. Like I mentioned earlier, I do have a YouTube. If you just go to my playlist, there's manufacturer spending. It has like over 100 videos on there. It'll kind of explain more about that. Don't stress yourself out about your utilization rate necessarily if you're not actively applying for anything. I know life happens, so just a word on that. Drop a 1 in the chat if you're still with me. I just want to make sure nobody's sleeping. I'll take a water break. All right, so length of credit history. So pretty much it's 15%, like we said. 15% isn't going to kill your score, but you don't want to sleep on your length of credit history. I would recommend you have at least 4+ years of history. Like I say, you could look at Credit Karma as an estimate, but it's not your FICO. So just remember that. If you need more age, get an AU. And then new credit, that's going to be hard inquiries, like I said. Pretty much if you have too many hard inquiries, you got to look at it like you're basically looking thirsty to the lenders. That's the way you got to look at it. And I would recommend not having more than 4 per CRA before you go for that funding sequence. And then I'm going to teach y'all how to delete hard inquiries. So if you don't already know how to delete them, it'll help you. As y'all saw in the beginning, I showed you one of my students that deleted. She deleted like 37, I think, in 6 hours. So yeah, it's not rocket science. Credit mix, 10% isn't going to kill your score again, but a lot of people disregard it because a lot of people that don't know about credit, they'll just be like, oh, my credit is good because my score is over 700, but you want to make sure you have that mix. Like I said, people have a high credit score with no mix of accounts, and they're going to be confused why they're getting denied if they're not reading the adverse action letter. So you want to aim to have at least 10 positive reporting accounts. So that includes installment loans, revolving accounts. And then, like I said, you want to have primary trade lines, which are your accounts as well as AUs. So I'm not going to read everything on here, but you can just take a quick screenshot. These are just some credit builders. With our credit repair service, we typically give these different accounts to our clients that they can go and apply for. A lot of people know about the whole Navy Federal pledge loan thing, but we also utilize a Hughes Federal Credit Union as well. So yeah, hopefully you got a picture of that. So that's just a little bit on the building side. If y'all have any questions when we get into Q&A, you can ask. But number 2 is basically how to delete any negative items on your credit report using consumer laws. So number 1, I need y'all to commit to understanding that any item can be deleted. I know a lot of times people that aren't in these types of groups that like y'all are in Breeze groups, I'm pretty sure y'all mindset is different from like the average person, but drop 1 in the chat if y'all got me. You believe that you can delete any item. Like I showed y'all people deleting every item, basically. Just drop a 1 in the chat if you actually believe it. Okay. All right, so a little commercial break real quick. We will not have time to go over everything, but like I said, I literally have like over 2,000 videos on YouTube, so you can go ahead and look that up at your convenience. Has anyone heard of the Fair Credit Reporting Act? This is 15 USC 1681. I feel like y'all have. Let me say, has anyone not heard of it? That's probably a better question. Has anyone not heard of it? Has anyone heard of it? That's what we're going to focus on today for the most part. The Fair Credit Reporting Act. Do y'all know what that is? 15 USC 1681.
Yes.
Hold on. Okay, I got a yes. Okay, I see a yes in the chat now. My bad, I've been ignoring the chat.
Just been saying comment. All right. So that's what we're going to talk about. So 15 USC 1681. So when you go to the law, you see at the top it says congressional findings and statement of purpose. What that means is basically Congress found something on that was happening, and then this is the whole purpose of why they released it. So I want to just focus on the bottom, really, B. It basically, like, the whole purpose of it is to make sure that reasonable procedures are being maintained. When we look at, let's just look at, the top. It says a Congress makes the following findings. The banking system is dependent upon fair and accurate credit reporting, right? And they're talking about the fact that inaccurate credit reporting impairs the efficiency of the banking system, and it basically is, it just messes up the whole system is what they're essentially saying. If you look at number 4, it says there's a need to ensure that consumer reporting agencies, which I said earlier are credit bureaus, they exercise their great responsibilities with fairness and respect the consumer's right to privacy. So remember that, that's important. But the main thing I want y'all to take out of it is the reasonable procedures. Because when we talk about litigation with the FCRA, when you understand the procedure that's supposed to happen, that's more so how you can have a reasonable claim to actually bring up in court against the credit bureaus. It's a little technical, but it's not, impossible. But just keep that in mind. Reasonable procedures. You want to think about what is going on. Are they doing an investigation and things like that? So I won't break down the whole FCRA, but we'll cover what you need to get results, right? The main thing is getting those results. So administrative process, if you don't know what that is basically your route towards getting your desired result as far as the deletion. Let's keep it simple. So number 1, you're going to send your notice of dispute. Or if you're dealing with like a collection, you will send a debt validation. So that would be under a different law, which is called the FDCPA, Fair Debt Collection Practices Act. That would be 15 USC 1692. Our main focus is on the FCRA today, so 1681. So when I'm talking about the notice of dispute, some laws that you want to look at are 15 USC 1681I, which is, you want to think about I and think of investigation. That's basically the investigation section, right? And it's basically called a procedure in case of disputed accuracy. Procedure in case of disputed accuracy. We're going to look at one of the parts that I think you should utilize in your letters. It's literally in our SOPs for my credit business, so you definitely should be using it. And then 15 USC 1681E. So this is the compliance procedures. One of the ones I like there is 1681EB, the maximum possible accuracy law. So just keep that in mind as well. And then what I said about the FDCPA, 15 USC 1692G. So that's going to be your debt validation law. So once you sent out that notice of dispute, the whole purpose of your notice of dispute is, it goes back to what I said in the beginning. You pulled your credit reports, you're looking at the information. I'm pretty sure as you look at your report, there's going to be some information that's either inaccurate or incomplete. So those are things that you want to look for. As soon as that happens, what you're doing now, you're writing a notice of dispute to the bureaus or the CRAs, letting them know, like, okay, I found this on my report. I'd like to request a reinvestigation. And the reason why it's a reinvestigation and not investigation is because before they even publish information on your report, this goes back into the procedures. Before they even publish information on your report, they were supposed to do an investigation. So if you go to 15 USC 1681I, you'll see it says reinvestigation. So that's where that reinvestigation comes from. So let's say you send it out. They say the typical verified, which is what they're going to do sometimes. You'll send your method of verification notice. So the whole purpose of this is questioning how the information was verified, because they have the automated system that just says, oh, verified, but it's not anyone actually doing an investigation. So 15 USC 1681I number 7, that's what we want to pay attention to in terms of the method of verification notice. I got a YouTube video. If you just search method of verification and my name on there, it'll break it down more in depth, like a whole video, like I'm going line by line, all that. And then the step after that, you can send more letters, but I recommend if you actually have a claim where relief could be granted, you can go ahead and sue them. And one piece of advice I recommend that y'all do. This is in our SOPs as well with my VAs. Each step, I would recommend that you submit a CFPB complaint. So CFPB, if you don't know, for anyone that's here or anyone watching the recording, it's the Consumer Financial Protection Bureau. And basically, they're supposed to be like the people that govern the credit bureaus, like their misconduct and things like that. So it's not like a guaranteed thing, but it's good to do a CFPB complaint, especially if you're deciding or if you're thinking about going ahead to sue the bureaus, because you show that you attempted to resolve the conflict in private before you brought it to the public, which is in court. State Attorney General complaint as well. I recommend that you submit that as well. You can submit a BBB complaint. We see a lot of success doing that with collections. And then OCC complaint as well is pretty good. So I recommend that you do as many of those as you can, just to add extra pressure to your letters. Again, if you don't know about credit, I could do the same thing for client 1 and client 2. Maybe client 1 got it deleted, client 2 got a told verified. So it's one of those things you got to look at it from the mindset of, I'm just going to keep on going and just be persistent. Looking at it like a boxing match. If somebody comes to me and they're just like, okay, fix my credit or something. Boxing matches aren't just predictable like that, unless they've already wrote the script or whatever. But it might be a situation, maybe the knockouts in the first round, maybe there's no knockout, maybe it goes a distance, maybe it's a knockout in the 7th round. So I want y'all to just have that mindset to look at it like that. All right, so let's look at 1681I, like I said. So 15 USC 1681I, procedure in case of disputed accuracy, like I told y'all, as y'all can see right there, like I said, reinvestigation. It's not investigation, reinvestigation, because the whole purpose of how the FCRA was constructed and what reasonable procedures are is that these bureaus are supposed to already do an investigation before they even put the item on there. That's why we have a law like 1681 EB, which is talking about the maximum possible accuracy law. So I recommend that you put this section in your notice, in your request for a reinvestigation. So keep it simple, right? So 15 USC 1681I A1A. As you see right there, I'll just kind of read a summary of it. It says if the completeness or accuracy. So if you look at your report, you see something's not complete, you see something's not accurate. Of any item of information, what does any item of information mean? Any item of information can be your personal information. Any item of information can be a charge off. It could be a collection. Any item of information, there's no restriction on what it's talking about. Whatever's on your damn credit report, you know what I'm saying? So look at it in that aspect. If any item of information in a consumer's file, you're the consumer if you don't know what that means. At a consumer reporting agency, it's disputed, right? So your dispute, like I said, is the notice of dispute. That letter that you're creating where you're asking them to do a reinvestigation is disputed by the consumer. And the consumer notifies the agency directly. What is this? This is you sending a letter. You go to your post office, you do it online, however you do it, right? Or indirectly. They said the agency shall. If you look up the term shall means that they have to do it. It's not optional. May means it's optional. Shall means that they have to do it. They shall conduct a reasonable reinvestigation, right? They're supposed to conduct a reasonable, they're not supposed to conduct a reasonable investigation. It's a reinvestigation because they were already supposed to do an investigation when they put that information there in the first place, to determine if the disputed information is inaccurate and record the status, blah, 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 before the end of the 30-day period, etc. So that's basically what the law is saying. And this law is very, very powerful because you can use this law as your foundation towards going through a litigation situation. All right, so how to write a dispute letter. I recommend you write your letters. Don't just copy and paste. Obviously, put this in your letter, but include these elements. Obviously your name, address, date, last four of your social, and then make your demand and reference the items in question and the relevant laws. So to keep it simple, you're literally requesting a reinvestigation per 15 USC 1681I, and then let them know, like the law says, delete this item in 30 days after the investigation is done. Don't overcomplicate the process. Read the law and then what you're asking them to do within that law. So let's talk about specific items. So going back to what I said about late payments, It could be a situation where you're deleting the entire account. It could be a situation where you're correcting it and you're keeping the account because of history or whatever situation you're doing it for. So you can correct late payments on an account and keep it, or delete the entire account. Like I said, within our business, we've specifically had success with 1681B number 2, which is a permissible purpose law. We've also had success with 1681C-2, block of information law, and then also the opt-out law. That's not the FCRA, but it's 15 USC 6802. So that's worth looking at as well. So I'd recommend you create customized letters for both the creditor and appropriate CRAs, depending on what you're doing. And then, like I always said, submit a CFPB complaint, state attorney general, etc. Be persistent. There's no guarantee it'll be deleted immediately. You could also, if you're using FTC report, you can go that route. If you want to submit a goodwill letter, go ahead, but you got consumer loss. So let's talk about actually correcting it. So you may have seen people talk about this online. 15 USC 1666B, timing of payments. So it says a creditor may not treat a payment on a credit card account under an open-end consumer credit plan as late for any purpose. So a lot of people just stop at that part, right? And one of the ads I'm running, actually, I literally explained this law, and people that know what it is, like they knew, like, okay, he's actually explaining it more than most people explain it. So when you read the entire thing, it's basically saying that the creditor, or let's say whoever is reporting your late payment, let's say it's Chase or Citibank or whatever, they're basically supposed to adopt reasonable procedures. They're supposed to follow the requirements under 1637B. So you can write that down and look it up on your own time. But they basically have to make sure that they mail or deliver that including your statement to you, no later than 21 days before the due date. So how do we use this to our advantage, and why is it powerful? We use it to our advantage because what I recommend that y'all do, if it's for yourself or your clients, you want to get out of paperless billing, because when you're enrolled in paperless, they can have the argument like, we sent it to you online. But if you get out of paperless billing and you're saying that you want your statements mailed to you, that's where at the point they have to mail it to you. But furthermore, this is where some people don't understand it. Furthermore, if they're claiming that they mail something to you, we need a tracking ID for that. They're just going to do regular mail. They're not going to have a tracking ID for that. So the same way that you have the green return receipt when you do certified mail, that's what you're requesting for them to send to you. So this is how, I teach my students and how they've had success correcting late payments. You saw the student I posted earlier. I think it was 6 late payments he corrected. But yeah, that's how you want to approach those late payments. So hard inquiries, like I said, you can delete them pretty easily for the most part. So you could delete hard inquiries that are not tied to open accounts. So if it's not an open account on your credit report, it's good to go. And that goes again on the business side. You obviously have exceptions like a Discover, Capital One, there may be more, but yeah, for the most part, you could delete those hard inquiries that are not tied to open accounts. So Experian is pretty much the easiest to delete. It should be gone within 24, 72 hours. I always tell people, now I'm teaching, say this on my YouTube, you can literally start a side hustle deleting these for people. If you don't even want to know all these consumer laws, you can literally just delete hard inquiries. So this is a working number, 1-800-493-1058. Literally just ask to be transferred to the fraud department. You'll dispute them as unauthorized fraudulent inquiries when you get a rep, and then you read them off. You can literally say this: I pulled my credit report. I noticed some unauthorized fraudulent inquiries I would like to dispute. After you read them off, they may ask, oh, do you want to put a fraud alert? You could say, oh, no, I'm about to apply for something. And then you'll wait 24 to 72 hours. They should be gone. Or if it's not gone within that time frame, then, just keep going again and again. So the reason you can dispute them as fraudulent or victim of identity theft is because they did not receive your written consent to furnish the information. So when it comes to TransUnion or Equifax, so typically what you're going to want to do, you're going to want to mail it. And Equifax, I would mail it too. These are some previous fax numbers that were used. They may or may not still be working ones, but I would recommend that you mail Equifax as well. And you want to go ahead and mail the FTC report. And the law that you typically want to use is 15 USC 1681C-2. That's a TransUnion address right there. You can Google the other ones. But basically in the personal statement, you can just use what I put there if you want. You don't need the 18 USC 1028A. You can include it, but the main thing is the 15 USC 1681 C-2 law. That's the FCRA law, and it should be deleted within the 4 business days. And you want to do a certified mail so that you have proof of when they received it, and you can calculate the 4 business days after that. Alternatively, I know some people, they might not want to go that route because they're thinking like they're scared of identity theft, all that. You can still get results sending a permissible purpose letter using a 1681 B number 2. So keep that in mind as well. Collections. So my personal recommendation, I don't recommend you pay them because the turnover and how they actually attempt to collect triggers FDCPA violations. And you can actually, sue these third-party debt collectors. And a lot of times what'll happen as you go through the settlement, they'll waive the debt and you may get a settlement check as well. So one thing you got to remember is that paying that collection will not necessarily help your credit score unless you got an agreement that the entire account is going to be deleted. I've seen some people, they said like they paid it down, but the collection still stayed there. And I'm like, you should have got in writing that they were going to delete it. So best practice, I always say send a debt validation notice first, referencing a 1692G. Sometimes you might get it deleted that way because they know that if it were to go to court, the turnover process, a lot of times they have a clause in there that says that the information is not 100% accurate. The turnover from the original creditor, quote unquote, to the third party collector. And then you could dispute the collection, or you can go the route of suing them, like I said, to get the debt waived and a settlement check. But, that's a more elaborate process. I got some of that on my YouTube channel as well, if you want to go watch. All right, so let's say they said verified after you send your first notice. What do you do now? First of all, don't panic. What you can do, like I said, you want to focus on that method of verification. So 15 USC 1681I number 7. So as you see right there, the law basically says a CRA or the credit bureau, they're supposed to look at the word shall. Remember I said that they have to do it. They shall provide to you, the consumer, a description referred to in 6B-III. So you can go and look that up as well, by no later than 15 days after receiving a request from the consumer for that description. So basically that method of verification, you're asking them to provide certain information in terms of how they did their investigation. But remember, the spoiler alert, they don't do an investigation. They just have this automated system. It's so many consumers sending in these requests, these disputes, they're not going to do actual investigation. So just do what you will with that information. Let's say round 2 fails. What do you do now? So you should sue them. That's my recommendation. That's not legal advice, but that's what I would recommend. So I had a one-on-one client. Basically, he kept disputing his bankruptcy and he wanted to know how he can go about suing them. So I gave him some information as far as how to do that. He got the item deleted. It got settled outside of court and he got paid $1,000. And then I had a different student that actually sued TransUnion. So this one was Experian, but I had a different student that sued TransUnion. He didn't get a settlement check, but he got his items deleted. And he said some of them were actually, he said these were not all negative accounts. So some of them were actually positive accounts as well. So just keep in mind that when you do these disputes and you're actually reading between the lines and understanding what they're supposed to do with these reasonable procedures, you're the one that's in power if you press forward with that. We won't go in depth with that because as far as litigation, so I want to keep it simple as far as FCRA. And, I'm not providing legal advice, but everything I'm saying on here is just facts, right? I don't want to dabble into legal advice, but your claim, if you're going through litigation, should have the following elements. Obviously, you're going to have the legal basis. So you got to identify the legal basis for your claim. Is that 1681I? Is that 1692? Like, what's the statute that you're suing based off of? And then, you got to provide a detailed and specific account of events and how they violated the legal right you're seeking to enforce, your relief. And then just word of advice, if you do fail to have a claim, like you're not on your P's and Q's, they're most likely going to hit you with the Rule 12b-6 defense motion, which basically says that you don't have a claim where relief can be granted. So just keep that in mind as you're moving forward. So with great power comes great responsibility. So all this information I gave y'all, just just do good with it. So thank y'all. Remain blessed. And now we're into Q&A. Oh, shoot, my bad. Someone was in the waiting room. But yeah, if y'all got any questions, we can go ahead and get straight into that.
How you doing, Michael?
I'm blessed, man. How you living?
I can't complain. I can't complain. I have some late payments that the first process that I did was they had inaccurate information on the reports. Like they had three different bureaus showing different late payments. So I asked them to remove the inaccurate information on all the bureaus, and all they did was they updated all of it. Then it like slammed my credit. So then on round two, um, I sent another because they still had it wrong. So then I did it again, and they updated it again, and they updated it wrong again. So then I went to the CFPB, showed them the proof, showed them the receipts, how they were, and they still didn't do nothing about it. That's where I'm at. Now it's two separate credit cards. Now at this point, they're both paid off. I don't owe no money on them, but the late payments are killing me. What should I do first to get them off after doing what I did already?
What law did you reference in your dispute letters?
I use the 6166B.
And you sent that to who? The bureaus or the creditor?
I send it out to both of them.
Okay. So what did the creditor say?
The creditor just, you know how they do it, like, no, we verified everything and that was it. They
Do you,
didn't.
do you have like did they mail you the response? Do you have that, or did you like throw it away?
No, they emailed it.
Okay, so you
They
have the
said
email. You have access to the email.
I got access to the email. Yeah, it's probably on this. If I dig for it, it's in there, like saved somewhere.
Okay, I mean, I would keep that piece of documentation because if you do want to go through suing them, basically with 1681I, like I just went over with y'all, the reasonable procedures, what's supposed to happen is they're supposed to do the reinvestigation. Part of that, they're supposed to contact the creditor. So the fact that it wasn't corrected correctly, it's either going to be the bureaus or the creditor that's held liable because basically, if the bureaus try to say that we did our investigation, they went and asked Chase or whoever it was, but they just listened to whatever Chase or them said and then they corrected it wrongly, they're still at fault because they didn't do an investigation to make sure that Chase wasn't capping, basically. So that responsibility of the creditor is 1681 S-2. I would look up that law. So that's how you could hold them liable. But as far as moving forward, I would look into those responses that you got, like the email that you said you got from the creditor. I would have the responses from the bureaus. You have those responses as far as I'm updating it incorrectly, right?
Yeah, from the CFPB, they said that everything was verified,
Okay.
but they
So
updated and verified. So
I mean,
my whole thing was like they had like it was like bad. Like they had on all three bureaus, they had like 60 days, 2 months in a row. That can't be. You can't be 60 days, 2 months in a row. Has to be like 30, 60, 90, And all they did was update it. They didn't update it correctly and they did it twice. They like hit my credit for like 70 points twice.
yeah. So I mean, like I said, if you have the responses and everything, I would, based off what I'm hearing, I can't physically see what you have, but based off what I'm hearing, I would file a suit against them. You just got to figure out what laws you're using. So, like I said, you said you use 1666B,
Yeah.
but if you're filing a lawsuit against the FCRA, the 1666B is not FCRA code.
All right.
Yeah, so you just got to look under if you're going to go that route, you can get it with the consumer lawyer as well if they're willing to take that on. But I would look under the FCRA, like I just showed y'all 1681I, like really study that law and what's supposed to happen. Based off of what you're telling me right now, like relate that to 1681I.
you sent a notice of dispute. They're supposed to do an investigation. Somehow they updated information and it was wrong. Either they updated it wrong or they just listened to the creditor that gave them wrong information updated. So then now that becomes liable on the bureaus for listening to wrong information, but also the creditor because they're reporting inaccurate information. So now that's 1681S-2. So you got to just sit with the laws and just kind of really paint the case of what's going on.
Okay. Thanks a
Does
lot.
that make
Appreciate
sense?
it. Yeah, no, it made a lot of sense. Yeah, it
Okay.
just, when you don't know about the consumer law, you listen to other people, and then, I probably should have attacked it another way. I shouldn't have
No,
probably
1666B is good, but what I'm saying, like, if you're gonna, this is not legal advice. If you're gonna sue them, you could look up literal case of 1681I. You want to kind of focus on the procedure of what went on. And the tricky thing too about late payments, especially if it's like a open late payment or so, when I'm talking to clients, I kind of let them know that whenever we're suing, it's more so for getting that item deleted versus like with a late payment where it could be a situation of, correcting it. So that's kind of where late payments are a little bit tricky when it comes to stuff like bankruptcy, that invasion of privacy. And then just the procedure again, they're supposed to contact the furniture. Bankruptcy is kind of an easy case because they didn't get the information, from the bankruptcy court. So with late payments, you may have to keep disputing, but you can't look at the procedure. Like I said, the fact that based off what you're telling me, I'm only going based off what you told me. The fact that they updated the information wrong, I don't know who's in the wrong, either the creditor or the bureaus, but someone's wrong and someone has to be held liable for that.
remember I in the beginning I said that the accounts were paid, right? So I paid them and I closed them because I didn't want to deal with them no more. So I paid my cards off because they were active cards. So I paid them off, and they're closed. You think I should just like remove the whole account, or should I still attack the late payments? Because the accounts are like
I don't
closed
know.
now.
I don't know what I don't know if that's a new, old, like I don't know how that will affect your credit. So you got to make that judgment for yourself. If it's like an older account, you just got to realize that you're gonna lose history.
But like, won't it help my credit? Because if I
It can help
remove
your
the
credit
whole,
at the same time, but like let's say it's a 13-year account and everything else is like 1 year. Obviously, you're losing age. So
yeah, I'm just thinking that once the late payments go away, it'll help my credit.
it will, yeah, for sure. But at the same time, you got to remember you're doing two things. You're still removing positive. I'm giving you the scenario if it is
Yeah.
one of the older accounts. But yeah, definitely removing a late payment will help. It's 35% of your score, so
Got you. Appreciate it. Thank you.
yeah, no problem. Does anybody have any questions?
I have something.
So
Is it a way that, because I know everybody don't know the consumer laws and want to kind of study them and just want to use it to get results. Is it a way that you can give templates or verbiage on how that law is supposed to be written out in the dispute letter?
what do you mean by that?
So like so the round one letter, the round two letter, like what those letters actually look like and how to use, because I know you gave out the laws, but how do we use these laws in the letter? What does that verbiage look like?
Oh, I got templates with my students, but like a basic thing I would say, just going back to the presentation, I tell people not to make it, too deep. So literally put the law and then be like, what's it called? I'm writing a notice of dispute. These are the items that I want to dispute. And the main thing is because I know people overthink about it. So literally just copy and paste the law that I said and just say that I'm looking to dispute these items and then just literally list it. It doesn't have to be too deep. Yeah. Oh, no, I'll say go to my YouTube too, because I got videos on there. There's I think it's the DIY Credit University playlist.
I literally got a letter that I'm walking. I'll try to find it and maybe I'll send it to you. But I would say it's on my YouTube for sure as well.
Okay.
Yeah.
Okay, cool.
To elaborate on Bree's question, so let's just say, for the sake of argument, let's just say I'm gonna use a 1681 i7. Let's just say,
Okay.
you said keep it simple, so do I just put the item and just put the 1681i, or do I have to put verbiage along with it from the law in there?
Well, how would you recommend that you do it? I just want to see what your thought process.
Because I'm real thorough, me personally, I'd probably want to put like at least a line or two from the law in it. But I just want to know, do you need to do that? Because a lot of people say that once you put the law in there, they already know what the law is, so you don't have to do that. I just want to know what is the proper way to do it. What do you think? Like, how would you do it? How would you guide me to do it?
Yeah, so going back to what I said, I would just make it super simple because I know when I started in 2021, I went through this as well. Like, okay, do I got to do this? Do I got to do this? Do I got to do this? But when you simply think about it, when we talk about just a 1681I claim, the reinvestigation, I could literally put a simple letter. I'm writing a notice of dispute to dispute these items based off of 1681I, A1A. And then these are the items. I send that. I already triggered the reinvestigation. Whether they know what I'm talking about or not, ignorance of the law is no excuse. You know what I'm saying? So if you want to explain all this, and that's your waste of time if you want to do all that. And I used to waste my time too. So I understand that. But I would, as far as your question, 1681 I7. So this is how I would do it. I would say, like, obviously you're using that as like your second notice. So I would say, what's today's date? So today's like the 8th. So I sent you my first letter, which you received on September 8th, and you didn't, correct it. Now I'm requesting a method of verification pursuant to 1681 I7. And then the same thing, I wouldn't, you can just copy and paste the law right there. But as you read the law, it's going to tell you what that you need from them within that 15-day period. So you'll let them know, again, do this within this period. And then that's it. That's pretty much what it is. And you got to think just high level, like you sent out the first notice. They didn't do what they were supposed to do. They're already violated. You're sending out the second notice, referring back to what you did on the first notice. I sent you this notice. You received it on September 8th. So you're explaining the situation in the letters. Pretend like a judge is literally looking at this. They're not going to want to go to court with you if you have everything on point. So you send that 1681I number 7 notice. You can make it as deep as you want or as concise as you want. You send that, have a green return receipt for that as well, because you want to be able to prove the violation. And then you can send a pre-litigation notice, or you can go straight to file the lawsuit, or bring it to a consumer attorney, see what they say if they want to take it on, essentially. But I would say don't think about it too deep. But if y'all, like I said, if y'all want like specific letters, literally go to my YouTube channel. I think it's the DIY Credit University playlist, where I go over more of the stuff like line by line. But I just don't want people to overthink too much about it. And that's why, as I'm teaching them more now, I'm more general, because if I'm giving everyone the same exact thing, we're just gonna have a bunch of robots and sending the same exact letter. So when I say just keep it simple, just keep it simple.
At what point when you dispute something that you would turn to the CFPB? Like, obviously round 1, you're not gonna go to the CFPB. At what point do you involve them?
I would.
In round 1?
Yeah, that's part of our SOPs with my VS. And that's why I recommend that people do. Yeah.
Okay. So you let's just say I'm disputing a collection, and I send out a debt validation letter to a collection. Let's just say Al and V Funding, and I put 1692G. So what do I do with the CFPB? I send them a copy of the letter I sent to the collection agency.
Yeah. So with collection specifically, we also have like a specific thing that I told them to fill out. But basically, that you're filing the CFPB complaint against the actual debt collector. So the notice that you're sending with the 1692G, I'm requesting validation of debt. And then once you have that letter that you sent over to the LVMV funding, submit the same thing as a CFPB complaint. And then the verbiage, I wouldn't think too deep about it as much. Just kind of you're filing this request of debt validation essentially, and you don't need to dispute with the bureaus, especially if you're gonna sue, if you plan on to sue the debt collectors for the FDCPA violations. I wouldn't. This is the only reason why I wouldn't dispute with the credit bureaus as well, because the instructions, the procedures of the FCRA is that they're supposed to notify the furnisher. So let's say the Experian or whatever notifies the debt collector, or the debt collector will use as an excuse saying that the reason why they contacted you is because the Experian told them to contact you, or per se. And a lot of times with the FDCPA, the violations that you're using against them is the fact that they're not supposed to contact you. So it could be a conflict of interest is what I'm saying. If you're planning to sue them, that's more technical. I don't want to confuse people. That's more
No,
technical.
I understand what you're
But
saying. Like
okay, all right.
you're setting them up basically. Like
Yeah.
you're following the procedure to also get it removed, but you're also following the procedure if you want to sue them after.
Yeah, with
That's
the debt collector.
yeah, I get it.
Yeah.
I get it.
Okay.
Let's see if somebody else wants to jump in. I could keep you here all night. Does anybody else have any questions? Maybe they have their mics muted.
Nobody have questions about the consumer laws, how to remove anything using consumer laws or your negative items off your credit report?
No. I have a question. Do you have the laws like on your YouTube page as far as like what each law is for?
For what item specifically? Are you saying like just all different items? Hello? You're on mute if you're talking. I'm not sure if you're talking.
Oh, yes, I was. I'm sorry. Yeah, just all of the different laws like the 1681C-2, 1681I-7. Like, do you have those laws on your YouTube channel as far as like what Bree was saying, like just like a mini template, or not necessarily a template, just like what they're for? Is like, okay, like 1681C is for removing inquiries. 1681I is for late payments, or just something to kind of guide.
You're talking
Like
about
a
like
guide?
yeah, you're talking about like a sheet or something?
Yes, just like a guide on what that law is and what it's for.
Gotcha. No, the answer is no. I just upload a lot on the YouTube, and as I guess people binge watch it, they can kind of tie it together. But if you have, I mean, we could literally talk about it right now. If you have like specific, like you're just like, okay, what would I use for this scenario? You know, I can literally answer that right now. And you can write it down, I guess.
I think I understand what everybody's asking. Like, what I'm getting out of what everybody's asking is like, what law would you use for inquiries? What law would you use for collections? What law would you use for charge-offs? And then I think we got what law you would use for late payments. I think that's what they're asking. Can you use multiple laws for multiple accounts, or I think that's what they're asking. Like, can you use one law to take off a collection and a charge off, or are they specifically only for certain things? The
So,
consumer law.
so one thing I would say, you guys are gonna have the recording. So I said rewatch the recording because it's in there. But like, let's say collections, I would just stick with 1692G. That's FDCPA. Hard inquiries, Experian, like I said, you can literally call them. You don't have to use a consumer law for that. But if you're gonna dispute with TransUnion and Equifax, like I said in the presentation, that'll be 1681 C-2. When it comes to what other items? Collections, late payment, we went over that. That's in the presentation. You guys will watch the replay.
Charge-offs?
Yeah. Charge off. So technically, okay, let me say this. So technically, 1681I, if you guys like really look at it, is based off procedure. Any item of information. You could use 1681I to delete anything, essentially. But if you want specifics as far as a charge off, one thing that I would recommend that y'all do is request a 1099-C from the actual creditor, because if it's not like over $600 balance. So that's one route you could take. But then again, 1681I, that's like the overall thing. I don't want y'all to get, too confused with it. Really focus on studying 1681I and what it's asking. When you send out that notice, if they don't answer to fulfill what 1681I is saying, they've officially violated FCRA. So don't make it too deep. And that's kind of my way of how I teach it now to simplify it more. I guess if you look at some of my older videos, probably like 2021, 2022, when I started, it might seem like more technical and stuff, but I'm trying to dumb it down more and just keep it more simple. So that's what I would say, so you don't get too confused, essentially.
And then if the bureau sends you a stall tactic letter or a verified letter, then you want to go ahead and do a method of verification with the 1681 I-7.
That's what I would recommend that you do.
Okay.
Yeah.
What did you say 1691G was?
1692G, that is a validation of debt law.
Okay.
Yeah.
Okay, thank you. And do you
no
have your
problem.
contact information on the playback of this, as far as like your YouTube
You can
channel
see
and
my
all that?
name right there, but the app Mike O. Benjamin, if you just search it out on YouTube, you'll be able to find me. That's an IG as well. And then I don't know, Bree could, I guess, share it with the community.
Yeah,
Okay.
I'll post this information in the community like how I do with the other guests, so that y'all can have it and be able to kind of get in contact with them.
Yeah, YouTube superstar though. You just punch in his name, everything gonna come up.
Right.
All right. Anybody else have any questions? I know we getting.
Yeah, no, thank you.
You good? Tori, you good?
Yes, I'm good.
I think the replay should help y'all too, because if you're just getting new to this stuff, the way I was talking about it could seem like what is he talking about? But probably just watch a replay a couple times and watch my YouTube. That'll help. You can pause and do all that. So yeah, if it was a little bit confusing, I apologize about that, but I just want to make it as simple as possible for y'all.
I'm gonna be honest with you. I disputed a bunch of stuff, and sometimes it came off, and sometimes it didn't. But I didn't follow none of these steps. Like I use different consumer law, so I already learned a bunch of stuff today. Now I know what to put for a stall tactic letter. Now I know which law to start off with. I know pretty much 1681I you can dispute everything on your profile. You start off with that. So like, yeah, I already learned a lot. I didn't know that you taught me something else too about the late payments. I didn't know that the paperless thing mattered. That's how they got me, because I was paperless. They were sending me emails.
Yeah.
Yeah, so yeah, I appreciate it. Thank you for
No
everything
problem.
that you say. Thank you to Bree too.
Absolutely, absolutely. I hope we all learned something, Michael. I really truly appreciate it. I'll get in contact with you after the call is off to see just to ask you a few questions, get access to a few things, see how we can work on something. But other than that, everybody good. We got our questions out, right? Tori, Brittany, Sabrina, Richard, we all good.
Yes. Thank you so much for your time.
Yes,
No
thank you.
No problem.
All right. Well, I'll see y'all next week. I had this recording up for y'all in a couple hours. All right.
Y'all may email you the recording once it's done downloading.
Okay, I got you.
All right,
All right. Good night, everyone.
Good night.
Have
Thank
a good
you.
one. Thank you.
Yeah. The following 4 hours you're about to watch is really the sauce. I'm giving you all the game to help you fix your credit. We're going to be going over the Fair Credit Reporting Act, which is 15 USC 1681, if you've never heard of it. And then we're going to transition into the FDCPA, which is 15 USC 1692. So this is what you're going to use against the debt collectors as they're harassing you. I'm literally giving y'all all the sauce. I've never put this out publicly before, so I just wanted to do a different type of video. Just give y'all all the sauce so you have no excuse not to get to the next level. If you enjoy it, if you get value from it, if you want to get more information, you can click the link in the description and then join our community Cat Credit University for only $39 a month. Enjoy the video. All right, listen, my name is Michael Benjamin. I think all of y'all know that. But basically, you know, we're going to be doing a consumer law breakdown of the FCRA, the Fair Credit Reporting Act. I want to thank y'all for showing up tonight because, you know, not everybody invests in themselves. So definitely appreciate y'all being here tonight. I definitely appreciate y'all participation. I know y'all gonna participate. If y'all got any questions, definitely type them in the chat. Some of y'all are only typing to me personally, which is fine. But if you want to change your settings, you can type to everybody. I know we got some older people here, so maybe you never use Zoom. So if you got a kid around you, maybe that can help you. But it's okay if you just want to type to me. And if you got questions, I'm gonna read them out loud to everybody that is attending. So yeah, with that being said, I'm gonna share my screen and then we're gonna get straight to it. Let me know if y'all can see my screen. Type a 2 in the chat if y'all can see my screen. Type a 2 in the chat if y'all can see my screen. I just want to make sure y'all can see it. Let me make sure that y'all can see it. I know y'all can hear me. So I'm gonna need full participation if we gonna, you know, move forward how we can. Can y'all see my screen? Type a 2. Type a 2. Type a 2 below if y'all can see my screen. Type a 2 if y'all can see my screen. I don't know if my thing's delayed or y'all not typing to me or what's going on. Y'all see my screen? It says I'm sharing though, so I'm assuming that y'all can see it. Participation, please. Okay, 2. Okay, perfect. You can, okay, I think you can hear me now too. All right, so let's get straight to it. Okay, 2. Okay, cool. If you can't see my screen, get the recording. All right, let's get straight to it. So this is a consumer law breakdown, the FCRA, presented by Michael Benjamin, yours truly. Like I said, I'm the CEO of Consumer Ammunition Tactics, or CAT. That is the logo. Y'all know what it is. Let's get straight to it. I want to just get y'all straight to the point. We're not going to be here all night, but you know, we're going to be here enough just so y'all will understand the language of the law. So housekeeping rules. The main rule I need y'all to understand is that y'all just need to take action, right? When I say take action, I mean that it's going to be a lot of information that we're going to go over as far as the laws, but y'all got to really understand to be persistent, to be consistent with all the information I'm giving y'all, right? So that's mainly the main rule. I just want y'all to take action. Y'all took action by being here, investing in the class. So I definitely appreciate y'all. And those of y'all watching the replay, y'all invested in the replay. So I also appreciate y'all too. All right, so the agenda. This is basically what the agenda is looking like. So pretty much we're gonna break down the FCRA, which is 15 USC 1681. We're gonna go in order of the laws I think are most important. So just really keep that in mind. 15 USC 1681, Congressional Findings and Statement of Purpose. If y'all want to screenshot this, you can screenshot it. Just to know what we're gonna go across and cover. Then we're going to go into the definition section. The definition section is very, very important. It's very, very important in terms of y'all getting y'all deletions. So really keep that in mind. Then we're going to go to 15 USC 1681B, permissible purposes of consumer reports. Remember, these are not credit reports. These are consumer reports. Keep that in mind. Then we're going to go to 15 USC 1681C-2, which is a block of information resulting from identity theft. I want y'all to really be familiar with that section, and we're gonna cover it. I'm gonna let y'all know what I want y'all to take from that section, because I want y'all to really master deletions. As a result of everything y'all learning tonight or reviewing tonight, y'all can start your own credit business. You can host your own class breaking down the FCRA to people. So really keep that in mind. Then we're going to go into 1681N, which is a civil liability for willful noncompliance. Then we're going to cover 1681O, civil liability for negligent noncompliance. Then we're going to cover 1681S-2. I'm going to cover something that I like as far as like a second round dispute. A lot of y'all see what I be posting on social media. You probably saw the reel when I was talking about 1681S-2 in your second round. So we're going to cover that. So basically it talks about the responsibilities of furnishers of information to consumer reporting agencies. CRAs are basically Experian, TransUnion, Equifax, those people, right? So once we break down all the laws and the language of the law, we're going to go into a deletion letter example. I saw that some of y'all purchased some of the letters. Some of y'all purchased payment deletion letter. Some of y'all purchased the bundle. Some of y'all purchased the debt validation. So we're going to go over an example and just break it down a little bit even more, just so it really crystallizes in y'all mind. Then we're going to go over an affidavit of truth example. A lot of y'all DM me about affidavit of truth. So I decided we're going to include that here. We're going to go over just the components that's included in an affidavit of truth. And we're going to move forward on that. Then we're going to go towards a process towards deletions. It's not, this is the only process, it's a process. So that's why I want y'all to recognize. So that's what we're going over tonight. All right, how do I move forward? All right, mindset. So this is where I need y'all to take action. When I say take action, take action. So I need you to write down on your piece of paper, on your notes, on your laptop, whatever you got for notes, right? Don't be writing it down in your mind. Write this down. I, and then insert your name, understand that everything I was taught about credit before may not have been true. And I promise to open my mindset to what I learned today. I, insert your name, understand that everything I was taught about credit before may not have been true. And I promise to open my mindset to what I learned today. Sign and then insert your signature. When you're done writing that down, say done in the chat. Let me know done in the chat. I'll give y'all like 30 seconds or something. I just want y'all to really be in that mindset where you're taking action, right? So I need y'all to do that real quick and then type a done in the chat once you're done doing that. Type a done in it. I'll put like 30 seconds or something. I'll put like 30 seconds, something light. I need y'all to take action. Action takers are money makers. And when you take action, you're going to be getting them deletions. If you want to get them deletions, you got to take action. If you want that money, you got to take action. So write that down, type it down, do whatever you got to do that's necessary. When I see like half of y'all say done, we're going to move forward. Y'all love typing the hosts and panelists. Type a done when you're done writing that down. Type a done when you're done writing that down. Type a done in the chat when you're done writing that down. Okay. Okay, we're gonna continue. All right, so any questions for me before we move forward? Just any immediate questions? I know we ain't covered the laws yet, but if y'all have any like immediate questions, definitely type them down below and let me know. Any immediate questions? Let me know if y'all have any immediate questions. Any immediate questions? Let me know. Will there be a replay? Yeah, when you went to actually buy the class, there was an option to purchase a replay. If you didn't purchase it, you'll still have an option to purchase it. So yeah, just keep that in mind. There will be a replay. Any other question before we start getting into the law? Does anybody have any questions? Any immediate questions? Will we be covering remedy? No, we're not going to cover remedy in this specific class. This is just breaking down the FCRA, but we will be doing a separate class where we will cover remedy. That's part of the reason why a lot of people that actually applied to be in the class, I was just saying like they don't technically qualify because of the fact that, you know, they might have been studying law already. So yeah, just keep that in mind. I'll take one more question if y'all got one more question. One more question if y'all got one more question. One more question. Okay, hold on. So we're about to get into it, but I need to go to the bathroom real quick. So y'all can take a little bathroom break, give me like a minute or two, and then we gonna get straight to it. Okay, I'm back. We're gonna get straight into it. Let me stop sharing my screen, and then y'all let me make sure y'all can hear me. You know, I stopped the voice and then I went back to it. Type a 1 in the chat if y'all can hear me. I just want to make sure this recording, you know, is on point. Type a 1 in the chat if y'all can hear me. Where my Zoom at? Okay, let me. Okay, actually type a 1 if y'all can see my screen. If you see 1681, 15 USC 1681. We got some West Coast people, we got some East Coast people. East Coast people, it seem like y'all sleeping. Type a 1 in the chat if y'all can see my screen. 15 USC 1681. Type a 1 if you can see. 15 USC 1681. Okay, you can see 15 USC 1681. You can hear me. Okay, cool. 1. Okay, 1. Okay, y'all love that host and panelists. All right, so we're gonna get straight to it. So 15 USC 1681. This is the Fair Credit Reporting Act. Fair Credit Reporting Act, right? This is congressional findings and statement of purpose. Let me just give y'all some background on what that means. So congressional findings and statement of purpose, basically it means that Congress found out that there was something wrong going on. Because they found out that there was something wrong going on, they decided to put out a law. And we're gonna get into, you know, what they found. And this is really giving y'all the background to understand your power as a consumer within this United States corporation. When we say this United States corporation, you understand that the code, or you should understand, is 28 USC 3002. If you scroll down to number 15, it says the United States is defined as a federal corporation. What that means is that the United States does commerce, it does trading, right? You as a consumer, me as a consumer, we engage in commerce. So basically with the Fair Credit Reporting Act, anytime, like I said, anytime you see congressional findings, it means that Congress found something wrong that was going on. So when you see congressional findings, just think about what did Congress find wrong that was going on, and then what did they declare as their statement of purpose? All right, so let's get straight into it. So 1681, we're looking at accuracy and fairness of credit reporting. Accuracy and fairness of credit reporting. We can't even move forward yet. We got to break that down right away. The average person would just look at that and then they just gonna continue reading. Okay, accuracy and fairness of credit reporting. What does it mean to be accurate? Type in the chat below what you think it means to be accurate. What is something that is accurate? Type below what you think is accurate. Type below what you think is accurate. Type in the chat. Accurate is correct. Okay. Anybody else? So accurate is correct, right? So that is a definition. But when it comes to, okay, somebody said perfect. Okay, so perfect and correct, right? So those are both true when it comes to accuracy. But when it comes to the law, you got to understand that the law is a language. When I say the law is a language, accuracy, if you have a Black Laws dictionary, if you don't have one, I recommend y'all look into getting one. But accuracy is defined as a measure of value. When it comes to the Fair Credit Reporting Act, accuracy is defined as a measure of value. I need y'all to write that down. Accuracy means measure of value. Michael, what do you mean by measure of value? When I say measure of value, or what the law says when it says measure of value means you as a consumer, when you're reading this, you as a consumer defines what valuable means to you, right? When it comes to credit reporting, we understand that when things negative are reported, that's not valuable to us. Is it valuable to us to have a collection on our account and then we apply for something and we can't get it? No, right? So that means that that is not accurate. So when you see, anytime you see accuracy or accurate in the Fair Credit Reporting Act, I want y'all to think of measure of value. Just substitute measure of value. Don't even think about perfect. Don't even think about correct. You know what y'all said in the chat? Just think measure of value, right? So you see, it's already deep. The very first word, we got to break it down. So that's accuracy, right? And then it says fairness. What is something that is fair? What do you guys think fair means? Type down below. What does fair mean? Fairness or fair, or whatever. What does it mean? We're going to really break down the law tonight. What does fair mean? Somebody said fair, it means fair. Hey, man, what does fair mean? What do you think fair means? What is fairness? Don't be Googling now. What does fair mean? Fair. Equal. Somebody said fair means fair. That's funny to me. Okay, so fairness. So when it comes to fairness and the law, it means somebody doesn't have an unjust advantage over somebody else. Somebody said be good. Okay, so somebody said be good. Somebody said fair means fair. So fairness basically in the law means somebody doesn't have an unjust advantage over somebody else. So somebody does not have an unjust advantage over somebody else. That's what you really got to understand when it comes to the law, when it comes to the Fair Credit Reporting Act. So y'all should know now, when we're looking at accuracy and fairness, don't think about what you were taught growing up. That's why I made y'all sign that mindset thing before. So accuracy and fairness of credit reporting. What is credit reporting? It's referring to the fact that you have these stuff on Experian, Equifax, TransUnion, right? So accuracy and fairness. We got to really, really break it down. We didn't even start reading the law yet. We didn't even start getting to what Congress was saying. So you got to really understand the language before you even get into reading it. Because if you don't understand the language, you're going to look crazy when you're sending out your disputes or your demands to try to get these negative items deleted. Does that make sense? So accuracy and fairness. When it comes to the congressional findings, we're looking at accuracy and fairness of credit reporting. Those are the two things we care about, accuracy and fairness. Accuracy is a measure of value. Fairness means someone doesn't have an unjust advantage over somebody else. But let me break that down even more if some of y'all are still missing out on what that means. So not having an unjust advantage over somebody else. That means the fact of if you have a collection, if you have a negative student loan on your report, doesn't Experian, TransUnion, and Equifax have an unjust advantage over you? They have an unjust advantage over you because they're sleeping good at night. But you're the one that has to deal with that. You have to deal with the negative item being on your report. So it's understanding these language, these words, that's going to allow you to be more, I don't want to say accurate, but more accurate, meaning correct in your disputes. So you'll get those negative items deleted and do what you got to do, basically. So accuracy and fairness. I want to really break that down to y'all so y'all can really focus on it. All right, so accuracy and fairness. I hope y'all took notes. I hope y'all understand that because we're going to be substituting these phrases, the language. So if you don't understand the basic, you don't understand accuracy and fairness, you're going to be lost. So yeah, keep that in mind. All right, let's continue. The Congress makes the following findings. Are y'all following? Y'all following before I even continue? Y'all understand the accuracy and fairness? Did y'all learn something? Did y'all review anything? Did y'all know about that before? Let me know. Let me know if that's helpful. Accuracy and fairness. All right, so the Congress makes the following findings. Number one, the banking system, right? Let's focus on here. The banking system is dependent upon fair and accurate credit reporting. We got to stop right there. We're gonna break down these laws now. I'm telling you. So the banking system is dependent upon fair and accurate credit reporting. What is the banking system? The banking system is the fact that you have what's it called? The banks like Bank of America, you have Chase, all these people you're doing business with. That's the banking system. They said the banking system is dependent upon fair and accurate credit reporting. What do we define fair as? Fair means not having an unjust advantage over somebody. Accurate means a measure of value. Is it valuable to you as a consumer, right? So that's the banking system. The banking system is dependent. What does it mean to be dependent? It means that you need it. So the banking system needs fair and accurate what? Credit reporting. And we're not even supposed to be covering this, but let me show y'all something about these banks real quick. So I just want to show y'all the power of these banks. So look at this law real quick. 12 USC 1431. Can y'all see that? 12 USC 1431. We're not even supposed to cover Title 12, but we're gonna cover it real quick. So I want y'all to look at the very first word right here. It says borrowing. Banks are borrowers. This goes into the fact that you are the original creditor. You originated that credit. We're not going to break it down too much because we're going to have a separate class on TILA, Truth in Lending Act. But I want y'all to understand that you guys are the consumer. You're the most powerful piece on the chessboard. You guys originated a credit. So I really just need y'all to understand that banks are borrowers. Banks are borrowers. Banks are borrowers. Write that down. Banks are borrowers. You originated a credit and then they loan you something that was originally your own credit. So just really understand that these banks aren't as powerful as you think they are. I believe I dropped a podcast episode on that, but yeah, I just want y'all to understand that. So let's go back to it. The banking system, right? These banks, their system is dependent upon fair and accurate credit reporting. But what is the definition of credit? A good habit I want y'all to have when it comes to reading these laws, when you see a link like this, click it, just click it. So it says credit. Credit and creditor. The terms credit and creditor have the same meanings as in section 1691A of this title. Okay, so if I'm reading the law, I'm gonna be like, okay, I see 1691A of this title. Let me go to 1691. Let me see what it's talking about, right? So I'm gonna go to 15 USC 1691. Or we said 1691A. So 1691A, right? Are y'all following? Am I going too quick? Y'all let me know below if y'all following, right? So we're looking at the term credit, and this is in D. So the term credit means the right granted by a creditor to a debtor to defer payment of debt or to incur debts and defer its payment or to purchase property or services and defer payment therefore. What does all that even mean? So credit basically just means that you have a right granted and you're deferring payment. But the most important part I want y'all to really understand from that definition is right. Credit is a right. Credit is your right. Credit is my right. It's your right. Somebody can't take something that's your right from you. So how are they going to tell you you could be denied from something? That goes into adverse action. I dropped a podcast episode on it. Y'all can go listen to that if y'all want. But I want y'all to understand that credit is your right. Credit is your right. That's the main thing I want y'all to understand from that. So we said the term credit means the right granted, but it says by a creditor. What did I tell y'all earlier? When you see a hyperlink like this, just click on it, right? The term creditor, let me go back. So the term creditor is just right after, right? So the term creditor means any person who regularly extends, renews, or continues credit. I'm gonna just stop there. We're not even gonna read the whole thing because we're gonna get back to the FCRA, but you see right here, any person, right? So let me click on person because I want to know what that means too. I think it's right after. So yeah, the term person means a natural person, a corporation, or a government or governmental subdivision or agency, trust, estate, partnership, cooperative, or association. So you can get in a rabbit hole reading these definitions. I just want y'all to have these best practices of constantly looking to figure out what you're reading. So we see person means a natural person here, right? Natural person just means that you were born naturally from your parents. You have a mom, you have a dad, they created you. That's what natural person means. A corporation can be the fact of you have a bill, you see your name in all capital letters. A corporation can be, Experian and all those people, right? So just really understand it's a language of the law. And there's different definitions per section. So when it comes to like consumer is defined as an adjective in the Truth in Lending Act. Consumer, we're going to look at the definition of consumer here in the Fair Credit Reporting Act, but consumer means just an individual in the Fair Credit Reporting Act. So you see that there are different definitions of the same word. This is why you got to understand that the language is a law. That's the main thing I want y'all to understand. Let me know how y'all feeling. Am I going too quick or y'all following? Am I going too quick or y'all following? So we're going to go back to the Fair Credit Reporting Act. We're going to go back to the Fair Credit Reporting Act. Let me know how y'all feeling. Y'all good? Y'all good? Y'all good? Y'all good? So we were talking about the banking system, right? We only went through the very first sentence, right? So the banking system is dependent upon fair and accurate credit reporting, right? So we finished that sentence. We recognize that credit means the right granted. Credit is your right, remember? And an accuracy is a measure of value. And then fairness, something that's fair means someone doesn't have an unjust advantage over somebody. So just really understand the language, understand these definitions. If you need a purchase, if I'm going too quick, definitely recommend you purchase a replay if you didn't already, and then just break it down piece by piece. All right, let's go to sentence number 2. Inaccurate. Before we move forward, accurate means what? A measure of value. So something that's inaccurate means it's not valuable to you as a consumer, right? It's not valuable to you as a consumer. So inaccurate, something that's not valuable to you. Credit, you're right. Something that's not valuable to you, you're right. Reports directly impair the efficiency of the banking system, and unfair credit reporting methods undermine the public confidence, which is essential to the continued functioning of the banking system. There's a lot said right there, right? So inaccurate means something that's not of value to you. Credit, the right, directly impairs the efficiency of the banking system. We already said the banking system is you doing business with Chase, Bank of America, all that, right? When you're applying, you're doing everything you got to do because you are, you're the consumer, you're the most powerful piece on the chessboard. So when you have something that's inaccurate on your credit report, something that's not of value to you, you determine that it directly impairs. What does impair mean? Diminishes the value. It impairs the efficiency. What is something that's efficient? Something that's working, right? Of the banking system. And unfair. What does unfair mean? We said fair means having not having an unjust advantage over somebody. So unfair means having an unjust advantage over somebody. And unfair credit reporting methods undermine. What does undermine mean? Diminish the value. Undermine the public confidence. Public confidence is us being confident to do business with Bank of America, Chase, Navy Federal Credit Union, all these people, right? Undermines the public confidence, which is essential. What is something that's essential? Something that's necessary. Essential to the continued functioning of the banking system. What does it mean to function, to work? So basically what they're saying is that Congress found out that there was unfair practices when it comes to credit reporting, and they understood the fact that we are the most powerful people, the consumers. So if we don't want to do business with them, it's not going to work. That's what you need to get from number 1. I want to really break it down so y'all really understand it. So when y'all doing y'all disputes, you understand what you're looking at. Let's go to number 2. An elaborate mechanism. Let's pause right there. So Congress is being very disrespectful right here. They said an elaborate mechanism. What is an elaborate mechanism? An elaborate mechanism basically just means that Congress is saying that these consumer reporting agencies, meaning Experian, TransUnion, Equifax, they appear to be bigger than what they actually are. They appear to be bigger than what they actually are. If you call someone an elaborate mechanism, you're basically saying that they're trying to be bigger than what they are. An elaborate mechanism has been developed for investigating and evaluating the credit worthiness. What do we say credit is? You're right? So an elaborate mechanism has been developed for investigating and evaluating your right worthiness. Your right, standing. Your right, capacity, character, and general reputation of consumers. How can somebody evaluate you on something that's your right? That's basically what Congress is saying. They're calling them an elaborate mechanism. These people are pretending to be bigger than what they are. And they're evaluating on you on something that's your right. That doesn't even make sense. That's what y'all got to really understand when you're going through the FCRA. And then we see here the term consumers, right? What did I say earlier? Consumers is defined differently in different sections. I said the FCRA means what? An individual, right? In the Truth in Lending Act, consumer is defined as an adjective. In the FDCPA, or Fair Debt Collection Practices Act, 15 USC 1692 is defined as any natural person that has an obligation or an alleged obligation to pay a debt. So this is just more evidence that the same word can be used and defined in different sections. So you got to really understand where you're at. On top of that too, the Truth in Lending Act is for credit. The Fair Credit Reporting Act is for credit reporting. So really understand the difference. Everything is a language. I really want y'all to remember that and understand that. So an elaborate mechanism has been developed and, for judging the reputation of consumers. You and I are consumers. So let's go to number 3, consumer reporting agencies. What is a consumer reporting agency? Experian, TransUnion, Equifax. A lot of people be like, oh, they're bureaus. They're not bureaus. The only bureau is the Consumer Financial Protection Bureau, the CFPB. We're going to go over them a little bit today. I'm going to show y'all some examples and things like that. So consumer reporting agencies have assumed a vital role in assembling and evaluating consumer credit and other information on consumers. Consumer reporting agencies have assumed. What does it mean to assume something? They've assumed a vital role. They've assumed a vital role, meaning that the role wasn't given to them. They're just assuming that they're it. If I assume I can fly, does that mean I can fly? That don't mean I can fly. I just made an assumption I can fly. If I assume that I'm the president of the United States, am I the president? I'm not the president of the United States. I just made an assumption. An assumption isn't always true. So that's basically what Congress is saying right here. They said Experian, TransUnion, and Equifax, they've assumed a vital role. What does it mean for something to be vital? It's a life or death situation. They've assumed a role that is life or death because the banking system, this whole corporation is dependent upon us, the consumers. A vital role in assembling and evaluating consumer credit and other information on consumers. So that's what they're saying right there. Number 4, this is the last one we're going to cover, and then we're going to go into the definition section. So number 4, there is a need to ensure that consumer reporting agencies exercise their grave responsibilities with fairness, impartiality, and a respect for the consumer's right to privacy. There's gold right here in what we're looking at. So number 4, there's a need to ensure that consumer reporting agencies, so Equifax, TransUnion, and Experian, there's a need to ensure that Experian and them exercise their grave responsibilities. What does grave responsibility mean? Again, it's a life or death situation. Their grave responsibilities with fairness. We defined fairness earlier, right? Fair means not having an unjust advantage over somebody. Fairness, impartiality, same thing. And a respect for the consumer's right to privacy. That's gold right there. You, as a federally protected consumer, you have a right to privacy. So we're going to get into, as far as like the weapons I would use when it comes to issuing your demand and your dispute letters, but there's gold right here. So a lot of times y'all have heard me on the podcast or on social media, I'll be like 15 USC 1681B number 2 talks about written accordance of the consumer. But one hack you could do, you could literally just start right here in the congressional findings. You could quote 15 USC 1681 A4. A4 says, I as a consumer have a right to privacy. So by them publishing information, a collection, a medical bill, that's a violation, right? So you could use that as ammo when it comes to your dispute letters. Before we move forward, any questions on this page? Let me know how y'all feeling. Are y'all taking notes? Are y'all getting value? Let me know below. Let me know below. Participate. Y'all sleeping? Let me know how y'all feeling. Y'all good? Let me know. Let me know if y'all good. Let me know if y'all good. Can y'all hear me? Let me know if y'all good. Let me know if y'all not good. Let me know. Let me know how y'all feeling. Type down below before I continue. Let me know if y'all good. Y'all good? That was a mouthful. Let me know if y'all got any questions about this section so far. Any questions? Any questions? Let me know how y'all feeling. Okay, good. Y'all ready to move forward? All right, we're gonna go to the definition section. All right, so 15 USC 1681A, definitions. Definitions, rules of construction. So we're gonna go over the main definitions that I think you should know, and then we'll move forward from there. So basically, the term person means any individual, partnership, corporation, trust, estate, cooperative, association, government or governmental subdivision or agency or other entity. The term person means any individual. What does any mean? Any means no restriction. When it comes to law, you got to understand that any means no restriction. There's no restriction to what we're talking about. That's why I want y'all to understand. Any individual, right? Person means any individual. So any individual can be you. Any corporation can be Experian, TransUnion, Equifax. Y'all got to really understand the definitions when it comes to you know, what we're talking about. The term consumer means an individual. Remember, I said consumer means different in different sections. So really understand what you're reading when you want to construct your demand. So consumer report. The term consumer report means any written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's credit worthiness, credit standing, etc. Right? The main thing I want y'all to understand right there is your consumer report is basically like your credit report. So really understand that too. And then what I want y'all to really understand is the exclusion section. So if you see exclusions right here, we're going to read the exclusion section and look at one of them. So except as provided in paragraph 3, the term consumer report does not include, last time I checked, it does not include means it's not supposed to be included. So the term consumer report does not include, right? Does not include. It does not include a report containing information solely as to transactions or experiences between the consumer and the person making the report. Remember its definitions. Between the consumer and the person making the report. So a lot of times when you're constructing your argument or your demand, your letter, you want to look at 15 USC 1681A 2AI. You want to use this section right here, 2AI. You want to literally copy it and paste it in your template letter and be like, oh, you know, it's a violation because your transactions or experiences aren't supposed to be included in your consumer report. What is a transaction or experience? An experience is a fact that you took out a credit card with Chase. Why is it being reported to Experian, TransUnion, and Equifax when you have a right to privacy as a consumer? So that's an experience. The fact you apply for something, you have an inquiry, a hard inquiry, that's an experience. That's not supposed to be included on your consumer report. So that's a violation right there. So in your very first letter, you can use 15 USC 1681A 2AI in your dispute, and that can help you move forward as far as, you know, your argument. So keep that in mind. All right, so that's 2AI. I want y'all to realize that. And then B. So 15 USC 1681A 2B. Remember, we're still in the exclusion section. So it means what's supposed to not be included in a consumer report, right? So any, when you see any, the word any means no restriction. Any authorization, or when you see the word or in law, it means you can choose either side you want to be on. Any authorization or approval of a specific extension of credit directly or indirectly by the issuer of a credit card or similar device. So when it comes to credit card, the term credit card has the same meaning as in section 1602 of this title. So that's truth in lending. We're not supposed to be focused too much on truth in lending, but I just want to show y'all, you know, the definition section. I want y'all to be in a habit of going to these sections when you see a new word and just read what it says. So 1602L is what a credit card is defined as. It just basically means any card, plate, coupon, book, or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. So any card, any means no restriction, like I said. Your license plate is a credit card. Your social security number is a credit card, right? That's the whole point of that. Your social security card or social security number meaning that was what you used in a transaction when you're able to get that credit. That's what they're talking about in the exclusion section. Any authorization or approval of a specific extension of credit directly or indirectly by the issuer of a credit card or similar device. What they mean right there is that when you use your social security number, which is an open-end credit plan, to go ahead and apply for something, when that information was reported to your report, whether in the form of an account, inquiry, or whatever, that's not supposed to be included on your credit report. So when you see people using the law to get negative items deleted, they understand this. 1681A to B is part of the exclusion section. So I want y'all to use that as well. So write this down, 15 USC 1681A to AI, which talks about transactions and experiences, and then 15 USC 1681A to B, which talks about authorization or approval of a specific extension of credit. And that's basically the use of your credit card or social security number. So yeah, just keep that in mind. I believe that was all I wanted y'all to know on this section. You guys know the term consumer reporting agency. Okay, let's look at the term file real quick before we continue. The term file, when used in connection with information on any consumer, means all of the information on that consumer recorded and retained by a consumer reporting agency, regardless of how the information is stored. The reason why I want y'all to understand file is that there's a difference between your credit report and credit file. You can send a letter to Experian, TransUnion, Equifax, and be like, I'm requesting my credit report. But you can also request your credit file. Your credit file has more information on you that they have on you. So really just understand that you can request your credit file, you can request your credit report. They're different things. So you got to really understand how these consumer reporting agencies are violating you, because they have a lot of information that they're reporting on you that they're not supposed to be reporting on you. I think that was all I need y'all to understand in this section. Yeah, that was all I need y'all to understand in this section. So the next law we were gonna go to, I think it was it's B, 1681B. So let's see if they'll allow me to move forward. Let me know how y'all feel in the comments. Y'all good? Y'all following? Okay, they starting that nonsense now. So I gotta go over here. So y'all good? Y'all following me? Any questions? Let me know if y'all good. Let me know if y'all good. If y'all following me, y'all sleeping, let me know. Let me know in the comments below. All right, so 1681B, permissible purposes of consumer reports, right? Permissible purposes of consumer reports. So when I said we're going through sections, I just want y'all to go through the main things I want y'all to know. The main sections I want y'all to know. So permissible purposes of consumer reports. Remember, your consumer report is your credit report. So the main section I want y'all to know is literally right here. Subject to subsection C, any consumer reporting agency may furnish a consumer report under the following circumstances and no other, in accordance with the written instructions of the consumer to whom it relates. What does that mean? It means that they cannot publish a consumer report unless they get your written instructions. Did you give Experian written instructions to publish that inquiry that you got from applying to a Bank of America credit card? The answer is no. Did you give them written instructions to publish, that negative account, those late payments? The answer is no. So that's a law that you can use as far as your weapons too, when it comes to disputing this negative information or demanding your information be deleted from your consumer report. So that's one thing I want y'all to realize. That's all I want y'all to take from that section. 1681B number 2, it just says that they have to have your written instructions to publish anything, to furnish anything on your consumer report. So keep that in mind. So when you understand that, basically anything can be removed from your consumer report. You as a consumer, you have a power to understand what needs to be reported, what doesn't need to be reported, because you have a right to privacy. Remember that. All right, so now I want to go to 1681C-2, which is the block of information resulting from identity theft. Y'all good? Let me know below how y'all feeling. Participate. Let me know how y'all feeling. Let me know how y'all feeling. Let me get a water break before we continue. We get a water break. Y'all following or y'all sleeping? If y'all sleeping, just let me know. Well, if y'all sleeping, y'all gonna be sleeping. All right, 1681B. Yeah, it's 1681B number 2. Oh, you said go back. It's 1681B number 2. 1681B2. I believe you purchased the recording. So yeah, you can just watch the recording. Go back at 1681B number 2. Y'all good? Are we gonna continue? So 1681C-2, block of information resulting from identity theft. This is an important section. I need y'all to really understand. A lot of y'all be DMing me about, FTC reports and inquiries. So you want to really pay attention here. So block is what I need y'all to understand. Except as otherwise provided in this section. A consumer reporting agency, what is that? Experian, Equifax, TransUnion. A consumer reporting agency shall block the reporting of any information. What did I say any means? No restriction. Any information in the file. What did I say file means? Or what did the law say file means? It's different from your credit report. Your file has more information on you. Any information in the file of a consumer. What is a consumer? An individual. That the consumer identifies as information that resulted from an alleged. What does an alleged mean? Something that possibly could have happened. Identity theft. Identity theft based off of the law means no consent. Did you give them consent to publish that information, publish that inquiry? The answer is no. Not later than 4 business days after the date of receipt by such agency of appropriate proof of the identity of the consumer, which is what you submit with an FTC report, a copy of an identity theft report, which is the FTC report, the identification of such information by the consumer. So the account you want to remove, the inquiry you want to remove, whatever. A statement by the consumer that the information is not information relating to any transaction by the consumer. So, your personal statement section when you write an FTC report. So I want y'all to have block of information in y'all tool belt because of the fact that it's an important section. And it says right here, I want y'all to really realize not later than 4 business days. How can we calculate that they have to, delete the information not later than 4 business days? We send a certified mail. When you send something certified mail, they have to sign that they received it. So if they don't delete those inquiries that you submitted an FTC report for, or those accounts that you submitted an FTC report for, you've already trapped them in a violation. And then we're going to go to the section later on in terms of what you can use for violation. 1681N, 1681O, you have a couple options in the FCRA. So 1681C-2, block of information resulting from identity theft. I just want y'all to not be scared about identity theft because from a law standpoint, it means no consent. You didn't give them consent to publish information. And then what's important too is an alleged identity theft. Congress is giving you power here. Even if it wasn't identity theft, it's alleged identity theft. I can't tell you what's an alleged identity theft. Me personally, if I go apply for something tonight, let's say I go apply for a credit card with Navy Federal tonight, I get an inquiry on my TransUnion consumer report. If I want to remove the inquiry, that's an alleged identity theft, right? I know I did it, but that's an alleged identity theft. So y'all got to really understand the language that Congress is throwing you. Congress is giving y'all, they're throwing y'all an alley-oop. You just got to dunk it. You just got to understand the language. So really understand that. And that's going to help you with your demands. So I encourage y'all, if all of this is a little bit fast for you, just watch the replay and then you'll be able to master it and master your deletions. So really understand, not later than 4 business days. If it's a 5th business day, bring them to 1681C-2. Let them know that, right? When I was getting cars for Turo, y'all know I do cars for Turo, and I was getting a lot of inquiries because I had financing through Bank of America for business, but then I was at a place where I had to get it in my personal name. So the Bank of America business auto loan approval that I had didn't work for that particular situation. So I had to run, the credit or whatever, but I already knew I could remove the inquiry. So I just let them, because I like to test out different things. So once that happened, I submitted a FTC identity theft report. I understood the block of information. And, I called them once they received it. I literally read the law to them. And luckily for them, they didn't do a violation because it was gone within the 4 business days. But sometimes it takes breaking down the law to these people to let them know, what it is. So really just, put this in your tool belt and that will help you move forward. What was the next law I wanted y'all to understand? C-2. Okay, yeah, we're going to the remedy section. Someone asked earlier, are we covering remedy tonight? We're not covering remedy, but we're gonna go over the section you can use. because I don't want to overflow y'all with information, and we can do a separate class on remedy. So we need debt collectors and things like that. We're gonna save all that for the mentorship though. But you know, just keep that in mind. All right, so 15 USC 1681N, civil liability for willful noncompliance. Before I continue, any questions? That's me wanting to take a water break. I'm talking like crazy. Any questions? All right, let's continue because we got some other things we got to cover. I don't want to keep y'all here all night. 1681N, civil liability for willful noncompliance. Willful noncompliance, what does that mean? You're willfully not compliant. So in general, this is what we're going to read real quick. Any person, remember what we said person means earlier? It could be a corporation, it could be an individual, it could be whatever. When we're looking at person, we're looking at Experian, we're looking at Bank of America, we're looking at the people that violated us. Any person, any means no restriction, remember that. Any person who willfully fails to comply with any requirement imposed under this subchapter with respect to any consumer is liable to that consumer in an amount equal to the sum of what? Any actual damages. So A1A is your sauce. B has some even more sauce. But A1A, any actual damages sustained by the consumer as a result of the failure or damages of not less than $100 and not more than $1,000. So in A1A, they're saying the damages that come to you can't be more than $1,000. Why do you think Congress said that? You got to read between the lines. The reason why Congress put that there is because they understand that you could be violated way more than $1,000. Let me give y'all a scenario. Let's say I'm in a situation where I have a late payment. Let's say I have a late payment and it stopped me from getting an approval for a house. Is any house gonna be just $1,000? That damage is gonna be way more than $1,000. What if I lost out on $500,000 house? So Congress, by putting that A section, they understand, they limited, the damage because they understand the fact that you're gonna sustain damages that are greater than $1,000. What if I'm sleeping at night and I'm just like, dang, I got a denial. And I have mental damages, I have mental anguish. I'm scared to see what's on my consumer report. Mental damages are gonna be way worth more than $1,000. So just really keep that in mind and read between the lines in the civil liability sections. So let's go to B though. B is even more sauce. So in the case of liability of a natural person for obtaining, okay, let's go back to what it said earlier. Any person who willfully fails to comply, right? In the case of liability of a natural person for obtaining a consumer report under false pretenses or knowingly without a permissible purpose, actual damages sustained by a consumer as a result of the failure or $1,000, whichever is greater. So when it comes to the civil liability section for willful noncompliance, you want to use section B. Why do I say that? Let's go back to my example with the house. They said it's going to be a damage of $1,000, but whichever is greater, right? If I lost out on a $500,000 house, is that not greater than $1,000? So you got to understand the language that Congress is saying. Congress tossed you to alley-oop is just for you to understand what's going on. So when you are talking about civil liability section, let's say you're not getting, your desired result as far as the deletions. Because number one, I want y'all to focus on deletions. Focus on deletions, and then you can go for the money after. Focus on deletions first. Master the deletions. So let's say they don't want to remove an inquiry, right? You're going to bring them to the civil liability section. You could use A and be like, oh, it's going to be $1,000. Or you could even use B and be like, this inquiry stopped me from getting an approval. Now I'm on the streets or something. I wasn't able to get my house or something like that, right? Just really point them and let them know that whichever is greater portion of it, and break it down to them. You got to break it down to them because most people don't understand these laws or what they even mean. So you got to really break it down in layman's terms. And that's the whole purpose of this introduction class. We're going to have a separate class, like I said, as far as remedy. I have a client right now that's being sued. But yeah, we're gonna go through that and just the process of how I would go about that personally. So yeah, that's 1681N, civil liability section. Have this in your tool belt. and understand that the civil liability section in the Truth in Lending Act is 15 USC 1640. Civil liability section in the Fair Debt Collection Practices Act is 15 USC 1692K. So both of those sections, Fair Credit Reporting Act or Fair Debt Collection Practices Act and Truth in Lending Act, both of those sections have one apiece, civil liability section. But the Fair Credit Reporting Act is special because they have two. They have 1681N, they have 1681O. Let's see if they'll let me go right away to it. Okay, yeah. So civil liability for negligent noncompliance. So not only can you hit them for willful noncompliance, you can hit them for negligent noncompliance. You're being negligent if you're not deleting that item I told you to delete after I proved to you that it's inaccurate. What is inaccurate? Something that is not of value to me as a consumer. Remember, accuracy means a measure of value. We're not talking about correct. We're not talking about something that's right. We're talking about Black Law's dictionary. Accuracy is a measure of value. Is it valuable to you as a consumer? Is it valuable to have an inquiry that's holding me back from getting what I need to get? That's a question you need to ask yourself. So any person who is negligent in failing to comply with any requirement imposed under this subchapter with respect to any consumer is liable to that consumer in an amount equal to the sum of, listen, any actual damage sustained by the consumer as a result of the failure, right? So any actual damages. So again, they're just reiterating the fact that you can get these furnishers of the information, meaning like Bank of America, whoever put the inquiry, or these CRAs, consumer reporting agencies, you can get them in trouble based off of these sections. If they're failing to delete the information you tell them to delete. So second one is important too. In the case of any successful action to enforce any liability under this section, the cost of the action together with reasonable attorney's fees as determined by the court. So I wouldn't necessarily use number 2. I just want to point it out to you because it says in the case of any successful action. Why is that different from number 1? Number 2 is different from number 1 because number 2 has to be a successful action. So you have to be successful in, your debate with the court. But number 1 says any actual damages. You as a consumer, you're always successful because you define actual damages, right? So really keep that in mind. So I just want y'all to understand when it comes to number 2, it has to be a successful action. Not to say that it can't be a successful action, but to me, I like to go with what's easy. What's easy is I could just say, oh, I sustained mental damages. I wasn't able to get an approval for what I got. But with number 2, it has to be successful action. Successful action meaning that's determined based off of someone else's perception. You don't want to be in a situation where it's determined based off of someone else's perception. So yeah, keep that in mind. We're gonna go over one more law, and then we're gonna go to the next section. I believe that is S2. Let me make sure on my list right here. Yeah, S-2. Okay, so this one is some real sauce too. So this is the last law, and then we're gonna move forward. So 1681 S-2, 15 USC 1681 S-2, responsibilities of furnishers of information to consumer reporting agencies. We got to break that down first. Responsibilities of furnishers of information to consumer reporting agencies. So some people might read that and they think, okay, they're talking about Experian, they're talking about Equifax, they're talking about TransUnion. You would be half correct, right? So furnishers of information, that means Citibank, that means Bank of America, that means the people that actually put that information on your report. I had a call with a client, and I know some of y'all that, well, I think most of y'all follow me on social media. You've seen me say like I'm not doing consultations. So the consultation was with someone in my cat friend circle. So my cat friend circle, if you don't know, is my private IG community where I'd be giving out, weekly game and things like that. So that's why we had a consultation. It's not like I was just having a consultation to have a consultation. So I had a consultation with a client, and she was basically not knowing the fact that you can go after the furnishers of the information on your report, right? So I want y'all to understand that you don't only have to go after Experian, TransUnion, and Equifax. You can go directly to the furnishers of the information. And I would say it's even better if you go directly to the furnishers of the information, because you got to think about it. If you're in a situation where you have an account and that came from like Bank of America, or you have an inquiry and that came from Bank of America, you run directly to Experian, TransUnion, and Equifax. It's like, go take it with the person you have the problem with first. You know what I'm saying? So really understand. You can send these demands to the furnishers. You can send the demands to the consumer reporting agencies. So responsibilities of furnishers of information. So responsibilities of Bank of America to consumer reporting agencies, to Experian. Responsibilities of Bank of America to Experian. So that's how you should read the report. Remember, it's a language, so just substitute different words and phrases. I hope y'all taking notes so that you can look back on your notes, study it, and make these substitutions. I've been studying this stuff for, quite some time, so I might be going a little bit quick. I might not be going as quick for some of y'all too. So, but just really take notes, and then, you'll be on your way. All right, duty of furnishers of information to provide accurate information. What do we say accurate means? A measure of value, something that's valuable to you as a consumer. So prohibition. What is for something to be prohibited? What does it mean? Let me get some participation below. For something to be prohibited, what does it mean? For something to be prohibited, what does it mean? What does prohibition mean? This is me taking a water break. Isn't allowed? Perfect. Okay, yeah. So for something to be prohibited, okay, not allowed. Yeah, exactly. So isn't allowed, not allowed, however you speak, whatever, is the same thing. So for something to be prohibited, it means it is not allowed. It is not allowed. So reporting information with actual knowledge of errors. Let's get it. So a person, we defined person earlier. I've said it multiple times, so y'all should know what a person means. So substitute a person with experience, substitute a person with Bank of America, whoever. A person isn't only you. That's a consumer. So a person shall not furnish any information relating to a consumer to any consumer reporting agency. So to Experian. If the person, so Bank of America, if Bank of America knows or has reasonable cause to believe that the information is inaccurate. There was a lot said right there. So it basically says Bank of America, Chase, whoever you have a problem with, they can't furnish any information to Experian, TransUnion, Equifax if they know that the information is inaccurate. These furnishers of the information, they have the ability to remove, this inquiry and all that stuff from reporting. So really attack the furnishers of the information. Take the problem with who you have the problem with. It doesn't always have to be Experian, TransUnion, and Equifax. You can just send to them as extra measure for a paper trail if you want, if it goes deeper than what it needs to be. So the reason why I like this section right here, and we're gonna get into it in the actual the template letter. The reason why I like this section right here is because of the fact that you got to understand this part right here. Reasonable cause. This is my favorite part. This is my favorite part in how my clients have gotten student loans deleted. I had someone with a late payment. They got it reversed back to them. So yeah, this is really the sauce on how you get these deletions. So reasonable cause to believe that the information is inaccurate. How do you make sure that they have reasonable cause to believe that the information is inaccurate? You make sure of that by your first round being you define accuracy to them, and then you let them know that therefore the information is inaccurate. So what does this entail? This entails breaking down the law to them. So then you quote 15 USC 1681 S-2 A1A, and you show them, look, I sent you in my last letter, the fact of the matter is that this information was inaccurate. And now I'm sending you the second round letter, S-2, to let you know that you have reasonable cause to believe that the information is inaccurate. They have reasonable cause because you let them know in your initial letter that this information is inaccurate. And they can't say that they didn't receive your letter because you sent it certified mail and then you got that green return receipt. You see how this is a system? You want to trap them, basically. So I want y'all to have the mindset of, I don't necessarily need to get my result in the first round or whatever. But to be honest, I had a client, she simply sent a debt validation letter and got a student loan deleted, but it doesn't always happen that way. Everybody's situation is different. But I want y'all to really understand, you want to set them up. So use 15 USC 1681 A4. Be like, oh, this is a violation of my right to privacy, so the information is inaccurate. Use 1681 B number 2. written accordance of the consumer, right? This is a violation because I didn't give you written permission. Use the exclusion section, 1681A2AI, experiences and transactions, or 1681A2B, authorization or approval, right? I gave y'all 4 sections y'all can use in your first round. And when it comes to late payments, you can use 1666B, timing of payments, or you can use 1666, go down to B, correction of billing error. That's 6 different laws y'all can use as your initial round. And then you hit them with round 2, 1681S-2, right? Y'all got to really understand that. This is the language of the law. So like I said, if I'm going a little bit too fast for you, just play the replay and y'all will be able to really understand it. Just study it every day and y'all will understand it. So yeah, this is 1681S-2. I think that was all the laws I wanted to cover. Any questions so far before we move forward? We're going to move to a deletion letter example, and I'm going to break down more of what I was talking about as far as, the rounds. I think most of y'all at least bought one template letter. So what we're going to look at should be familiar to y'all. Let me know if y'all got any questions. Let me know. How y'all feeling so far? Are y'all following? Let me know how y'all feeling so far. If y'all following, if y'all good, let me know if y'all taking notes. Let me know if y'all gonna watch a replay. Let me know. Let me know if y'all sleeping. If you can, let me know. Let me know. Let me know how y'all feeling, or if y'all got any immediate questions. Let me know. Yeah, we're about to look at the template letters. Where can you purchase the template letters? So when you purchase the class, basically there were order bumps when you scroll down and they had deletion letters. I don't know, maybe you scroll past it. But if you go to catactisllc.com, we also have deletion letters, so you can go ahead and get deletion letters over there. And that should help. How do I remove a late payment? That is the only thing holding me back. Okay, so with a late payment, we're gonna go over the template letter, and I'll give you an example. But what I've seen, like I said earlier, one of my clients, she literally sent a debt validation letter, or I think that was for a student loan. It might have been for a student loan. She sent a debt validation letter and got it, removed. So just really understand everybody's situation is different. But if you figure out that, you can't do it by yourself, you can go to catactisllc.com. You can book a free credit repair consultation. We will get you handled and, go on about that. Feeling good? Okay, good. Got a lot of notes. Okay, good. That's perfect. I hope you study the notes. And I remember you purchased the replay as well. And I think you might have got the bundle. Did you get the bundle? I think you got the bundle too. Okay, so we're gonna look at the example. Majority of y'all are doing to hosts and panelists. I hope y'all know that you're not typing to everybody, which is fine, but ain't nothing wrong with that. I just want to let y'all know. Okay, let me get out of here. Okay, so the deletion letter example. So a couple of y'all already got this, but this is basically how I would construct an example deletion letter. So now that we understand the law, we understand the language of the law, we don't want to make it too deep. We just want to send them a simple letter to get this deletion letter removed. Do I always have to send an affidavit of truth? Okay, we're gonna get into affidavit of truth, but you don't necessarily always have to send an affidavit of truth. I'm gonna cover that in a little bit. So you're getting ahead of me. Relax. No, I'm playing. All right, so first of all, you want to put your name, your address, all that, and then you're gonna put the date, and then you're addressing to Experian or the furnisher of the information, whoever you want to address. So what I would put is to whom it may concern, and then I would put, I received a copy of my insert your report, whatever it is. It could be Experian, TransUnion, Equifax, whatever you got a problem with. And I noticed you're gonna insert the negative item that needs a deletion. I noticed this that needs to be corrected. They are as follows. Put down the account number, put down the account. Very, very basic information. You're literally letting them know. I noticed something on my report. This needs to be deleted. and we're making a demand. We're not making a request. This is a demand. I want y'all to have that mindset. So then you immediately let them know your company is in violation of the Fair Credit Reporting Act, otherwise known as 15 U.S.C. 1681. One thing I want y'all to know too, with template letters, I don't want y'all to just copy what it says verbatim. Plug in your own words. Template letters are meant to be a guide in terms of how you should do it. And I used to actually not even sell template letters just because I was, worried that people would just copy it verbatim. And I had these template letters for a while, but it's just that when I was on consultation calls, I would just tell people how I would, construct it. But y'all getting the information as far as looking at it here. And I know some of y'all purchased them already. So I just want y'all to be responsible with how you actually use the template letters. So let them know they violated the FCRA. Then what the best practice that I like to do is literally copy the law and break it down to them. So this is a round 2 letter that we have as an example. You see it's S-2, responsibilities of furnishers of information to consumer reporting agencies. I would say the law clearly states, and then publish it, right? Copy and paste it. Does that not look familiar? We just talked about prohibition. Don't make it too deep. So then I'll explain it to them, right? So like I said, this is an example of a round 2 letter. So let's say we sent our first round, we sent a debt validation, we sent, just for the sake of example, we used 1681B number 2 in our example for round 1, saying that our late payment needed to be removed because we didn't give them written instruction. Or we use 2AI because that was an experience or transaction between us and, the person. So this is round 2, like I said. So clearly, prohibition means something that is not allowed. This law says a person, you in this case, shall not furnish any information relating to a consumer to any consumer reporting agency if the person knows or has reasonable cause to believe that information is inaccurate. So you're just letting them know what they're doing. You want to coach them through, the law. Somebody asked, why are there highlights? Okay, I should have said that too. So as far as the highlighting, the reason why I'm highlighting is when you're sending dispute letters to Experian, TransUnion, and Equifax, there's something called the eOscar system. The eOscar system means that when your dispute or your demand is sent over to them, they have an automated system, an automated system that scans your letter. And our whole goal is to get our dispute to a human being. How can we get our dispute to a human being as best as possible? What we could do, we could throw them off by highlighting random phrases and words and things like that. So that's really the reason why I'm putting the highlights, because I want y'all to bypass the eOscar system, get directly to Experian, TransUnion, or Equifax, or whoever you're dealing with. Because you got to realize it's billions of consumers. They're not going to be reading your dispute all the time. But most people don't understand the fact that there is an eOscar system. So most people are going to get that automatic thing of, oh, this information is verified. Whole time it wasn't even a human being that looked at your letter. So you want to really think about what are tactics, consumer ammunition tactics, that we could use to bypass the eOscar system. So that's why there's a highlight. That was a great question. All right, so then you walk them through it. Accuracy is defined as a measure of value. We talked about that. Having this information on my credit report is not of value to me, so therefore it is inaccurate, and I demand it to be deleted from all consumer reporting agencies. So let them know. Let's look at reasonable cause to believe that the information is inaccurate, right? Did we not just go over this in the presentation? So you can literally replay the presentation if you purchase a replay, and just kind of, take my position. The way I'm breaking it down to y'all, break it down to them. So look, I clearly showed you in my previous letter. Remember, this is round 2 example. In my previous letter that you received via certified mail. This is why we send certified mail, because they can't lie. Oh, I didn't receive it. They have to sign that they received it. That you have reasonable cause to believe that the information is inaccurate by me clearly defining accurate and what it means to be inaccurate and pointing out the laws that you violated. Therefore, the information being inaccurate, right? So this is just an example. And then while we're at it, right? While we're at it, pursuant to 15 U.S.C. 1681A4, like I told y'all, y'all can go as simple as just going to the congressional findings. This is where it states Congress makes the findings. There's a need to ensure that consumer reporting agencies exercise their great responsibilities with fairness, right? But the most important part is the respect for the consumer's right to privacy. So once you say that, remember, a lot of these people, they don't know what the law is. They dumb, so you got to break it down to them. So clearly my right to privacy as a consumer has been violated by publicly reporting this information when I never gave your organization permission to report my information. Right, that's a mouthful. Keep that in mind. All right, so, remember, this is a round 2 letter. So now what you could say is, you don't got to say, remember, this is a guide. This is getting out of hand. So if you continue failing to follow the law after I've clearly showed you that you have reasonable cause to believe that the information isn't, in fact, inaccurate, this matter will result in legal actions being taken against your company, and I will be seeking $1,000 for violation of the following. So that would be 15 USC 1681N, civil liability for willful noncompliance, 15 USC 1681O, civil liability for negligent noncompliance. So they're willfully non-complying and they're being negligent in their noncompliance as far as them not removing the late payment that I am demanding that they remove, because I've showed them and proved to them that they have reasonable cause to believe that the information is inaccurate. Therefore, it must be deleted from all consumer reporting agencies. That is what is going on in this whole scenario. And furthermore, you could even copy and paste 1681N. I didn't do that in this example, but it's something that y'all could do just to show them. Remember, I said earlier, any actual damages, any damages could be your mental health, damages could be you getting denied, damages could be anything. And you just point out the fact that they're in violation of $1,000 per violation. Remember, I said in a separate class, we're gonna walk through the $1,000 per violation. I saw somebody ask, how do we get the money from them? We're going to walk through that in a different class, but I want y'all to really, really focus on getting these deletions first. Let's focus on the deletions and then we'll get the money after. All right, so then what I would do to end the letter, it doesn't matter how much time you give them. You can give them 30 days or whatever, but I just put an example. You could put, you have 14 days to respond upon receipt of this letter to delete the reference items and send me a new letter. Notify me that the information has been deleted from all consumer reporting agencies, and also mail me a copy of my report, right? So you as a consumer, remember, you're giving them instructions. So when it comes to like debt, when it comes to Fair Debt Collection Practices Act, we're not talking about that today, but just for the sake of my example, you could literally send them a cease and desist and tell them, when it comes to like a collection or something, you could tell them to stop contacting you because you're trapping them in a situation. You tell them to stop contacting you. If they continue contacting you, that is a violation because you have a right to privacy. I've shown you like 18 times you have a right to privacy. So keep that in mind. And then you'll end it with best regards and your name. And a best practice is you want to always have a copy of your ID and a utility bill showing your proof of your address, your current address, right? So you want to also mail that with your demand, because a lot of times these consumer reporting agencies do things that are called stalling tactics. So if you don't send your form of ID, they might be like, oh, it's not you. We're still looking into your case. We need proof of, whatever. So because they're going to do that a lot of times, just send them your identification right away. Want to give them no excuses, right, to move forward with the process, because you got to understand that credit takes time. So if we can minimize the amount of work we got to do, the better we'll be within our situation. So that's an example of how I would walk through a demand. This is how, my clients have gotten negative items deleted, and this is how you're going to get your negative items deleted. And one thing I'll say that's worth mentioning too, because I was on a consultation call too with this girl, and she was basically saying how she was tired of, sending letters after letter. Why is it not working? She got a couple of bureaus off, but I said bureaus. When we talk about the language, you know what I mean, Experian, TransUnion, Equifax. So she got a couple of the consumer reporting agencies off, but it was one of them that wouldn't budge. I want y'all to have that mindset. You got to be consistent. Not only do you have to be consistent, you got to be persistent. I had a client, she went like 7 rounds just to get an item deleted. So imagine if she was like, oh, I'm doing 5 rounds, it doesn't work. Or I did 6 rounds and it didn't work. All she needed to do was 1 more round. So when it comes to sending these letters, whether you're sending like an FTC report, one hack I'll say is you want to send the same thing you're sending and then send a new one. So let's say you send an FTC report, 14 days later, I would send a new one, but maybe 10 days later, I'd send the same one just as a reminder, just constantly be in the flow of it. I covered it on the podcast, I don't remember what episode it was, but just binge listen to the podcast and you'll hear what I meant by that as far as the FTC example. Any questions based off of the template letter? Let me know. Any questions based off of the template letter before we move on to the affidavit of truth? Any questions? Any questions? Let me know. Let me know. Let me know. I need a water break. How y'all feeling? I know most of y'all that's in here got the template letters. I know a couple people that weren't able to make it tonight also got the template letters. But let me know if y'all have any questions as far as these laws. Thank you for the information, King. This is helpful. No problem. Thank you for pulling up. Thank you for investing in yourself. Thank y'all for investing in yourselves. Okay, we're gonna move forward to the affidavit of truth example. Hopefully y'all not tired. All right, so affidavit of truth example, very simple. There are 6 parts to an affidavit of truth. This is all I want y'all to realize. So we're gonna cover the affidavit of truth, then we're gonna cover the process. And then, you know, we're gonna cover a little bit extra resources. And then if y'all got any last minute questions, we'll cover that and then we'll be out of here. So you can take a screenshot, you could do whatever you gotta do with it. But affidavit of truth, number 1, has a title. Number 2, statement of identity. Number 3, statement of truth. Number 4, statement of fact. Number 5, affiant facts. And then number 6 is a notary seal. So basically, with the title, I like to be very, very simple. So you could literally put affidavit of truth, right? Don't gotta be nothing serious. So statement of identity. Statement of identity is who you are, right? Do you have an affidavit of truth example to send us? So not technically, but I could put something in the CAT Credit University, like a template letter. That's a good question. I don't even know why I didn't have an example already in there. But I'll type a little bit here, and then y'all can use that. But I'll have a more polished example in the Credit University. That's a great question. Thank you for asking that. So statement of identity is basically who you are. So the way that I put it, I have my example here. I usually just say notice to all. I am, and then you could just say, a natural person. I am the natural person. You're the original creditor when it comes to Truth in Lending Act. That's a whole different conversation. Consumer. And then you could say, given the name, surname, let's say John Doe or something, right? So it's really just who you are. And then I would end it with, and I have been appointed and accept being the executor, both public and private, for all matters proceeding, right? So you're basically establishing who you are. Statement of identity. That's what number 2 is. So number 3 is statement of truth. So statement of truth is basically because affidavit of truth, you can't lie in it because you're under penalty of perjury. It means that it's illegal for you to lie on affidavit of truth. So with statement of truth, you're basically, you're saying that you're not going to lie. So this is how I'd write my example. Whereas I, of age of majority, give this notice to all. I make a solemn oath to the Most High under the penalty of perjury that the following are factual, or something like that, right? And a statement of fact. So statement of truth, you're basically just saying that I'm not gonna lie in this affidavit of truth. These violations are the truth, etc., right? Because it's illegal to lie in an affidavit of truth. It's illegal to lie in an affidavit of truth. It's illegal to lie in an affidavit of truth. So statement of fact, you're just literally stating a fact. You're literally stating a fact. So when we're dealing with the Fair Credit Reporting Act, we can state a fact as far as what the Fair Credit Reporting Act is intended, right? So you could literally go to quote 15 USC 1681A4. You would say like fact, the Fair Credit Reporting Act or the FCRA states that the banking system is dependent upon fair and accurate credit reporting. That's a statement of fact. It's a fact, right? That's what the Fair Credit Reporting Act states. We went over that in the congressional findings. So you could state however many facts you want. It's up to you, right? So you're just making a statement of fact. And then affiant facts. Affiant facts, and affiant is somebody that's writing an affidavit of truth. So you are the affiant. So the affiant facts, now we're getting straight to your facts, right? So when we're saying your facts, we're just talking about, let's talk about an example I did. So with the auto loan inquiries that I did, I used I included affidavit of truth with, my FTC and everything to remove those inquiries. I basically said, so this is how I do it. I put fact, affiant, which is me or you, is aware and has proof in the attachment labeled as Exhibit A that Bank of America, for example, is in violation of, and then you put whatever they violate, 15 USC 1681 A to A I, right? Which talks about the transactions or experiences, because it's not supposed to be on your report. An experience is that inquiry I got, right? Or that inquiry you got. So that's an example, and then you just list all your exhibits. So exhibit is basically proof of how you were violated, right? Because remember, you can't lie on affidavit of truth. It's a fact. So on a separate sheet of paper, I would write literally Exhibit A. I would circle it, Exhibit A, violation of 15 USC 1681 A2AI. So this is what I did when I was removing my inquiries. But I believe I used 1681 B number 2, which is written instruction of the consumer, because I didn't give them written permission to furnish those inquiries on my report, right? So you just list out all the violations that occurred. You don't have to send an affidavit of truth, but it's definitely gonna help. And then number 6, the final part is a notary seal. So every affidavit of truth has a notary, right? So the notary seal, when you get to the notary seal, you could, before you get to the notary seal, you could put thank you. I'm just going off my example. I swear to all the information provided, I do so under the penalty of perjury, that the information I so affirm to be true, correct, accurate, to the best of my ability and knowledge, so be it, right? So then you'll include like a signature. Let me scroll down. Like, why is it so low? Signature, and then, you sign it, sworn to, affirmed by, and subscribed before me on the, you insert the date. So today's what? The 30th? Day of what? January? That's when you would insert that. Shout out to Aquarius season. You feel me? Year 2022, right? We're in 2022. So you would put the date and, the month, and then you'll put the notary name, which is the person that's, the notary, and then notary signature, and then he or she will sign it, the notary, and then you'll have the actual notary seal. I have an example here. I don't know if y'all can see it. It might be. So that's a notary seal right there, right? So that's basically affidavit of truth. So you'll be publishing affidavit of truths as like extra ammo, just to point out, how they violated you. So keep that in mind. when you see an affidavit of truth, this is the real sauce on it. So with the affidavit of truth, when you go to your AFI and facts right here, right? If they don't reply line by line, disputing, saying, oh, this is false, this is false, this is false, then your affidavit of truth is considered correct, right? It's considered correct because they didn't deny it. They're supposed to deny it line by line. Let me give y'all the spoiler alert. They never, line by line say like, oh, this isn't correct, this isn't correct. In my experience from doing it, in my experience from hearing, clients do it, in my experience from hearing anybody do it, I never heard about the company going through an affidavit of truth and denying line by line. Remember, this is law. Affidavit of truth, they're supposed to deny stuff line by line. So what you're doing by submitting an affidavit of truth, submitting multiple of them, you're basically creating a paper trail. A paper trail, because in case it goes to court, if they sue you, you sue them, you have all your paperwork in order. And part of that is making copies of everything. You want to make copies of everything so that you have that paper trail and so that your argument is very, very powerful. And then, it's less likely that you even going to lose what's going on. You can go to court as a pro se litigant, which means representing yourself, and then you'll be good to go because you understand the Fair Credit Reporting Act, you understand the affidavit of truth, you understand all these laws because you're going to watch a replay. You have notes from tonight. And yeah, so any questions on affidavit of truth before we go into the process? And then we will, if y'all got any questions, then we'll close it out. Oh no, I got some resources I want to show y'all too before. Any questions on affidavit of truth? I'm gonna need the template. All right, I got y'all. I'm gonna have something in the university. I'll have my assistant edit the website once I, get like an official one. But I mean, you can literally Google an example. But if y'all want to use, something that I would use, then I'll have that in the university for y'all. How y'all feeling? Y'all good? Y'all awake? Y'all sleep? I know y'all East Coast people. Oh, it's only 8:53 for y'all out there though. So y'all shouldn't even be sleeping like that. All right, so we're gonna talk about what's it called? The process, right? So one thing I want y'all to know about the process. This is a process, not the process. My boy say you tired, low key. Okay. So I know we got people tired. I know we got some people on the West Coast. So y'all are 5:53 with me too. But some people are East Coast time. So this is a process, not the process. So everything I'm showing y'all tonight, besides the law is the law. That's what it is. But besides the law, everything else is like negotiable, right? So you don't got to follow how I did my affidavit of truth. Besides having the 6 parts, you don't got to follow this process. You don't got to follow the exact template letter. Everything is a guide. The main thing I want y'all to understand is the language of the law. A lot of people, they want to start running before they walk. You got to walk first. Walking is understanding the language of the law. Walking is getting the deletions and mastering the deletions first before we start running to try and, get excited about money, getting excited about, getting a car, 0 money down, all that, right? Getting a car, trapping them in Truth in Lending Act violations. So really understand mastering deletions first. I want y'all to be very, very confident in mastering deletions. I want y'all to be very, very confident in quoting these laws. And then we could start running. But yeah, let's continue. So number 1, this is a process. Understand the language of the law and how you are violated as a federally protected consumer. Under Title 15, Chapter 41, which includes Truth in Lending Act, Fair Credit Reporting Act, Fair Debt Collection Practices Act, you are a federally protected consumer within this United States corporation pursuant to what? 28 USC 3002. 28 USC 3002, if you write that down, you scroll down to number 15, it defines the United States as a corporation. That means the United States is about business. What is business? Doing commerce. Business is money. Business is commerce. Commerce is you applying for, Chase, you applying for Bank of America, you applying for Key Bank, you applying for all these local credit unions, all of that. So the world runs on credit. The world runs on credit reporting. So even if you're not passionate about credit, even if you're not passionate about the laws, you're doing yourself a disservice if you don't understand how it works, right? That's why I want y'all to really understand. So once you understand it and you understand how you are violated, we can go to step 2. So if it's applicable, send a debt validation letter, right? So an example is like collections. If they trying to say, oh, this is an attempt to collect debt, etc., send them a debt validation letter because they have to prove that it is your debt. We're not going to get into debt, but debt is an obligation or alleged obligation, right? Do what you will with that information. So 2.5, draft up a cease and desist notice if applicable, right? So an example is, if you have a collection or something, draft up a cease and desist, be like, stop contacting me. It's a violation of 15 USC 1692C when it comes to collecting a debt. That's a communication section because a debt collector is not supposed to communicate with you as far as the connection of a debt. So you can draft up a cease and desist letter, and that could be very, very powerful within your situation because you're coming up with a paper trail. Number 3, identify the law or laws you wish to use in your demand for your deletion. Remember, we're going after deletion first. Deletion first before we go to the money. Let's focus on one thing at a time. Deletion first, right? So an example is 15 USC 1681B number 2, written accordance of the consumer, right? You didn't give them written instruction to publish that information. Identify the law you wish to use in your demand for your deletion. Number 1, we want to get that deletion. We want to get that information deleted from all consumer reporting agencies, and then we will be happy to move on to the next step. Do you have a cease and desist template? No, but you can Google that too, or I can put something in your university as well. Dang, y'all want all the letters. You know what I'm saying? But now I got y'all. All right, so once you do all that, number 3, now we go on to number 4. Now you're gonna draft up your round 1 letter, like the template we discussed in the class. Copy and pasting the law. Walk them through the law. Walk them through how they violated you. Walk them through how the information is inaccurate because you understand the law. You understand the language, right? Even if you understood everything I said today, it's good to continue practicing, right? Because you could, let's say you're a master of the law. Let's say you consider yourself a master of the law. If you're good at basketball, if you're good at football, you obviously got to go to practice, right? This is good for me too, because I got to be on my P's and Q's understanding what the law is. So I got to break it down to y'all. So really understand. It's good to consistently, be looking at the law, and drafting up these letters are really, really going to help y'all continuing to be good with the law. All right, so number 5, paper trail. We want to make copies of everything. Then we're going to mail out certified mail and get a green return receipt. Get a green return receipt. We're going to mail out copies, mail out certified mail, and get a green return receipt. Why do we want to mail out and get a green return receipt? We want to get the green return receipt because that's proof that they received our letter, whether it is a furnisher, whether it is Experian, TransUnion, or Equifax, right? So really understand that. Once you make the copies and mail out, now what we're going to do is we're going to file a CFPB complaint. What did I say earlier? There's no such thing as a bureau besides the CFPB. The CFPB is a Consumer Financial Protection Bureau. And you got to talk to them like you're talking to these CRAs, Consumer Reporting Agencies. You got to break down the law to them like they're babies, right? So same thing with your CFPB complaint. The CFPB complaint, you got to look at it as the CFPB is like your employee. But to be honest, as times get more recent, now we're in 2022 versus 2021, when things have been working maybe a little bit better, they're catching on to different things and they're coming up with different rules. There's different regulations and things like that. So the main thing I want y'all to look at when it comes to the CFPB is you want to look at it as a paper trail for the work that you've submitted, right? Because you're building up a case. You want to look at it from the moment you've been violated to you understanding it, from the moment you send your very first demand for them to delete the information from your report. You're building up a case, and we're going to look at some past CFPB cases just to give y'all a little bit more confidence about how, some people are getting paid based off of these inaccuracies. So once you file a CFPB complaint, you can also file a BBB complaint, a Better Business Bureau complaint. Again, paper trail. You could also file an FTC report. FTC report is an identity theft report, right? So identity theft meaning no consent. So you got them inquiries, go file that FTC report. Go listen to the CAP podcast. I already walked y'all step by step on how to do all that. State Attorney General complaint. So every state, they got a state attorney. So if you just Google State Attorney General complaint, you can file a complaint. You have that under your belt as well. So Attorney General complaint, and then OCC complaint. So OCC is basically the regulators of banks, and we're going to walk through a resource as well, just to kind of help y'all as far as that. So you just want to establish a paper trail with everything. Certain things work for different people. Some people, they'll file a Better Business Bureau, and then things will get handled. Some people, Better Business Bureau won't do nothing. So it's like, it really just depends on your situation. So once you do all that, now we're going to round 2. So round 2, what are we doing? We're going to draft up a round 2 letter. We literally looked at an example of round 2 letter here in the class. So, do what you will with that information. Scroll back if you're watching the replay right now. And then you could draft up an affidavit of truth. So this process, I'm telling you right now, you don't necessarily submit an affidavit of truth in your first round, even though you can. Remember, I said this is a process, not the process. It's not the only process. It's multiple ways to skin a cat. You don't even got to use consumer law to get deletions, just that y'all are interested in, learning consumer law because consumer law is powerful. So draft up the affidavit of truth, same example we showed earlier. Again, make copies, mail out certified mail, get a green return receipt. And that same thing, file CFPB complaint, BBB, FTC, Attorney General complaint, OCC complaint, just have a paper trail of everything. Every time you file these complaints, you're going to get like an email. Sometimes you're able to print out a copy of what you filed. Make copies of all of that. All those are exhibits. All those are attempts that you made in order to get the negative information removed, right? So just really remember, all of this is a paper trail. And remember, most importantly, a lot of this stuff takes time. So be patient with the process. And then repeat until you get your desired result. Based off of this class, remember, your desired result initially should be just to get the deletion. We can go after the remedy, meaning the money for the damages later. But initially, you want to focus on the deletions. I want y'all to get comfortable with the deletions, right? You got to get comfortable with the free throws before you start, starting to shoot Hail Marys like you Steph Curry. You know what I'm saying? So really just keep that in mind. And that is the process, or a process, I mean. That's not the process. Do y'all have any questions? We're going to walk through just some final resources. And then, yeah, I want y'all to ask any questions if you do have any. It might be a lot of information. Maybe y'all just got to actually execute it. But yeah, if y'all have any questions, let me know. Can you walk through submitting an FTC complaint? Okay, I know that you're new to following me, but I literally put out a podcast episode where I did that. So just for the sake of time, everybody's time, I'm not going to do that because it's in a podcast episode. So yeah, you could definitely go back and listen to the podcast, and I have an example there of where I walk through FTC report. I think y'all might be tired. Maybe y'all not tired. I don't know, but yeah, we're gonna go through the final resources. So yeah, okay, I got a resource here that I want to go through. It's gonna be help with my bank.gov. So basically, help with my bank.gov. This is the OCC. Like I told y'all, the OCC. Oh, that my light tripping. The OCC is basically the regulator of banks, right? They regulate banks. So they regulate Chase, all them peoples. So if you don't know who regulates your bank, because maybe let's say you're not getting your desired result, I want y'all to go to help with my bank.gov. Help with my bank.gov. I want y'all to go over there so you can file a complaint. Remember, you as a consumer, you can file a complaint with anybody you want to file a complaint with, right? So this is what they say here. Before you file, try to resolve your issue directly with your bank first. But this is assuming that we already tried to, right? So now what we're going to do is we're going to file a complaint. So you can go here, file a complaint. And what I wanted to show y'all is really number 2. So number 2 says, check to make sure we regulate your bank. So if you're not sure if the OCC regulates your bank, you can go to who regulates my bank, right? So then you're going to come here to search financial institutions. So now we come to the FFIEC website, and this is just a helpful resource just to, give y'all more information on who's regulating your bank. So let's say I want to figure out Wells Fargo. right? So Wells Fargo, I want to look at National Association because I want to just look at globally who regulates. And let's say specifically have who I'm looking at. So I see right here, Office of the Comptroller of the Currency, that's OCC. So I've confirmed to myself that Wells Fargo is regulated by the OCC. But if I look down here, Wells Fargo International Banking, they're regulated by the Federal Reserve, right? So the reason why I'm showing y'all this is because if I'm going at Wells Fargo International Banking Corporation, and I think it's the OCC that's regulating them, so I submit an OCC complaint, I'm already going to the wrong target. So you got to really use this as a resource and really understand who regulates your bank. So add that to your toolbar. I want y'all to add that over there. Okay, yeah, last resource, and then we gon', if you guys have any questions, if y'all not sleeping, and then we gonna close it out. So sometimes this is what I do for fun. I just look at CFPB past complaints. So you can look at CFPB past complaints. You come to the database right here, and you see right here, it shows 1 million matches out of over 2 million complaints, right? So this is throughout the world. So you can just Google CFPB past complaints, and this can help you with confidence, right? I know y'all like the money, so we're gonna look at some cases where there was money, right? So we'll scroll down here. So you want to look at the section where it says company response to consumer. Company response to consumer. Who's a consumer? You and I, right? So what we want to look at is we want to look at close with monetary relief. What does that mean? Close with monetary relief means that the CFPB issue was closed where the consumer got paid, right? When we talk about getting paid, we can talk about damages as far as $1,000 per inquiry. We're going to cover that whole process in a different class, but just as an example. But y'all see right here, close with explanation, that's a majority of what happens. You got over 1 million results right here, globally. So let's look at close with monetary relief, because, you know, we're looking at the money. But we gotta filter even more, because look, it shows different sections of what happened as far as what was closed with monetary compensation. So credit card is most popular, 15,000. What we're interested in is the least popular, which is credit reporting, credit repair, etc. So we're gonna go to filter it again, right? So we look at the issue over here. We could expand this. Hold on. Okay, I'm in the wrong section right here. So product is credit reporting, credit repair services, or other personal consumer reports. Because remember, we're Fair Credit Reporting Act right now. So remember, look at the timeline. From January 30th of 2019, literally 3 years ago, up until 3 years today, which is January, at the time of the recording, which is January 30th, 2022. So what we'll do, go to list. This is what you want to click right here. Because once you come to the website, you're automatically on the map. So you can look at map, you can look at trends, but you want to look at the list because that's going to give us the data. So we click on list. So then we can actually literally look at it. Look, date received. What is this? 126 was what? 4 days ago, right? You can see the consumer state. They live in California. Shout out to my West Coast people, California. So basically what happened, the issue was with this company, Grant Mercantile Agency. That sounds like a person defined in the Fair Credit Reporting Act, right? So Grant Mercantile Agency, they sound like a furnisher of information. Basically, the situation was closed with monetary relief. But what was the issue? Credit reporting. Incorrect information on your report. Information belongs to someone else. So what happened? This person 4 days ago, they got paid for information that belonged to someone else being reported on their report. When it goes back to accuracy, that's both inaccurate in terms of not being correct, but that's inaccurate and not being valuable. Because why is somebody else's information on my report? What if that person doesn't have good information? You know what I'm saying? So just look, 4 days ago, going through these sections can give y'all confidence as far as getting paid after we get the deletions. Let's look at another one. So 120, January 20th, what is that, 10 days ago? The consumer state was Texas. So it's not only in California. So close with monetary relief, what does that mean? Damages were sustained, they got paid. Alliance Data Card Services. That sounds like a furnisher of information. So what was it? Credit reporting again, right? Problem with the credit reporting company's investigation into an existing problem. Their investigation did not fix an error on your report. So because the error wasn't fixed, they got paid. What does the error not being fixed sound like? Sounds like I'm submitting all of these letters and I didn't get the deletion, right? So these are damages. Maybe you lost sleep because you didn't get the negative information deleted. So keep that in mind. Let's look again. Let's look at maybe a couple more examples. Let me even scroll down a little bit more. Let's just randomly stop right here. So January 6th, 2022, right? What state? Georgia. Revenue Enterprises LLC. So that sounds like a company or something. That could be a person. Close with monetary relief, credit reporting issue, account information incorrect. Incorrect information on somebody's report. Account information incorrect, right? So you could literally get paid for information being incorrect. If something's reporting and it's incorrect on the report, it would be a disservice to you not to submit a CFPB complaint. If they're not complying with it, that's willful non-compliance. That person probably understood they have the law at their disposal, 15 USC 1681N. Maybe they did willful non-compliance, or maybe they did 15 USC 1681O, negligent non-compliance, right? So it's really just up to you. Let's look at one more example. All right, so same thing, right? So Citibank was the issue, close of monetary relief. Their investigation did not fix an error on the person's report. So the whole point of me showing you all this is that it allows you to know people are getting paid for this information. And I want y'all to know that the money is there. You will get paid, but first master the deletions. First master the deletions. I want y'all to master the deletions, right? So last thing I just really want y'all to understand is, I said it earlier, but with the CFPB, you got to understand that you're talking to them like they're babies. Let me stop sharing my screen. So I'm pretty much on that. So with the CFPB, you're talking to them like they're babies. Because you're talking to them like they're babies, you got to understand that they don't necessarily understand the law. They don't understand all the time what's going on. These are employees that probably get like, $10, $9 an hour or something. They don't get paid like that, right? So they just trying to go home like anybody else. So really, really break down the law. I hope this class gave y'all value. If y'all awake, let me know how y'all feeling below. Let me know if y'all got any questions. Oh, one thing I wanted to say too. I think I said it earlier too, but if you look up 15 USC 1666B, it talks about the timing of payments that could be effective in terms of removing late payments. And then 15 USC 1666, scroll down to B again, correction of billing error. So those are a couple more weapons to add to your tool belt when it comes to deletions. This was a lot of information. If you purchase the recording, then definitely, definitely understand that it's just going to be consistency and persistence to help y'all move forward. Any questions? I'm going to let it be like a couple minutes if I don't hear any questions. I mean, if I don't read any questions, then we're going to get out of here. Hopefully this gave y'all value. Hopefully y'all not sleeping right now, But if y'all sleeping, then, it is what it is. It is what it is. Any questions? How y'all feeling? Thank you. This was a lot of great information. I just need to implement. Okay, appreciate you. Appreciate you tapping in. I know you're in the East Coast, so, I appreciate you staying up. It's only 9 o'clock though, but, anybody could be tired at this time. Any questions? Any questions? Did I light y'all up with information? Is that it? Did I light y'all up with information? Fire emoji. I appreciate that. I appreciate that. I appreciate you. Okay, no more questions, I don't think. All right, yeah, man. With that being said, I think that's all we have. But yeah, with that being said, man, y'all have a blessed one. I hope you enjoyed the FCRA. I hope you got some practical stuff you could take to go ahead and get to the next level. Now we're going to talk about the FDCPA, which is the Fair Debt Collection Practices Act, and this is 15 USC 1692. So this is going to be when you're receiving those texts, emails, phone calls, and this is where you go and you're sending your debt validation. So without further ado, we're going to get straight into it. If you've gotten value so far, you can click the link below and you can enroll in CAT Credit University to get our template letters and just get in a community of like-minded individuals that are also looking to get to the next level. Enjoy the video. All right, we're gonna get straight to it. So, my name is Michael Benjamin. I'm the CEO of Consumer Ammunition Tactics, or CATS. I think everyone in here, knows me. You probably talked to me. You probably talked to my assistant. You probably talked to someone in our business. So tonight, we're going to be breaking down the Fair Debt Collection Practices Act, which is the FDCPA, or 15 USC 1692. All I ask is that y'all have an open mind and take action on the information that we're going to talk about tonight. It's going to be a lot of information. We're going to go deeper than just Title 15. I'm going to be diving into things I only talk about in consultations, things that I don't talk about on a podcast because, you never know who's listening. And I don't want the information I'm going to be putting out into the wrong hands. So yeah, with that being said, let's get straight to it. All right, so housekeeping rules. I just need y'all to take action. Taking action can be simply taking action on information I give you. If you guys want to post on your story and tag me, that's taking action as well. Let people know, what's going on. You learn this information, you're about to get to the next level. So just take action. Don't overthink things. Take action. That's the main thing. All right, so the agenda. So we're breaking down the FDCPA, like I said. So first of all, it's going to be FDCPA literacy. So Fair Debt Collection Practices Act literacy, all right? So the FDCPA is 15 USC 1692. You can take a screenshot of this if you want, so that while we're going along, you could follow along. But 15 USC 1692, it's the congressional findings and declaration of purpose. Words are very, very important. If you go to the Fair Credit Reporting Act, or if you got the replay that I did, it's congressional findings and statement of purpose. The Truth in Lending Act, I'm gonna do a class on that maybe next month, maybe the following month. Congressional findings and declaration of purpose. I wouldn't focus too much as far as declaration versus a statement, but I just say that to say the congressional findings is where Congress found something was going on that was wrong, and it's why they came up with the law. 15 USC 1692A, definition section. When you're reading the law, the big three or just any law, there's always going to be a definition section. Definitions, just defining, the different terms that's going to be used in the following sections. The FDCPA in particular has 8 definitions. I don't know everybody's familiarity with the FDCPA, but the FDCPA has 8 definitions. So not too many. We're going to focus on them. Then we're going to go into 15 USC 1692B. 1692B is an acquisition of location information. So we're going to dive into that. We're going to go over some violations over there. And those of y'all that know, pursuant to 15 USC 1692K, civil liability section, each violation is at least $1,000. So we're going to talk about it and, help y'all as far as getting paid and things like that. Then we're going to go into 15 USC 1692C, the communication section, communication in connection with debt collection. The communication section is one of my favorite sections because literally if a debt collector communicates with you, that's a violation. You know what I'm saying? So it's going to be a lot of violations. Then we're going to go into 15 USC 1692D, harassment or abuse section. Harassment or abuse, an example is a debt collector simply saying that this is an attempt to collect a debt. You as a consumer, you decide what is harassment or abuse to you. So we're going to get into that. Then 1692E, we're going to talk about false or misleading representations. Some of y'all may have seen when I posted about speeding ticket, as far as a police officer pulling you over. I'm going to go a little bit deeper into that when we get towards the end of the class, and you'll kind of know where to start when it comes to disputing a speeding ticket, as far as, getting paid and things like that. All right, after that. So 15 USC 1692F, unfair practices. Unfair practices, we're going to get into that. And what you're going to see is that some of these laws might seem redundant, but the thing about them seeming redundant is it works in your favor, because if you get a violation that's in 1692F, but it's also in 1692C, you didn't just get a $1,000 violation, you got $2,000 violation, right? And then we're going to go over an example of the invoice. I'm going to show y'all how to structure that, how you should structure it. Then we're going to go into 15 USC 1692G, validation of debts, right? We're going to get into the definition of debt and just everything that needs to be done to validate a debt. But spoiler alert, these debt collectors, they can't validate a debt because you, the consumer, have the power to actually validate that debt. Then we're going to go into multiple debts. So that's 1692H,
I'm gonna show y'all what y'all can do to send out a notice and, you know, get additional payment. Then we're gonna go into 1692I. One, again, it's redundant, but it's gonna talk about legal actions by debt collectors. So I'm gonna give y'all a law that shows you and proves to you by law, debt collectors are not allowed to sue you. Corporations cannot sue you. So I'm gonna give y'all that law. I haven't mentioned it on a podcast or anything. It goes beyond Title 15. So, you know, just stay along, hang in there. We're gonna get through it. If you leave early, you're not gonna get it. And when I do, when we do, what's it called? When we chop up the recording, for those of y'all that got the recording as well, we might chop out some of the information. So you wanna stay through the entire class if you can. 15 USC 1692J, furnishing certain deceptive forms. So when we talk about, for example, your auto loan contract, just the fact of when you see under the name creditor and it says somebody else that's not you, that's technically a deceptive form because you are the original creditor. We're not going to get too deep into that in this class. That's more of a Truth in Lending Act thing, but you know, just pay attention. We'll get into it. And then we're going to wrap up the literacy with 15 USC 1692K. This is a civil liability section. This is where you're gonna go as far as, you know, getting your remedy, getting your money, things like that. So yeah, just keep that in mind. All right, so after we go through the literacy aspect, that's just part one. After we go through the literacy aspect, we're gonna go over the administrative process. I'm gonna talk about a process, not the process. There's multiple ways to, you know, skin a cat. So just understand that when we're going through it. Then we're gonna go over an affidavit example. What I think you should do as far as moving forward, as far as getting your remedy, whether that is a deletion, whether that is getting paid, things like that. We're going to go over an invoice example. So the way that I believe you should structure it, the way that I was taught to structure it, because I used to structure it differently, but I was taught by my mentor a different way to actually structure it. So I think it'll be of benefit to y'all. Then I'm going to give y'all some information, extra information on deleting charge-offs. If you've listened to my CAP podcast episode where I talked about deleting charge-offs. I talked about deleting charge-offs, but I didn't talk about what I'm going to talk about tonight, right? So it's just an extra measure you could take as far as deleting charge-offs. So we're going to get into that real quick. Then we're going to talk about litigation with the debt collectors. So suing debt collectors, because we don't have time to be just sending them notices all day and not even getting what we desire, right? So then we're going to talk about that. Then we're going to talk about miscellaneous bonus info. This is where it's going to go deeper than just Title 15. So a lot of the stuff in the miscellaneous section we're going to talk about, I've never covered it on the podcast. If you have ever heard anything I've said in the miscellaneous section, you've probably booked a consultation. And those of y'all that know, my consultations for 30 minutes are $350, right? So I only trust certain people with the information. You feel me? And then we're going to get to final remarks and then, you know, any questions y'all got, and then we'll get out of here. All right, so number one, mindset. I need y'all to study, right? Study these laws, but do not overthink. Overthinking leads to you not taking action. And I would hate for y'all not to take action because you're trying to just figure out the difference between one phrase and one word, right? So don't overthink yourself out of taking action. Please do not overthink yourself out of taking action. Number two, embrace the spirit of execution because it takes time. What do I mean by that? I mean, embrace the spirit of taking action because the whole process takes time. You know, when you send out a letter as far as like the credit reports, consumer reporting agencies, it's like 30 days for them to, you know, reply to you and things like that. We're going to see in the affidavit that I have, I specify 14 days because I like my process to be quick, but I don't want y'all to be in a habit of, okay, I sent this out 30 days. They got to reply. I sent this notice out 30 days. I got to reply. I sent this out 30 days. I got to reply. We're going to go over the administrative process. You could do it like that, but we're going to talk about a way you can combine everything just in one notice and then just get straight to litigation if you need to go that route. So just execute and do not overthink. I'm going to walk through the most important parts I think you should have in FDCPA. If y'all got questions, you can ask, but if it's beyond the scope of what I'm covering, I might, you know, just tell you not to focus too much on it because you want to look at it as use only what you need to use to get your desired result. You don't need to use everything in FDCPA to get your result because FDCPA goes from 1692A all the way to P. We're only covering 1692A all the way to K, right? That's all we need to get our desired result. So don't just have so much information and just be like, oh, I can say 15 USC, 1692, whatever. Use only what you need to get your desired result. I had a lot of when I first started, studying, I had a lot of just unnecessary dealings with just trying to memorize and know everything. Just get what you need and move forward. Don't overthink. That's my point. Hopefully that mindset helps you guys listening live or, somebody watching the replay. All right. So I'm a big believer in mindset and writing things down. So if y'all attended FCRA class or you watched the replay, this may look familiar. We got the same statement. I'm going to need you to write this down in your notes. If you're typing, if you're writing, do whatever you got to do. Put I, insert your name. Understand that everything I was taught about credit before may not have been true. And I promise to open my mindset to what I learned today. Sign and then put your name. I'm going to give y'all like a minute or something to do that real quick. And then I'm going to continue. And you guys can put done in the comments once you actually write that. But yeah. All right, yeah, for the sake of time, let's continue forward. Okay, yeah, before we actually get started, any questions for me? Any immediate questions for me? Y'all let me know. I might take like 1 or 2 questions before we get into it. We got a lot of information to cover, but I want to give y'all the space. FDCPA related questions to ask me real quick before we actually get started into interpreting the laws. I'm going to assume it's no questions and get straight to it. Okay, let me know. Can y'all see my screen? The law of Cornell 15 USC 1692. Let me know if y'all can see that. Let me know if y'all can see that. Okay, perfect. See, I got one C. I'm gonna get straight to it. All right, let's get straight to it. So like I said, 15 USC 1692. This is a Cornell website. You can go on the Cornell website to read the laws. Those of y'all that listen to my podcast, I've covered a lot of it. So congressional findings and declaration of purpose. Like I told y'all, this section is where Congress found something wrong that was going on. And that's why they decided to create the law. All right, listen. So abusive practices. So this is A. There is abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Let's stop right there. Before we even continue, you see it shows like a hyperlink to the word debt. It's going to take you to the definition of debt. So when you're reading these laws, I want y'all to get in the habit of clicking these hyperlinks. Because the definition of debt is in the next section, I'm not going to click on it right now, but I just want y'all to have that mindset of when I see a hyperlink, I'm going to click on it and get more information. So just in that first sentence alone, there's a lot. There's abundant evidence. Abundant, what does the word abundant mean? It means a lot, right? So there's a lot of evidence. They didn't say there's a little evidence. They said there's abundant evidence of the use of abusive. Does abusive mean you're treating somebody right? No. Abusive, deceptive. What is deceptive? Deception. You're deceiving somebody. And unfair. 1692F. Isn't that unfair as well? We're going to talk about it. Unfair debt collection practices. This is where the Fair Debt Collection Practices Act came from. So y'all got to realize that something bad was going on for Congress to be like, let's put out, the Fair Debt Collection Practices Act. So abusive debt collection practices contribute to the number of personal bankruptcies, to marital instability. Marriages are messing up, to the loss of jobs, people losing their jobs, and to invasions of individual privacy. Those of y'all that know in the Fair Credit Reporting Act, 15 USC 1681A, number 4, it talks about, you have a right to privacy as a consumer. So understand that they're also talking about invasion of your privacy in the Fair Debt Collection Practices Act as well, the FDCPA. So we only looked at one sentence or one section, abusive practices, right? So just really understand that there's a lot that really came into this. Congress didn't just wake up one day and be like, okay, let's just put out the FDCPA. It's because something wrong was going on as far as debt collection. They're not supposed to be collecting these debts from you. Everything is prepaid. We're not going to get too deep into it, but yeah, that's what's going on. So B, inadequacy of laws. So you don't need to pay too much attention, but it just says existing laws and procedures for redressing these injuries are inadequate to protect consumers. So basically what Congress is saying is that the current laws that were in place before they put out the FDCPA were inadequate. What does inadequate mean? Not adequate. What does adequate mean? Enough. If the laws were enough, that still wouldn't be good. For something to not be enough, it must be bad. Y'all following what I'm saying? So really just pay attention to, the different words and languages. All right, so available non-abusive collection methods means other than misrepresentation or other abusive debt collection practices are available for the effective collection of debts. So they're just basically saying that there should be better methods to debt collection. The current methods are not good. People are being abused, people are being harassed and things like that. So that's why they came out with the FDCPA. All right, D, interstate commerce. Abusive debt collection practices are carried on to a substantial extent in interstate commerce. Before we continue, interstate commerce is basically, understanding the fact that the United States is a federal corporation pursuant to 28 USC 3002. You go down to number 15, you're going to see the United States is a corporation. So meaning that the United States, you do business. Everything is business. Everything is commerce. Everything is trade. Everything is, personal property, money, things like that. That's basically what that interstate commerce means. So abusive debt collection practices are carried on to a substantial extent in interstate commerce and through means and instrumentalities of such commerce. Even where abusive debt collection practices are purely intrastate in character, they nevertheless directly affect interstate commerce. So Congress is just basically tying everything back to interstate commerce as far as debt collection practices. It's very bad, right? All right, so purposes. This is where I would focus the most on if you want to focus the most on. You don't need to pay too much attention. This is just like background history information. So purposes is the purpose of this subchapter to eliminate means get rid of, right? Abusive debt collection practices by debt collectors to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged and to promote consistent state action to protect consumers against debt collection abuses. So they basically want to make sure that debt collectors are doing good practices as they are performing debt collection. Before we continue, any questions on this section? I don't think there will be any questions, but I just want to give y'all the space if y'all have any quick questions. Like I said, don't overthink it. I wouldn't place too much attention on this section, but are we going to continue? If you guys have any, I guess, deep questions too, save that for the end. If you somehow don't get to ask your question, save it for the end. All right, so we're in the definition section. 15 USC 1692A. Remember, every law has a definition section. So the term bureau means the Bureau of Consumer Financial Protection. So I think everybody in here is familiar with the CFPB, the Consumer Financial Protection Bureau. That is the bureau that Obama created when he was president. And the CFPB is basically where you can submit complaints. They regulate the consumer reporting agencies, meaning Experian, TransUnion, and Equifax. Remember, Experian, TransUnion, and Equifax, they are not government related. They are privately owned companies, right? So the CFPB or the Consumer Financial Protection Bureau governs them. So when you're putting in your letters, credit bureaus, you're basically not speaking correct language, to be honest. So this is why you want to put consumer reporting agencies. If you don't understand that language, and you need to go purchase the FCRA replay that I did, the 2-hour one. But yeah, so the term bureau means the Bureau of Consumer Financial Protection. They're basically just talking about the CFPB. That's the only bureau that exists. All right, so number 2, remember there's 8 definitions, eight definitions in the FDCPA. So the term communication means the conveying of information regarding a debt directly or indirectly to any person through any medium, right? They said a lot over there. Communication is conveying information regarding a debt directly or indirectly. Let's stop there. Directly means you the consumer, right? You the consumer meaning John Doe or whatever. But indirectly is you, an example is you on a letter, right? If they send you a letter, notice that your name is in all caps, all capital letters. That's your corporation. That's you as a corporation. So that's what they mean by indirectly. And remember, the word or means whichever side you're choosing on. So if a debt collector communicates with you, meaning they send you a letter to you, they send a letter to you, they're communicating with you indirectly, right? If they call you, they're communicating with you directly. So just keep that in mind. Directly or indirectly to any person. Remember, any means no restriction. So any person through any medium, no restriction, medium. What are examples of mediums? A medium, like I said, phone call. A medium, like I said, mailing. So any form of communication. This is going to be very, very important when we get to 1692C. So just keep that in mind. All right, the term consumer means any natural person obligated or allegedly obligated to pay any debt. So consumer, This is really where I always tell y'all you got to really understand the language, because the term consumer in the FDCPA is differently defined as it is in the FCRA, the Fair Credit Reporting Act. In the Fair Credit Reporting Act, the term consumer means any individual or an individual. We obviously see here that's different from what it means in the FDCPA. So this is why when you're structuring your letters and your notices and things like that, you gotta understand what the definition you're talking about is. Remember, it's a language. You're not gonna use Spanish when you're trying to communicate in English, right? So just really understand that. So any natural person, so no restriction. You're the natural person, no restriction. Obligated or allegedly obligated. What do we say or means? Or means you choose the side you want to be on. So it's up to you when it comes to a debt if you're obligated or if you're allegedly obligated. When we talk about 18 USC 8, it talks about that obligation as well. So you got to really just understand, are you obligated to pay that debt or are you allegedly obligated to pay that debt? So understanding that is really what's going to allow you to be powerful as far as your notices. And we're going to go over an example of affidavit as well, but I just want y'all to be familiar with that. So the term creditor means any person who offers or extends credit creating a debt or to whom a debt is owed, but such term does not include any person to the extent that he receives an assignment or transfer of a debt in default solely for the purpose of facilitating collection of such debt for another. Don't think too deep about it. Whenever you're saying creditor, when it comes to the FDCPA, remember you're the consumer. A lot of times in the way you structure your letters, the creditor is going to be, that person you're talking to, that debt collector. But technically, when we're talking about Truth in Lending Act, when we're talking about creditor, you are the original creditor, right? So it depends on what you're talking about as far as interpreting creditor. But I don't want y'all to overthink it. I'll just say, in most cases, when you're using the FDCPA, the creditor is going to refer to them. You're the consumer. All right, so the term debt, let's continue. This is a very, very important definition. The term debt means any obligation or alleged obligation of a consumer, right? You're the consumer, right? To pay money arising out of a transaction. I would just stop there, but I'm going to read the whole thing. In which the money, property, insurance, or services which are the subject of the transaction are primarily for personal, family, or household purposes, whether or not such obligation has been reduced to judgment. So when it comes to debt, the main thing I need y'all to really focus on, you can read the whole definition, but the main thing I need y'all to focus on is any obligation or alleged obligation of a consumer, or means you choose what side you want to be on. Me personally, Michael Benjamin, the consumer, when I see the term debt is an alleged obligation of me, right? There's no law that says you have to pay any debt. Debt is an alleged obligation. To me, it's an alleged obligation. If you say it's an obligation to you, it's an obligation to you. When a debt collector sends you something, they say, oh, you owe the debt. If you don't refute it, if you don't say this is not my debt, it stands as is. Remember, silence is acquiescence, meaning that if you don't reply, what they say stands. It's the same, and it's the same thing when you send them an affidavit. If they don't reply line by line, it's an unrebutted affidavit. They didn't reply adequately, so it stands. So just keep that in mind, and you decide if debt is your obligation or alleged obligation. All right, the term debt collector is a long definition. We're not going to read through the whole thing. I just want to give y'all the important part. So the term debt collector means any person, remember any, no restriction, any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is a collection of any debts, right? And it goes on to say, or who regularly collects or attempts to collect directly or indirectly. Remember, directly calling you, indirectly, capital letters, mailing you a letter, right? Debts owed or due or asserted to be owed or due another. So the main thing I need y'all to really understand is a debt collector. Any person who attempts to collect something from you. So this is why a police officer is considered a debt collector. Because any means there's no restriction. Congress is literally letting y'all know, these police officers, they are debt collectors. Are they not attempting to collect a debt from you when they're running your credit card, your social security number, right? So you got to really understand that when it comes to debt collectors, it's any person who uses any instrumentality of interstate commerce. Remember, interstate commerce is just like doing business within the United States. So it goes on to say, let me show y'all how police officers are debt collectors. So A says any officer or employee of a creditor while in the name of the creditor collecting debts for such creditor. Any officer means there's no restriction on the officer. It's police officer, right? Policy officer. It goes deeper than that. Police policy officer. There's no coincidence why it's, like that, civil procedure and stuff like that. But we're going to get deeper into that later. If it goes to C too. C says any officer or employee of the United States, right? So just really understand that. So debt collectors are debt collectors, right? There's no restriction on debt collectors. All right, so number 7. The term location information means a consumer's place of abode and his telephone number at such place or his place of employment. So location information is 1692B, which we're going to get into in the next section. But basically, location information is just pretty much saying where you're located, because debt collectors are not supposed to have your location information, because you got to remember, you as a consumer, you have a right to privacy. So they're not supposed to be communicating with you, right? So keep that in mind. It can also be your place of employment. And we're going to talk a little bit about that deeper. All right, and then the term state, I wouldn't focus too much on, is just, state. The term state means any state, territory, or possession of the United States. So, somebody said California, wherever you're at. The District of Columbia, the Commonwealth of Puerto Rico, or any political subdivision of any of the foregoing. This is beyond the scope of the class, but the original Department of Treasury was in Puerto Rico, by the way. But yeah, I just wanted to let y'all know that. But any questions on the definition section? Any questions on the definition section? How are we feeling so far? Are we sleeping? We barely even got started. Don't be sleeping on me. Type in the comments so I know y'all awake. Y'all can hear me. Any questions on the definition section? I think definitions are pretty straightforward, but once we get into the later sections, it's probably going to be, it might be some questions. I don't know. I think I did a pretty good job on the podcast explaining. So some of this might be review, but y'all got any questions? Let me know how y'all feeling, at least down below. I don't see any questions right now, so I'm going to continue to 1692B. 1692B. Okay, feeling great. Okay, cool. Maybe everybody else is asleep. I saw feeling great, so at least one person's feeling great. I don't know where everybody else is, but let's continue. All right, acquisition of location information. This is 1692B. All right, so any debt collector, remember the power of that word any, no restriction. Any debt collector communicating with any person other than the consumer, so not you, for the purpose of acquiring location information about the consumer. So what is that saying? It's basically saying that if a debt collector is trying to get your location from somebody that is not you, what's an example of somebody that's not you? The most obvious example of somebody that is not you is like a family member, friend, whatever. But don't sleep on the fact that somebody that is not you is communicating with you indirectly. So if they send a letter to you, right? It might seem like they're communicating with you, but they're communicating with you indirectly. So that's what Congress is saying. They're communicating with you, but they're not directly communicating with you. So that classifies as any other, person that they're talking about. So yeah, just keep that in mind. You got to read between the lines sometimes. It says when they're doing that about the consumer, they shall. So shall means that they have to do it. They shall, number one, identify himself or themselves, state that they are confirming or correcting location information concerning the consumer, and only if expressly requested, identify the employer. So basically, it's pretty self-explanatory. They just got to identify themselves, etc. Number 2, this is 1692B, number 2. This is one of my favorites that you guys can use as a violation. Not state that such consumer owes any debt. So it's a violation for them to say that you owe a debt to somebody else. But remember, somebody else could be them mailing you a letter, because that's not directly you, that's indirectly you. Have you ever received a letter that said this is an attempt to collect a debt? It has your name in all caps. So that's a violation. 15 USC 1692B number 2. That's a violation of that. You need to write that down. Write it down as an exhibit on that letter, make a copy of it, and send it out with your paperwork. So number 3 says, not communicate with any such person more than once, unless requested to do so by such person, or unless the debt collector reasonably believes that the earlier response of such person is erroneous or incomplete, and that such person now has correct or complete location information. So the main part I want y'all to focus on is not communicate with any such person more than once. Remember, think about the communication other than you as them sending you a letter. So they're not supposed to communicate with you more than once unless you request them to, and you never request them to. So it looks like 1692B number 3 is a violation as well. We already found $2,000 worth of violations. If we want to go with number 1, we found $3,000 worth of violations. Number 4 says not communicate by postcard. So a while ago, debt collectors used to communicate by postcard, but they don't as much anymore. But yeah, so you can skip that section unless you get communicated with by postcard. So this one, number 5, everybody has this violation. Not use any language or symbol on any envelope or in the contents of any communication affected by the mails or telegram that indicates that the debt collector is in the debt collection business or that the communication relates to the collection of a debt. So basically, 15 USC 1692B number 5 is saying that if they use any language on a letter, what is any language on a letter? Literally typing anything. That's a violation. So you already got, are we at $4,000, $5,000 worth of violations yet? If they use a symbol is their logo. If you see a Chase logo on something, circle that. That's an exhibit. That's a violation of 15 USC 1692B number 5. So that's like what, $6,000? We're only in 1692B. We haven't even gone through all the sections. So you got to really understand that they are really committing a lot of violations. You want to really write them down, make copies. And at the end of the day, identifying the violations aren't too hard. It's just about structuring your argument and going to get your desired result and your remedy. But we're going to dive into that. All right, number 6. So it basically says, after the debt collector knows the consumer is represented by an attorney with regard to the subject debt and has knowledge of or can readily ascertain such attorney's name and address, not communicate with any person other than that attorney unless the attorney fails to respond within a reasonable period of time to communication from the debt collector. So 15 USC 1692B number 6 is just basically saying if you have an attorney, they're not supposed to communicate with you. To be honest, we're going to dive deeper later and we're going to talk about you representing yourself, which is a pro se litigant. So I wouldn't focus too much on that violation, but if you have an attorney, then, if they communicate with you, that's an extra $1,000. Any questions? I said any. Any questions on 1692B? Let me know. Are we gonna move forward? If y'all have questions later on, just let me know. So we're going to one of my favorite sections, 1692C. Communication and connection with debt collection. So A says communication with the consumer generally. So communication with you generally. Sometimes it makes it easier to read these laws when you just substitute things with phrases. So you're the consumer. So you can say, if your name is John, you could say communication with me or John generally. So without the prior consent, what does consent mean? You're allowing them. Without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction, a debt collector may not communicate with the consumer in connection with the collection of any debt. Just that section alone. We don't even got to go to, number 1, 2, and all that. You can quote 15 USC 1692CA, communication with the consumer generally. They're not supposed to communicate with you. That's already a violation if they communicate with you. So that's $1,000 right there. All right, number 1, what does it say? At any unusual time or place, or a time or place known or which should be known to be inconvenient to the consumer. In the absence of knowledge of circumstances to the contrary, a debt collector shall assume that convenient time for communicating with the consumer is after 8 o'clock and before 9 o'clock, local time at the consumer's location. Let's break down that second sentence first before we get into the sauce of the first sentence. So it basically says a debt collector shall assume. Does an assumption mean it's correct? Just because a debt collector makes an assumption and then they call you, it doesn't mean they didn't violate you. What if they call you at a time that's inconvenient to you? That's a violation, 15 USC 1692 CA1. So the first sentence, it says at any unusual time or place, which should be known to be inconvenient to the consumer. So this is a sauce right here. What if, okay, let's say you're working your job, right? But what if you're also a business owner? As a business owner, let's say you work 24/7. So if a debt collector calls you, isn't that already a time that's inconvenient to you? I can't tell you what's inconvenient to you, but I can tell you what's inconvenient for me. Me as a business owner, I'm on the go 24/7. So if a debt collector calls me at all, that's inconvenient to me. That's already 15 USC 1692 CA1. That's a violation. That's $1,000. I'm gonna need that, right? So you got to really understand what's inconvenient to you. If you're a business owner, 24/7, you work. If you're at work and they call you, obviously that's a violation. The easiest way, obviously, is you working as a business owner 24/7. You don't even technically got to be a business owner. Maybe you're learning about business. You're still working, so that communication is a violation. Number two, if the debt collector knows the consumer is represented by an attorney with respect to such a debt and has knowledge of such attorneys, etc., it's basically saying right there, which was in the previous section, if you have an attorney, they're not supposed to communicate with you. And earlier in the beginning, I was saying how some of these laws you're going to see are redundant, and it works in your favor, the fact that it is redundant. So in the previous section, 1692B, where we had the attorney law, that was a $1,000 violation. We can come back to 1692C, same violation, $2,000. We just double up, right? So just really understand that when you see something that's like repetitive or redundant, it's going to work in your favor. All right, so number three, at the consumer's place of employment, if the debt collector knows or has reason to know that the consumer's employer prohibits a consumer from receiving such communication. What did I say about you as a business owner? I said, if you're a business owner, right, your place of employment can be literally anywhere. If I'm at the store or something and I'm a business owner, 24/7, I'm working. I might be buying some stuff for my business. You communicate with me, you call me, that's a violation of 15 USC 1692 CA3. So really just understand how it can work in your favor, right? Congress made these laws for you. It's up to you to utilize them the correct way. So communication with third parties, this is B. It basically is redundant again, based off of the previous section we talked about, so we're not gonna go over it. But 1692 CC, ceasing communication. This is where your cease and desist comes in. So if a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer. You could just stop there, that's a violation. To such debt, except, so it says number one, to advise the consumer that the debt collector's further efforts are being terminated. So they can only communicate with you after you send a cease and desist notice to let you know that, okay, we're done communicating with you. They can't attempt to collect anymore. Number two, to notify the consumer that the debt collector or creditor may invoke specified remedies which are ordinarily invoked by such a debt collector or creditor. So I wouldn't worry about 2 or 3 really, but the main one you want to worry about is 15 USC 1692 CC. So this seizing communication section. This is all I would really worry about as far as, getting your remedy and things like that. Remember, there's a lot of laws, there's a lot of sentences and things like that, but only get what you need, right? So if a consumer notifies a debt collector in writing, if you send a cease and desist notice, which we're going to go over, if you send a cease and desist notice that you refuse to pay that alleged debt, if it's alleged to you, it's alleged to me personally, to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt. So if you let them know, I refuse to pay this debt, they're not supposed to communicate with you anymore, right? And when you tell them you refuse to pay that debt, it's now been disputed. And we're gonna get into multiple debts, which is 1692H. I'm gonna tell y'all something y'all can do. We're gonna tie it to the Fair Credit Reporting Act. So just be taking your notes and then revisit it later. And if you bought the replay, watch the replay. If you didn't buy the replay initially, then you'll have a chance to buy it later. But yeah, that's the communication section. Any questions on the communication section? I'm gonna take some water and then just continue. All right. So 1692D, harassment or abuse. This is a fun section as well. A debt collector, we know what debt collectors are, right? May not engage in any conduct, the natural consequence of which is to harass, oppress, or abuse any person in connection with the collection of a debt. So that already lets us know what's about to go on. Without limiting the general application of the foregoing, the following conduct is a violation of this section. Remember, when you see violations, you circle them, you put them down as exhibits. If it's a phone call, screenshot it, print it out. And then you're going to tie it to 1692K, which we're going to talk about later. So number one, the use or threat. The use or threat of use of violence or other criminal means to harm the physical person, reputation, or property of any person. Let's stop right there. So 15 USC 1692D, right? 1692D, harassment or abuse. 1692D, number one, the use or threat of use of violence or other criminal means to harm the physical person, reputation, or property of any person. The most important part I want y'all to focus on, because a lot of what we're focused on is credit, is your reputation. If you have a negative item on your credit report, your consumer report, whatever you want to call it, is that not a harm to your reputation? That looks like it's a violation of 15 USC 1692 D number 1. So really look at the words and how you can use it and apply it within your specific situation. If you got an inquiry, that's harmful to your reputation. Technically, credit reporting is optional. So you got to understand that, you can really structure your credit report, consumer report how you want to. And then also too, as far as reputation, we're talking about debt collectors. If they send you a letter, what if you live with your spouse, significant other, or whatever, siblings, family, parents, whatever, right? That's a harm to your reputation, because they're letting you know that, you owe this alleged debt. So, that's a violation you can use. So 1692 D number 2, the use of obscene or profane language, or language the natural consequence of which is to abuse the hearer or reader. Obscene or profane language, you, the consumer, you determine that. To me, if I look at a letter and it says this is an attempt to collect a debt, that's obscene or profane language to me. To me, you're cursing me out by saying that I owe a debt. So to me, I'm going to use 1692 D number 2. That's a $1,000 violation, because you can't say I owe a debt, because I know I don't owe a debt. I know I'm the original creditor. I know I extended that credit to myself, right? So obscene or profane language is up to you. If you see an amount, a dollar amount, if that's obscene or profane language, that's obscene or profane language to you. So really understand that. Number 3, I wouldn't worry too much about it. Number 4, I wouldn't worry too much about it. Number 5, causing a telephone to ring. So we'll stop right there. That's basically just giving you a phone call. If a debt collector gives you a phone call, that's a violation of 1692 D number 5. You can get them for $1,000. There's also something called, I think it's a TCPA. I think that's $500 per phone call violation. So you can get them in multiple violations. You can get them in 1692K, or you can get them in I think it's TCPA. Do more. You could look it up and confirm that, but yeah, that's a violation as well. So 1692D, harassment or abuse, it has, these violations you can use. There's obviously several violations that we're looking at. So what was I going to say? Any questions? Let me know. Let me know. No questions so far? Okay, harassment or abuse. There's a lot of violations here. And I also have, I forgot to let y'all know. The people watching the replay, if you're watching the replay, this does not apply to you, because you should have came to the live class. But those of y'all that's here in the live class, there's like a cheat sheet I have that walks through the entire FDCPA on one page. So it's just easy to look at. So I'm going to email it out to y'all. And then, y'all can have that. Maybe I'll show y'all at the end too, just for the people that's on the replay. All right, so 1692E, 15 USC 1692E. I think I covered it briefly on a podcast, but we're really going to talk about, as far as disputing a speeding ticket. I gave enough information to start on the podcast, but like I said, the class is for deeper things I cannot talk about in public on the podcast. Oh, the podcast is about to go live actually in like 6 minutes. Make sure y'all tune in to the New Cap podcast when y'all get off this class. I interviewed my friend Precious Price. She's talking about Airbnb, and she's gonna really, help y'all get started in Airbnb. But that's besides the point. 15 USC 1692E, false or misleading representations. Let's get straight to it. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. Without limiting the general application of the foregoing, the following conduct is a violation of this section. So number 1, the false representation or implication that the debt collector is vouched for, bonded by, or affiliated with the United States or any state, including the use of any badge. Does a police officer have a badge? Congress told you police officers are what? Debt collectors, right? So you can get them under this violation if they attempt to collect a debt from you, meaning a speeding ticket. So number 2, this is a violation too. This is one of my favorites as well. The false representation of the character, amount, or legal status of any debt. What's my favorite one over here? Amount. If they send you a letter and they say minimum payment, whatever, it could be $1. That's a violation. False representation, because you know a debt is alleged obligation. They're giving you something that is allegedly yours, right? So that's a violation right there. Remember, each violation is $1,000. We've been here talking about it, maybe like what, 30, 40 minutes talking about it. We haven't even been through all the sections, and we've already found thousands of dollars of violations. So really just understand that, you know, these violations are there. So if they say you owe any amount, that's a violation right there. 3, the false representation or implication that any individual is an attorney or that any communication is from an attorney. What does that mean? An attorney cannot communicate with you. You as a consumer are very, very powerful. So if you get a letter from an attorney, that's an exhibit. That's a violation. I'm pretty sure they know, they understand that. But to be honest, most people don't know the information that we know. Those of y'all that's in this class, you obviously know a little bit about consumer law, at least a little bit about consumer law. And I'm pretty sure you know more than most people know about consumer law. So these attorneys, judges, everybody, they just assume that everybody doesn't, you know this information. People don't know their rights and things like that. And it's sad that's the case, but that's why, you know, at CAT, Consumer Ammunition Tactics, it's our duty to make sure y'all know this information in a digestible way. Because when I first started, you know, learning these laws and things like that, it wasn't as digestible. So when I was learning it, I was like, okay, I know I have to pass this forward. So let me make it in a more digestible way. That's where you get the podcast. That's where you get these master classes. You know what I'm saying? So yeah, that's just a little bit on the goal. So number 4, the representation or implication that non-payment of any debt will result in the arrest or imprisonment of any person, or the seizure, garnishment, attachment, or sale of any property or wages of any person, unless such action is lawful and the debt collector or creditor intends to take such action. So it basically says that they can't threaten you to say that if you don't pay the debt, you know, they're gonna close your account. They can't say that it's gonna result in arrest and things like that. That's a violation. That's $1,000 violation, at least $1,000, right? They can't garnish your wages, things like that. So yeah, just really understand that they're committing a lot of fraud, a lot of violations, and people are just allowing them because they don't have access to the information. Number 5, the threats to take any action that cannot legally be taken or that is not intended to be taken. So they can't threaten to do something that they can't do. And I'm going to give y'all a law that I never spoke about on a podcast or anything that lets you know that corporations, debt collectors, they can't sue you. Right? So pay attention later when I give it to you. You can combine it with, this number 5, and you'll have a powerful dispute. The false representation or implication that a sale, referral, or other transfer of any interest in a debt shall cause a consumer to lose any claim or default. I wouldn't focus too much on that. So just understand it's a lot. If you really go through all of these, for the sake of time, I'm not going to go through everything, but some of these are redundant to previous sections. So if you spend your time going through all of it, you'll really realize that you can get a lot of violations. Look at number 10, the use of any false representation or deceptive means to collect or attempt to collect any debt. Attempting to collect a debt, that's a violation. That's already $1,000 extra over there, right? So yeah, just really understand it goes real deep. It goes all the way to number 16. But yeah, we're going to continue if nobody has any questions on 1692E. And then remember, 1692E is where your foundation for disputing a speeding ticket is. And when I say disputing a speeding ticket, I'm not telling y'all to drive 100 miles per hour, you know, just to test it out or anything. So drive safely. But if you do get a speeding ticket, there is a way because the law. So any questions? I do not condone speeding. Drive safely, drive carefully. But if you got a speeding ticket, there's a way. All right, let's go to F. Again, this is a redundant section, but I just point everything out just to let y'all know, just in case you're missing some of the language, and then we're gonna get into application in a little bit. So a debt collector may not use unfair or unconscionable means to collect or attempt to collect any debt. So what does that mean? A debt collector may not use unfair means to collect or attempt to collect any debt. We're going to get into what unfair is, but just within the first sentence, we already have an idea that we're going to get a lot of violations in 1692F. And remember, when it's redundant, when you see something that's similar to previous sections, you can combine those violations. You're just getting more money for, you know, what you're disputing. So keep that in mind. Without limiting the general application of the foregoing, the following conduct is a violation of this section. Number one, the collection of any amount. What does any amount mean? No restriction on the amount. So if you send me a letter that says this is an attempt to collect $1 from me, I just got a $999 return because I'm going to charge you $1,000, right? So the collection of any amount, unless such amount is expressly authorized by the agreement creating the debt or permitted by law. No, there's no law that says you have to pay a debt, so that's irrelevant. The collection of any amount, just stop right there. The collection of any amount. 15 USC, what section are we in? 15 USC 1692F, number one. We go back to the congressional findings. Congressional findings, what did Congress find? There was abusive practices as far as debt collection. We're in unfair practices. It's unfair to collect on any amount of debt because you are the consumer. United States went bankrupt in 1933. Look up the 1933 Act and you'll get more background information. So really just understand that that's a violation right there. That's already $1,000, right? That's the main one I want y'all to know here because a lot of this is redundant, but I like number one. And then I want to speak about repos, repossessions. Number 6. So anybody that has a repossession, if you're dealing with a repossession, look at 15 USC 1692 F number 6. So taking or threatening to take any non-judicial action. What does non-judicial action mean? A non-judicial action means it's not given by, judges. It's not given by the court to affect dispossession or disablement of property if A says there is no present right to possession of the property claimed as collateral through an enforceable security interest. There's no present intention to take possession of property. The property is exempt by law from such a dispossession or disablement. So this basically, what the law is basically saying, 1692 F number 6, is basically saying that repos are technically illegal. They're not supposed to happen. So if a repossession happens, the court didn't order them to kidnap your property, right? So if you have a repossession, what you want to focus on as far as the FDCPA is 15 USC 1692 F number 6. So really pay attention over there. Look, number 7 is redundant as well. 1692 F number 7. Didn't we talk about communicating with the postcard earlier? $1,000, right? They don't really do postcards anymore, but look at number 8. Number 8 is going to be a violation for everybody. Using any language or symbol. Didn't we talk about that earlier? Any language. What's a language? This is an attempt to collect the debt. Okay, that's a violation. 15 USC 1692 F number 8. Pursuant to 1692K, I need $1,000. Symbol. Chase's symbol, Bank of America symbol. Why is it on this letter? I'm circling it. That's a violation of 15 USC 1692 F number 8. Pursuant to 1692K, that's a violation. So just really understand there's several violations. The FDCPA, out of the big three, if you don't know, is the Fair Credit Reporting Act, 1681, which I taught already. Truth in Lending Act, which is a 1601 and 1602 definition section, and then the FDCPA 1692. The Fair Debt Collection Practices Act is probably, in my opinion, where you should start if you haven't started studying consumer law. I think it's the easiest one to understand, and it's just several violations. And the fact that there are many violations, even if you miss some violations, there's so many violations, you're gonna rack up a lot of money within your remedy. So yeah, just keep that in mind as you're going through it. Any questions? Any questions? Remember, we're just diving into the definitions. I've covered some of this stuff on a podcast, so a lot of this may be review if you listen to the podcast, but we're gonna get deeper into the stuff that I don't cover on the podcast. I only cover in consultations. Remember, consultations, 30-minute consultations are $350 currently. It's gonna go up to $500 pretty soon, but currently they're $350. I think everybody in here used a 40% off code, so you got the class for $120. So you're saving a lot of money, by taking action and being in a course class, whatever you want to call it. All right, so we're going to go to validation of debts. I'm going to give y'all a UCC code, Uniform Commercial Code. That's very similar to validation of debts. That's one of the things I haven't talked about on the podcast. I've only talked about it in consultations, but we're going to talk about 1692G. 15 USC 1692G, validation of debts. So basically, the section 1692G, whenever you're writing your debt validation letter, which is part of your administrative process, you're basically letting them know what they have to do to actually validate that debt. But even though you're reading the 5 things that they have to do to validate the debt, understand that they cannot validate the debt. Only you, the consumer, can validate the debt. So just keep that in mind as we're going through. Notice of debt, contents. Within 5 days after the initial communication with the consumer in connection with the collection of any debt, a debt collector shall, unless the following information is contained in initial communication or a consumer has paid the debt, send the consumer a written notice containing. Number 1. Oh, before we even continue, like I said, as y'all are going through it, if you want to tag me on your story or something, you know, let the people know what you're doing, let the people know, you know, you're getting the information, go ahead. So number 1 says the amount of the debt. So number 1, they have to say the amount of the alleged debt. Remember what I said about the hyperlinks. When you click on the hyperlinks, it lets you know, it takes you back to the definitions. So the term debt means any obligation or alleged obligation. So get in the habit of clicking on them hyperlinks. So let's go back. They have to let you know the amount of the debt. Number 2, the name of the creditor to whom the debt is owed. Number 3, a statement that unless the consumer within 30 days after received the notice disputes the validity of the debt or any portion thereof, the debt will be assumed to be valid by the debt collector. So I have to let you know that too. Number 4, a statement that if the consumer notifies the debt collector in writing within the 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt or a copy of a judgment against the consumer, and a copy of such verification or judgment will be mailed to the consumer by the debt collector. And number 5, a statement that upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor if different from the current creditor. So I'm gonna give y'all a secret. All 5 of these things, these debt collectors are never gonna give it to you. But like I said, even if they give it to you, the language is very, very important. Even if they give you the 5 things, what does that even mean? Any obligation or alleged obligation. If it's an alleged obligation, even if you give me the 5 things to actually satisfy or validate the debt, it's still an alleged obligation. I wrote to you, it's an alleged obligation. So it's an alleged obligation. That's the foundation. So really just understand, even if they send you the 5 things, which they won't, you know, it's an alleged obligation. We're gonna walk through my affidavit example. It's an 11-page affidavit. It's asking more than like 50 questions, basically. So you have 5 here, but in the affidavit that I send, it's like 50-something questions. They're not gonna answer every question. So by law, your affidavit is your most important piece of information when it comes to, you know, winning in court and all that. So by law, that affidavit is going to stand true, because if it's not replied to line by line, it stands as true. So yeah, just keep that in mind as we get into the affidavit. I'll give you guys more information on that. But the validation of debt section, this is basically what they say has to be satisfied. And like I said, I'm going to give y'all a UCC code, Uniform Commercial Code, because, you know, these laws go deeper than 15 USC. There's UCC codes, there's rules. You know, rule 1, rule 2, rule 602. We're going to go through some rules as well, which I don't talk about on the podcast, but I'm going to, you know, y'all pay for the class or replay, so you'll get the information. But yeah, don't get overwhelmed. It's a lot of information. Just be taking notes and then revisit it later. Just take action. So B, 1692G, number B. I said number B, letter B, disputed debts. So this is a long paragraph. I'm not going to read the whole thing, but basically all you need to know is that if you notify the debt collector in writing that the debt is disputed. So if you're disputing a debt, it means that they're not supposed to attempt to collect on it. So basically, when we go back to 1692 CC, which is season communication, if y'all took notes or just remember, that was basically where we were talking about. Once we let them know that we refuse to pay on the alleged debt, they have to cease communication. They have to stop communicating. They have to cease their collection efforts and cease communication. 1692G B is an additional ceasing communication section. And I'm also going to give y'all later, it's going to tie to multiple debts. Whenever you dispute a debt and, you know, they've received your notice and it's noted that you're disputing a debt, you can use 1692H, which is multiple debts. And you can actually send a notice to invoice them for previous payments. Because if they are attempting to collect on a debt that is disputed, that's a violation. So we're gonna dive deep into it, and it's gonna tie to The Fair Credit Reporting Act. This is a specific section in the Fair Credit Reporting Act. So yeah, so if you're disputing, they're not supposed to attempt to collect on it. Just remember that. 1692G(c), admission of liability. The failure of a consumer to dispute the validity of a debt under this section may not be construed by any court as an admission of liability by the consumer. So this is basically saying that if you fail to say that the debt is yours, it shouldn't be misconstrued that you're liable for that debt. So what does that mean? Isn't Congress looking out for you? Congress is looking out for you because usually it's like ignorance or law is no excuse, but the fact that they're saying that if you fail to dispute the validity of it, it shouldn't be misconstrued as saying in court that you do owe that debt. So Congress gave you all the power. They gave y'all a cheat code by saying that even if you fail to say, oh, this ain't my debt, they can't say like, oh, you didn't say it's your debt, so now it's your debt. Admission of liability. So 1692G(c), that's a powerful section as well. Pay attention to that one. So that's pretty much validation of debt. Like I said, I'm going to give y'all an additional validation of debt UCC code. But that is that. Any questions? Any questions? I've been talking. I need a water break. So we're going to go to 1692H. I got to go over here because it acts weird after you get to 1692G. So we're talking about multiple debts. Multiple debts. So this is a section you want to pay attention to as well. I haven't really covered it deeply on the podcast because, I don't want it in the wrong hands. But if any consumer owes multiple debts and makes any single payment to any debt collector with respect to such debts, such debt collector may not apply such payment to any debt which is disputed by the consumer and where applicable shall apply such payment in accordance with the consumer's directions. All right, let me read that one more time and then I'm going to break it down on what it means if y'all aren't following. So 1692H, multiple debts. If any consumer owes multiple debts and makes any single payment to any debt collector with respect to such debts, such debt collector may not apply such payment to any debt which is disputed by the consumer and where applicable shall apply such payment in accordance with the consumer's directions. It might sound crazy, but this is what Congress is saying. Let's say you send out a notice and you're disputing the validity of a debt. So you send out your debt validation letter. Because you sent out your debt validation letter, this is now a disputed debt. So let's say, oh, the minimum payment comes around again. If you make that minimum payment, they're not supposed to apply that minimum payment to the account because you disputed the debt. Because it's being disputed, it's supposed to be applied based off of your instructions. The reason why they say multiple debts is like you made multiple payments. Because it's supposed to be applied in terms of your instructions, what you can actually do is send a notice to them because it's disputed, let them know because it's in accordance with the consumer's directions. You can let them know to send you that payment and the previous payments you made to you via check, to your bank account or whatever. So it's up to you as a consumer. Remember, all this stuff is prepaid, right? So it's up to you and your directions. So the way that you're actually going to do it, you're going to use 15 USC 1692H. You're going to combine it with the FCRA section, 15 USC 1681I. So 1681I, it talks about basically, when you're disputing the process, when something is disputed, they're not supposed to be attempting to collect on, that debt and things like that. So write down 15 USC 1681I and use that section with 1692H. So multiple debts. So that's some sauce right there. A lot of people don't know about that and how you can combine those two sections. You're supposed to, you're not supposed to, you can instruct them when you dispute that debt because it's based off of the consumer's directions to send the debt over, to send the previous payments you made over to you. I'm not saying that it's going to happen like that. A lot of times, like I say, you got to apply pressure and take them to court. But as long as you show these things through paperwork, you'll be able to get your desired result eventually. Because you got to think about it, just because you send an invoice, just because you send 1692H, you're showing them the law, they're going to continue violating the law unless you apply pressure. So this is why we're talking about litigation today or tonight, whatever. Any questions on 1692H? 1692H. All right, we're going to go to 1692I, remember I said it acts weird, so I gotta go to the actual, hold on. Okay, I gotta go to the actual thing over here. Okay, this is a redundant section again, but just extra violations to rack up. So legal actions by debt collectors. Remember, I'm gonna give y'all a law later that shows you debt collectors they're not allowed to sue you. There's a specific law that gives you that. I haven't talked about publicly besides consultations. So venue, any debt collector who brings any legal action on the debt against any consumer shall, in the case of an action to enforce an interest in real property, securing the consumer's obligation, bring such action only in the judicial district or similar legal entity in which such real property is located. So they're basically saying that they have to sue you where you live, basically. That's basically what it's saying. And in a court, judicial. In the case of an action not described in paragraph 1, so not applying to paragraph 1, bring such action only in the judicial district or similar legal entity in which such consumer signed a contract sued upon. So wherever you did business, B says in which such consumer resides at the commencement of the action, you know, where you were at the time of that transaction that they're attempting to sue you for. But remember, they can't sue you. If you get sued by a debt collector, you should be smiling because you understand, well, you're gonna understand if you don't know already, the law I'm gonna give y'all that y'all wanna write down to use against them if they attempt to sue you. In the authorization of actions, it just says nothing in this chapter shall be construed to authorize the bringing of legal actions by debt collectors. So yeah, they're not supposed to sue you. But if they attempt to sue you, I'm giving y'all the protection on how to go about that. Any questions on, this one? All right, let's go to HIJ. So we got 2 more and then we're gonna get deeper into examples and stuff. So this is just a literacy aspect. Oh, I meant to open an additional tab. Hold on. Furnishing certain deceptive forms, legal actions by debt collectors, furnishing certain deceptive forms. This applies to everyone, right? Chase, etc. Yes, it applies to Chase. If they're attempting to collect a debt from you, they are a debt collector. So yes, it applies to them. Our 1692J, furnishing certain deceptive forms. Furnishing certain deceptive forms. So A, it is unlawful to design, compile, and furnish any form knowing that such form would be used to create the false belief in a consumer that a person other than the creditor of such consumer is participating in the collection of or in an attempt to collect a debt such consumer allegedly owes such creditor, when in fact such person is not so participating. So a simple example I can give y'all. This goes back to TILA, Truth in Lending Act, which is 15 USC 1601, but 15 USC 1602, it's a definition section. So when you have your car contract, if you go to your car contract right now, it's going to say original creditor and it's not going to say you. That is a deceptive form. So that's a violation of 15 USC 1692J because of the fact that you are the original creditor. You extended the credit to yourself. The FDCPA is not the section for us to break down, the fact of how you're the original creditor, but just understand, take notes, 1692J, that applies to your car contract. So when you circle on your car contract, the original creditor, that's deceptive, right? Because it's as if you're not the original creditor, right? So anything is, anything that says you're not the original creditor on that car contract is a violation. An additional violation is if they don't give you like a certain disclosure. So omitting something from a certain process, that's a deceptive form. So just really be thinking about, things that you get and what is a certain deceptive form. A deceptive form, what's a deceptive form? An example of a deceptive form, because they say any form means no restriction. An example that I want to give y'all as well, they send you a letter saying that you owe a debt. If it's an alleged debt, that's a deceptive form because they're making you think that you have to pay something that you don't have to pay, right? Because you're not paying on a positive balance. So you got to really understand that. B, any person who violates this section shall be liable to the same extent and in the same manner as a debt collector is liable under section 1692K of this title. We're going to go to 1692K next. That's where the money is. For failure to comply with the provision of this subchapter. So 1692J, pretty self-explanatory, just additional violations for y'all to get them under. The main example that I've seen, dealing with people is just the fact of, your car contract. So when it comes to rescinding that car contract, that 1692J is what you want to be aware of as far as part of your exhibits. That's only a small portion of the whole process, but that's a different conversation for a different day. So this is 1692J. I'm going to go to K if there are no questions, and then we're going to continue. So civil liability section. So you see 15 USC 1692 goes all the way to P, but I'm telling y'all, only use what you need. You don't need to get too deep into it. I used to be falling victim to getting so deep with, all these laws and things like that, but it's like, use only what you need. So civil liability section. So if you don't know about civil liability, 15 USC 1681N is a civil liability section for the Fair Credit Reporting Act. So if you watch the Fair Credit Reporting Act, or if you just know about it, that's civil liability section. 16810 is also a civil liability section. So the Fair Credit Reporting Act has two civil liability sections. The Fair Debt Collection Practices Act, which is what we're talking about today, it has one civil liability section, which is what we're talking about right now. The Truth in Lending Act has one civil liability section, 15 USC 1640. So Truth in Lending Act, that's going to be a separate class that we're going to talk about. But I just want y'all to be familiar with, the different civil liability sections. So amount of damages. Except as otherwise provided by this section, any debt collector, any is no restriction, right? So someone asked about Chase earlier. Chase is, if they're attempting to collect a debt from you, they're a debt collector. Any debt collector who fails to comply with any provision of this subchapter with respect to any person is liable to such person in an amount equal to the sum of any actual damage sustained by such person as a result of such failure. So an actual damage is dependent upon you. For me personally, if you're using obscene or profane language, that's a damage to me. That's harmful to my reputation. You're saying I owe a debt I don't owe. You put something on my credit report or my consumer report, that's harmful to my reputation. That's an actual damage. You put something on my credit report, it's aggravated identity theft because I did not give you consent to put it on there. That's a damage, actual damage, right? So it's really up to you to determine what an actual damage is. So in the case of any action by an individual, such additional damages as the court may allow, but not exceeding $1,000. So that 2A is where you understand when we say it's $1,000 per violation, where it's $1,000 per violation, right? And when you're doing it, when you're suing in district courts, the max you can get is $75,000 you can sue for. But there's a further relief section, which is, and this goes deeper, or we're going to go deeper into it. It's 28 USC 2201. There's a further relief section if you want to sue for more than $75,000. That's what you would use. But yeah, we're gonna go deeper into that in a little bit. But I don't want to give y'all too much information to where you won't take action. When it comes to litigation, we're going to talk about litigation in a little bit. We're looking at 1692 KD, right? So a lot of people, this is where a lot of people just focus on. A lot of people just focus on, any actual damage right here. A1, 2A, etc. But when we're talking about actually taking action, like I said, I haven't mentioned this on the podcast because, I don't know who's serious, right? You guys invested in the class. I know you're serious. So let me tell y'all what we actually focus on when it comes to taking these people to court. 1692 KD, jurisdiction. An action to enforce any liability created by this subchapter may be brought in any appropriate United States district court without regard to the amount in controversy or in any other court of competent jurisdiction within 1 year from the date on which the violation occurs. So amount in controversy, this is basically the amount that your remedy is, what you're suing for, and you would state it in your affidavit. So just keep that in mind. So 1692 KD is what you want to focus on when you're going about your remedy. So before we get a little bit deeper, are there any questions? We're going to get into the administrative process. We just got into the literacy aspect. We're just getting started. So I hope y'all aren't sleeping. That was only the beginning. And that should have been reviewed to a lot of y'all, to be honest. If it wasn't reviewed, don't be discouraged, because I know not everybody knows about the law, but that was really only the beginning. Any questions? Okay, we ready to get into the real stuff, huh? All right, so let's get into the administrative process. Hold on. I could leave this open. I don't need to leave this open anymore. We already reviewed everything. Okay, so we're gonna get into the administrative process. So this is a process, not the process. This is a process, not the process. So administrative process. What you're gonna do, anytime you're dealing with a debt collector, what you wanna do is send a debt validation letter. So you can send a debt validation letter pursuant to 15 USC 1692G, which is what we talked about earlier. And then also, like I said, we're gonna look at UCC 9-210. I haven't talked about it. Not a lot of people use it, but it is something you can use. On top of the debt validation letter, we're gonna send a notice to cease and desist. So 1692 CC, or you can use 1692 CC, or you can use 1692 GC as well. Just letting them know to stop attempting to collect on the debt. And the reason why I bolded notice, sometimes some people just send a letter and they say cease and desist. You don't want to do that. You want to put notice. Remember, language is very, very important. You want to put notice to cease and desist. The reason why you want to put notice instead of just putting cease and desist is because the word notice allows it to be something that's used in a court, right? If you're just putting cease and desist, it doesn't technically mean it's going to help within your case. So you want to put the word notice. Just that piece right there. I don't think I've talked about that on the podcast. You know, I only want to give information to people that are serious. So remember to put the word notice when you're writing your cease and desist. So once you send that debt validation and your notice to cease and desist, let's say it's 14 days, 30 days, you gave them, right? When it comes to UCC 9-210, the reason why I like using UCC 9-210, which is a different form of validation of debt, it allows you to say they have to respond in 14 days. And remember what I said about time. Time is very, very important. We don't have time to be waiting left and right for them to reply to us, right? So we want to get straight to it. So once that 14 days, 30 days happens, where we sent our debt validation and our notice to cease and desist, we want to send it certified because we want to make sure when they receive it. When you send it certified, you're going to know that they received it. And then number 2 is optional, which is what I talked about earlier. You can follow up with the multiple debt section, 15 USC 1692H multiple debts. Why can you follow up with the multiple debt section? Because you disputed the debt by saying, I need validation, I need verification of this debt. Once they receive it, that debt is now in dispute. Any item in dispute on your credit report pursuant to 15 USC 1681I, they're not supposed to be attempting to collect on that debt. So now what I'm gonna do, I'm gonna send you 1692H multiple debts. Please redirect my previous payments and this a payment that I just sent and apply it to me. Send it to me via check or whatever. So that's an optional thing you can do. You don't have to do all that. You can do that in your invoice later, but that is something that you can do. After that, it's gonna be your affidavit, right? You're gonna send your affidavit. So this is technically like step 2 or step 3 if you do multiple debts. So the affidavit, the whole purpose, this is your most important document when it comes to winning your case. The affidavit is important because it's going to show your exhibits, right? It's going to point out how they didn't provide an authenticated record by law. Authenticated record is more of language used in the UCC 9-210, which we're going to look at. But they didn't provide validation. That's basically what your affidavit is going to talk about. And you're going to point out to them how they're violating the cease and desist notice, if applicable. And in the affidavit, I'm going to show y'all an example. And keep in mind with the example that I'm going to show y'all, I do not sell that. I do not sell the letter only to people. I only give it to people that have been on a consultation because I know you're serious if you book a one-on-one consultation. So I'm going to give y'all like a preview, just to give y'all an idea of what you should put in your own affidavit. But understand, if you got the Fair Credit Reporting Act Masterclass, I went over like what to include in your affidavit of truth. But the affidavit I'm going to show you here is a deeper affidavit and it has everything you need to do just to get everything, right? So you'll see that it's a little bit different from what you saw in the Fair Credit Reporting Act class. So after that, remember your affidavit is your most important document because it's really where you're you're seeking a default judgment based off of Rule 55, which is what we're going to talk about. That's one of the laws that I haven't talked about on the podcast. I only reserve it for people that are serious. We're really talking about litigation here because I want y'all to get y'all desired result, whether it is a deletion, if it's collection, charge off, whatever, or if what you want to get is remedy, right? Because, you know, you could get paid off of these people. So we're going to send a notice of default. So basically what we're going to do is we're going to let them know again that they failed to provide you the information in the allotted time, whether that is 14 days, 30 days, etc. And, you know, it's going to be a violation of 15 USC 1692G if you choose to use that section, or it's going to be a violation of UCC 9-210. I like UCC 9-210 because, like I said, the law says they have to reply in 14 days. That 1692G says 30 days. I like a faster approach. It's up to you what you use, right? And then, you know, you're going to have an opportunity to cure. So you're going to send them that letter. And then you're basically going to reference a previous notice that you sent them. Remember, notice is very, very important. The word notice, like I said, notice to cease and desist, notice to do this, notice to do this. Notice can be used in court. Language is very, very important. So you're going to send your opportunity to cure. And it's basically a final attempt at resolving the issue, whether you want a deletion or if you want to, you know, get paid for them violating you and your rights. So an example of opportunity to cure that you can, example law is 15 USC 1681 S-2. It's basically talking about when you've showed them that they have reasonable cause to believe that the information that they're reporting is inaccurate. So you can use that law in your opportunity to cure. If you don't get your desired result, we don't got time to be going back and forth with these debt collectors. Nothing is saying that you can't sue these debt collectors. So then we get into litigation. All right, so we're going to get into it. I'm going to get y'all started as far as it. And then if you want more information, obviously, you know, when you're suing somebody, you can get thousands upon thousands of dollars. I don't think it's crazy to let y'all know. If y'all want, you know, assistance with the process, you're going to have to book a consultation. What is $350 to, you know, what you're going to get in court, right? So just keep that in mind. What I want to say, going back to what I said in the beginning, this is a process, not the process. So my point in saying that, your affidavit, this is how I do it. Now, just over time, I've, you know, changed the process. I used to do the administrative process just like this, right? Send a letter, wait for them to reply, send a letter, wait for them to reply, send a letter, wait for them to reply. Your affidavit can include everything. So you can send one notice and then just get straight to suing them if you want. So affidavit can include the notice of default, and it can include opportunity to cure. You can warn them in one letter, everything that they have to do, and it includes your debt validation. So your affidavit can include literally everything. You can do everything in one notice because we don't have time to be going back and forth with these people that don't want to, you know, stop harassing you. So you can do it and then get straight to litigation. I just want y'all to know that. And then one thing too, a best practice, I want y'all to look up the register agent address of the debt collector. I want y'all to look up the EVP, which is executive vice president if you can. And I want y'all to look up the general counsel if you can. The general counsel is basically like the attorney or whatever for that company. So when it comes to looking up those, you're going to see on the affidavit example, you're going to basically send out the letter to them as well. You want to put everybody on notice. This is how it works to the best of your ability. So this is why we do things like state attorney general complaint, CFPB complaint, things like that. I wouldn't focus too much on the CFPB complaints and things like that. You just want to use it as a paper trail. Don't rely on them to help you. Take these people to court, sue them, right? So that's what I would recommend to y'all. And then a lot of people don't know, but you can notarize with or without the United States. So notarizing with or without the United States means that you can, if you're doing it without the United States, basically you don't have to go through a notary. You don't have to get the document notarized, right? So this is a power you have as a consumer within, you know, United States. So a lot of people don't know it's more than one United States. So this is why it's important to study these laws, and it's important to invest in things that I have because, you know, I'm studying these laws so you can just follow my lead or whatever, but it's important to understand too. So when you're signing without the United States, it's 28 USC 1746, number 1. The thing that you have to do, you have to quote Matthew 18:16, and that basically talks about having 2 witnesses. And, you know, that's obviously from the Bible. A lot of people might think like, oh, you know, is it a religious thing? It's not necessarily a religious thing. It's just that the Bible is the law of the land. Let me give y'all an example. There's a public law you can look up. I forget it off the top of my head that lets you know the Bible is a law of the land. But an example as far as how the Bible is the law of the land is basically like, let's say you have a debt and they say, you know, with credit, on your credit report, your consumer report, it's 7 years and then it falls off. It literally says in the Bible, after 7 years, stop collecting on, you know, a debt. So that just goes to show you a lot of these policies, the Bible is a law of the land. So when it comes to notarizing without the United States, you're going to quote the scripture, Matthew 18:16. So write that down. If anyone has heard me say, go this deep on a podcast, let me know. I'll send you $10,000. You know what I'm saying? So yeah. So let's look at 28 USC 1746, number 1. I just want to show y'all the notarizing real quick. So this is 28 USC 1746. Remember, I said it goes deeper than 15 USC. 15 USC is what you'll get on a podcast. When you get in classes, private stuff like this, you're going to get more than Title 15. So 28 USC 1746, this lets you know how to actually notarize your affidavit. So number 1, this is if you're executing without the United States. This is what I was talking about. So if executed without the United States, you write the same thing as what you write on number 2. But the main difference, like I said, 28 USC 1746, number 1. Number 1 says if you're notarizing without the United States, you have to have 2 witnesses. 2 witnesses, and you have to quote the scripture, Matthew 18:16. So that allows you to notarize without a notary. So you don't have to notarize with a notary. You can notarize without the United States. If you notarize with the United States, then that's your typical affidavit where you get a notarize. You go in front of a notary, they sign it, stamp it, all that. But if you want to notarize without the United States, 28 USC 1746, number 1. When it says 2 witnesses, you know, that's up to you, whoever that is. So yeah, just really understand that. Do more research on that on your own. That's more independent study stuff. I just wanted to expose y'all to that because, you know, you invested in the class. I want to give y'all the bang for your buck. I think everybody here using the code, you invested $120. I hope by the time we're done with the class, you think $120 was worth your time being here. All right, so I also want to show y'all the UCC code I was talking about. So this is a different form of an affidavit. This is a different form of a validation of debt. So UCC is Uniform Commercial Code. And Uniform Commercial Code is commercial law. Courts, they use commercial law. So these laws are very, very powerful. So UCC 9-210 is request for accounting. You as a consumer, you have a right to request for accounting. What is a request for accounting? The one I want you to focus on is UCC 9-210, number 2. So UCC 9-210, number 2 says request for accounting. Request for accounting means a record authenticated. That's all I want you to focus on. A record authenticated, right? So an authenticated record means that it's signed by an official. So if you send out a debt validation letter and you decide to use UCC 9-210, what you're telling them is that they have to give you a record authenticated. So when they send you something that is a statement saying that, oh, these are things you paid and all that, it wasn't signed. It wasn't authenticated by an official. It has to be authenticated by an official, and they're never going to do all that. Why is that so powerful? Because they're never going to do all that. That means they didn't adequately validate the debt. You have a right to request for an accounting, right? So because they're not going to send you a record authenticated, that now becomes the fact that they didn't answer adequately to your affidavit. So you put this in your affidavit, how they didn't answer it, and now your affidavit stands as a truth. So you can use 15 USC 1692G for your validation of debt and your debt validation letter, or you can go to Uniform Commercial Code. You can use UCC 9-210, request for accounting. And like I said, the reason why I like UCC 9-210 is because of speed. Let me show y'all in the law where it says 14 days is when they have to reply. So a person that receives a request for accounting for authenticated record, look right here. Within 14 days after receipt, by saying the debtor an authenticated record. So basically it's saying when they receive that notice, they have to reply in 14 days versus 30 days in a 1692G. So that goes a little bit deeper beyond the scope of Fair Debt Collection Practices Act, but UCC 9-210 is related to debt. So that's why I wanted to include it in the class. and just reward y'all for investing in yourselves. So that's UCC 9-210. And we also went over 28 USC 1746. So, notarizing without the United States. So now what we're going to do is we're going to go through the example affidavit. And then we're going to go over invoice and other stuff. How y'all feeling? Are y'all with me? Let me know if y'all awake. Let me know if y'all sleeping. Let me know what y'all doing. Hopefully y'all awake. If you're sleeping, if you're missing anything, hopefully you bought the replay or you buy the replay. All right, so like I said, you can put everything in one notice. Everything can go in one notice, right? So this is your affidavit. This is the 11-page affidavit that I use personally. Like I said, I don't trust everybody to take action. So I only give this template to people that booked a consultation. So if you booked a consultation, then you can get this affidavit. But if you didn't book a consultation, then you obviously don't have the affidavit. So let's just walk through it real quick, and then we're gonna go into the next section. So notice to agent is notice of principal, notice of principal is notice to agent. If you don't know what that means, this basically just means when you send out this affidavit, the notice to agent is notice of principal is notice to agent. It means that by law, it's supposed to get to the right person, the right department. So for example, sometimes when you send out these notices, it gets to the clerk, the front desk clerk. That's not even the right department. It could be the wrong department. But when you put notice to agent is notice of principal is notice to agent, it's a binding document. It has to get to the right person. And then I put silence as acquiescent. I put silence as acquiescence. What does that mean? That means if they don't reply, it stands as truth. But it doesn't just go there. If they don't reply line by line, it still stands as truth because they didn't refute it correctly. An affidavit has to be refuted line by line in order to be refuted adequately, but they're never going to do all that. If they won't do it on a simple debt validation letter that might be 1 to 2 pages, you think they're going to reply line by line to my 11-page document? No. So yeah, put the date, put your name and address, put the debt collector's name and their address. And then this is why I say you want to look up the registered agent. When it comes to, getting your desired result and doing this effectively, you're going to have to do research. So you might be like, how do I get the registered agent? Google the Secretary of State, right? They should be registered as a business on the Secretary of State. Where do they do business? You'll find a registered agent. You'll find a registered agent address, right? You can search the Secretary of State website in the state that they're registered in. So you should know where they're registered in, obviously. You can also search their trust indenture. So just really understand that. Okay, hold on. Let me scroll down. My picture is in the way on this Zoom. All right, so if you do have the document, you want to keep this in there. And then you would say, you, private woman or man, you'll put your first, middle, and last name. You would just say, basically like in a normal affidavit, that what you're about to say is facts and to the best of your ability. And then what we put is within 14 days of receiving this document, they have to reply. If they don't, it's they didn't reply to it adequately. So now they're in trouble, right? And then remember what I said. A lot of people just say, 15 USC 1692K, that's how you get money. But we're looking at 15 USC 1692K D specifically, right? So we're looking at D specifically. So basically, once I say that, I tell them I'm looking for a Rule 55 judgment, Rule 55 default judgment. We're gonna get deeper into that, but Rule 55 judgment, default judgment. This means that if they don't reply, I'm looking for a default judgment. I'm gonna get my remedy. So that's how you want to look at it as. Remember, this is an 11-page document. So then I say I require proof of the following to authenticate, this account. So 1692C, proof of your permission to contact me regarding this debt. Obviously, we didn't give them permission, so they can't even prove that. Number one, they can't even prove that. So it's like they can't even refute the document. But we asking them over 50 questions here. Proof that I gave you permission to speak to me as a communication from an attorney is illegal. 1692E number 3, go back to that. That's illegal, right? And then, it just goes on to say different things that they have to satisfy. And like I said, I give this to people that have been through consultations. If you haven't been through a consultation, you can book a consultation. I'll give you this example. That's how I'll know you're serious. But yeah, it asks all these questions. We go through like over 50 questions. And then basically At the end is where you certify. Remember, your signature is very, very powerful. So if you're certifying, if you're notarizing without the United States, 28 USC 1746 number 1, that's what you'll say here. So I notarize without the United States. So that's what you'll put there. And then I just put John Doe as an example. Like a normal affidavit, you'll say the day and the month. And then you'll say attached exhibits of violations and invoice for violations. So exhibits are everything we did earlier, right? Everything we did earlier as far as identifying the violations and things like that. Also, I just remembered I got to show y'all the PDF I'm going to send y'all. Those of y'all in the live class. So I'm going to do that in a little bit. But yeah, basically this is where they are supposed to sign. They're not going to answer everything, but this document is all you need to send. We're going to get into litigation and what you need to send as far as getting your desired result. But you want to send an affidavit that has everything if you want to do it quickly. Or like I said, it's nothing wrong with doing the administrative process where you send your affidavit, then you send your notice of default, then you send your opportunity to cure, and then you go about litigation. But you can literally, this 11-page document, it literally has everything in it. I just sent one notice and then now it's litigation. And then as far as authenticating your own signature, just a best practice, you want to sign in blue ink. Use a blue pen when you're signing, when you're signing with your name. Do not use a black ink because black ink represents a dead entity. Blue ink is certifying it that you're signing it. And then what an additional thing you can do to authenticate it, you can get a red ink pad. Red ink pad, thumbprint. Your thumbprint is very, very powerful. Thumbprint and then stamp it. So that really certifies the document. So that's what you send out. Once you send that out, they're not going to reply to it within that 14 days. And then that's when we get into litigation. But before we even get into litigation, I want to walk y'all through the whole invoice thing. But before we get into that, I want to show y'all the cheat sheet thing I was talking about. So this document, it literally has everything we talked about today. And I'm going to send it out to y'all. And it's just a way to, look at everything on one simple page. So those of y'all that's here on the live class, you're going to get this. If you're watching the recording, maybe screenshot, I don't know. But just a treat for the people that came on the live class. So I'm going to email that to you guys when we finish the class. You'll get it within 48 hours. So we went over the affidavit, right? So affidavit is finished. Like I said, I don't sell this document, so don't ask me for the document. If you book a consultation, then I can give you the document. We can walk through it and make your disputes more powerful. So this is done. Administrative process, I can leave that up. But now we're gonna look at the invoice, and then we're gonna get into litigation, and then we're gonna get into charge-offs and stuff like that. So yeah. So your invoice, everything in the law is language. Remember, everything in the law is language. So you want to title your invoice bill of particulars or true bill. So what does bill of particulars mean? It's just a formal way to present your invoice in common law, which is what we're in. It's an itemization of the claims in a lawsuit against the defendant. Remember, the debt collector is the defendant, you're the plaintiff, you're suing them, right? So you want to title it bill of particulars. Or true bill. True bill is the decision to indict the defendant. So you're saying that they're committing criminal activity, basically, or they're committing a violation against you. So you want to call it what it is. These are law terms you want to use. You don't want to just, in the beginning, I used to just say invoice, You could say invoice, but this makes it more official. So on the invoice, you'll put the date on the invoice. Then you'll say these are invoice. This is an invoice for the violations. And you'll let them know. Please remit the payment to the address on the true bill within 10 business days. It's up to you. You can do 7. Or whatever, but this is an example. And you'll say, attention, debt collector name, and you'll put their address. And you'll put your name and your address. And then this is how I would structure it. You'll put the description of the violation, the quantity, the unit price, and the cost. Someone got a caught in my mouth, my bad. So 15 USC 1692 B number 2. So if that's a violation, if they violated me 2 times, the unit price is $1,000 per violation. It's 2 of them though, so the cost is $2,000. 15 USC 1692 CC. They violated my cease and desist, right? They did that 5 times. Unit price is, well, it should say unit price is 1,000. That's my bad. Unit price should be 1,000, but that was 5 times. So $5,000 violation. 15 USC 1692 D number 2. One time violation, $1,000. $1,000 is how much it costs. Escalator fee, which is basically a late fee. It's up to you what you determine that to be. It could be, sometimes when I put in my letter, I'll be like, it's $50 a day or $1,000 or something like that for the month, right? So you could make it $1,000 and then, that's $1,000. So you'll put the subtotal and then you'll put the total. And it's $9,000 in this example. Then you'll say, thank you. The remedy is being pursued in relation to Rule 55 of the Federal Rules of Civil Procedure and 28 USC 2201. When we get into litigation in a little bit, we're gonna get deeper into that. But this is basically how you wanna structure your invoice. And then you're gonna put your name, beneficiary. In law, beneficiary is a person, receiving the remedy. So that's why you wanna structure it like that. Any question on the invoice? Any question on the invoice? How are we feeling? Are we awake? Are we sleeping? Let me know. This is how you can structure your invoice. So we're going to get into the charge-offs, deleting charge-offs, just something extra you could do. And then we're going to get into litigation and then miscellaneous info. And then we're going to call it a night after y'all have questions, if you guys have any questions. Okay, no, there's a question. Can you invoice them for deletions too? Since it's technically an omission. Oh yeah, that's something I wanted to say. I think I was gonna cover it later. But yes, you can invoice them for the deletions, because what you wanna do with your invoice, okay, this is what I should have said. What you wanna do with your invoice is you wanna invoice them as soon as an action happens. So let me expound on that. You wanna invoice when an action happens. When you get a deletion, that is admission. So that's when you're invoicing them. But if I don't know if your question is saying if you invoice them before you get a deletion and you invoice them after you get a deletion. I don't do that. I wouldn't do all that. But basically when you're invoicing them when an action happens. 2 actions. One action is they delete the information. A second action, they don't reply adequately to your notice. They ignore your notice. That's an action. They took an action to not reply. So you invoice them. So whether it is a deletion or they don't reply, you can invoice them. So yes, you can send an invoice after they delete, because that is an action. Technically, you're supposed to send an invoice after an action happens. An action can be when they delete it, because that is admission. An action can be they didn't delete it and they ignored you, right? So basically, let's say you sent a notice to them and then they didn't delete it and they didn't reply in time. You can send that invoice because them not replying in time is an action. Let's say you send a notice, they do delete it. They admit it. So now you want to go back and invoice them. But as far as charge-offs. So charge-offs, I think we all know. If you listen to my charge-offs episode, you do know. Charge-offs are basically income. So it's not supposed to be reported on your consumer report. Because income is not supposed to be reported on your consumer report, it's inaccurate information. So we're obviously going back to the Fair Credit Reporting Act. So charge-offs can be very, very stubborn sometimes. So one thing that we've been doing within our business as far as credit repair, sometimes what we'll do is we'll send out IRS tax fraud forms. And this is something you can implement within your own pursuit if you're helping someone get a charge-off deleted or if you're deleting a charge-off yourself. So this IRS tax form that you're going to want to send as far as IRS fraud is a form 3949A. So basically you're going to fill out section 2, which is about the business. Let me pull up the form. Hold on. Okay. So yeah, let me max out my screen. So if you got a debt collector, charge off, whatever, you're going to skip number 1 because it's not about an individual. Number 2 is going to be the name of the business. So you're going to put their information. And then number 3, you're going to describe the violation. So it's really up to you. But what we do is a lot of these boxes you can check. The one that we choose is we check false exemption, false deductions, failure to withhold tax, failure to file return, and other. So like I said, it's up to you what you decide to choose. But, you know, that's what we do. The whole purpose of filling out this form is letting the IRS know that they did not send you your 1099-C, because this is the approach you want to do with a charge-off. Whenever you have a charge-off, you want to request a 1099-C form because the company wrote off your debt and they're supposed to have filled out a 1099-C form. If they didn't fill out a 1099-C form, they're committing tax fraud. So this is why if you send out the notice and they don't send you that 1099-C, which happens a lot of times, take it directly, send a notice to the IRS for tax fraud. I'm not saying the IRS is going to do anything, but it helps when you're filling out a form where they do business to the Attorney General. You let the state Attorney General know in your complaint. You filled out an IRS tax fraud form. You put in your CFPB complaint and other complaints. I'm just giving y'all an extra measure as far as, you know, this is related to the scope of debt collection. So this is what it is. If you don't have charge-offs, you don't deal with charge-offs, just sit through what I'm talking about right now. But yeah. So like I said, number 3 is where we check those boxes. Number 4 is where you would skip. Number 4, you would skip it. And then number 5 is where you describe what happened. So this is how we do it. We say, so this is after we sent a 1099-C form. I requested my 1099-C form that should have been given to me by insert the name of the company, but they failed to give it to me. So it is under my assumption that they have committed tax fraud by not filing. The account number for this reference account is XYZ. If they did file a 1099-C form and just didn't give it to me, it needs to be deleted from my insert the credit consumer reporting agency it's reporting on, wherever it's reporting, because it's inaccurate. Since per the IRS, it is now classified as income, and income is not supposed to be reported on a consumer report. So that's what you would put in number 5. So this is what you would put. And then number 6, additional information, you can skip that. Number 6, you can skip that. And then section C, number 7 is about yourself. So you put your own information, whatever applies. So if you're doing it for a client, you know, put the client's information. And then you're going to print the form and send it to the IRS. So you're going to IRS, can I highlight this? Oh yeah, I can. PO Box 3801 in Ogden, Utah. So you're going to send that out and you have notice that you've sent it out to the IRS. So mail to Internal Revenue Service, PO Box 3801, right? And then once you do that, in my opinion, the next step would be litigation. Because the whole point of litigation is you attempted to resolve the issue that you have with them in private. So this brings me to my next point. Let's talk about litigation. Anybody have any questions about the charge-offs? Let me know. That was just a quick walkthrough. I don't think anyone has questions, but if you do have questions, go ahead and let me know. Or we're gonna get straight to litigation. This is the fun part. We're gonna get straight to suing these people when they're not acting right, which is 99% of the time. All right, so litigation. So when it comes to litigation, I need y'all to really make sure that you built up your case prior to suing. The main thing, your main piece of evidence is in them not replying line by line to your affidavit. When they don't reply line by line to your affidavit, remember that 11-page affidavit I showed? If they don't reply line by line to that, which I've never had a situation where they reply line by line to it, you got yourself a case, you can sue them, right? So like I said, like I was just saying like a minute ago, the goal is to settle in private with a private claim, but if they don't resolve it, we make a complaint, which is public, meaning we're suing them. Right? And then, like I said, we're going to be suing pursuant to 1692 KD. This is for district courts, 1692 KD. So the amount you can sue for is up to $75,000. If you want to sue for more than $75,000, you go to the further relief section in 28 USC 2201. So these are the laws you want to be aware of when you write your affidavit. And this helps you build up your case. So when you're writing your affidavit, if you don't have my 11-page one, you're going to want to include these laws. Like I said, I don't talk about these laws on the podcast or anything. I only want it in the right hands. So Rule 55 is default judgment. So Rule 55, default judgment. Write that down and look it up. Default judgment, you want it by the clerk. You don't want it by the judge because the judge is not there to, help you or anything. Default judgment by the clerk, when you read it, it says a sum certain. A sum certain is basically the amount that you're suing for. And that's what you're going to put in your affidavit of truth. This is your remedy. So Rule 55, when it comes to litigation, when it comes to suing these debt collectors, consumer reporting agencies, whoever you're suing, write down Rule 55, Rule 55, Rule 55, Rule 55. You want to be familiar and be aware of Rule 55. Put that in your affidavit of truth, affidavit of truth, whatever you want to call it. You want to combine Rule 55 with 28 USC 2201A. This is the creation of your remedy. 28 USC 2201A. This is the creation of your remedy. When you combine Rule 55 and 28 USC 2201A, this is where you're able to, get the remedy for the violations that we invoice them for. You also want to use Rule 301. Rule 301 basically says that they have an obligation to reply line by line to your affidavit. So you're just using all these laws to back yourself up to have the best case in the world. And then Rule 602, this is the need for personal knowledge. This basically rules out attorneys from participating in the case. So let me give y'all an example. If you're dealing with a debt collector, you're suing a debt collector. Obviously, with that debt collector, something happened where you applied using your social security card and everything. So in that transaction, the only dealings was with you, the consumer, and the creditor, the debt collector, right? So if an attorney is communicating with you, let's say they hire an attorney, the way to roll that out is use Rule 602. So use Rule 602. If you let an attorney know about Rule 602, they're going to know and be like, okay, this person knows what they're talking about. And they have no choice but not to reply, because when it comes to law, everything's under the penalty of perjury. So for an attorney to come and say and represent them, Rule 602 knocks that out because they didn't have personal knowledge of the situation because they weren't there for the transaction. This is why Rule 602 is very, very powerful. So really understand that. As far as formulating it and everything and the proper forms of fill out, you'll have to book a consultation for all that. But, I just want to expose y'all to it if you're not familiar with these rules and, 28 USC and all that. So like I said, also in 28 USC, notarizing. You can notarize with or without the United States. 28 USC 1746 number 1. If you want to sign without the United States, you just have to have 2 witnesses and remember, quote, scripture. You want to use those 9x12 manila envelopes. So when you're sending out your documentation and everything, use those envelopes. Don't be just using regular envelopes. You don't want to be folding papers. You want those big envelopes so the paper can stand in there and not be folded. You want to take this court stuff serious. And you can sue in small claims court. Usually it'll be like $60 a file. Or you can sue in district courts. It's about like $400. If you don't want to pay the $400 to sue, I'm going to give y'all a form. I'm going to reference a form that you can use to fill out to waive that fee. So you can technically sue for free, right? So just do your research and fill out the proper paperwork. Like I said, you could book a consultation if you want more information. I'm just presenting it to y'all. It's a lot of information today. So obviously just pay attention, take notes, do more research later. All right, so when you're suing in district courts, so the forms you want to have is your civil cover sheet. You want to have your complaint for civil complaint form, and you want to have the summons and civil action form. So the summons and civil action form, each company you're suing is going to need this form, need the summons, right? So let me give you an example. Let's say you have a debt collector, they're reporting something on your consumer report that you don't want reported. So let's say it is debt collector 1. Let's call them debt collector 1. So if you're suing debt collector 1, but what's reporting is on your Experian, TransUnion, and Equifax, you need to also sue Experian, TransUnion, and Equifax. So they get the same damages, right? Because they're also participating in the situation. And when you're sending out your notices and when you're serving, you need to send it to every single person, right? Every single corporation or whatever you want to call it. So just keep that in mind when you're doing your summons. You want to send an example. You want to send a summons document to everybody involved. And then, which is optional, this is the form for waiving that $400 fee. So application to proceed in district courts without prepaying, right? So this is what you can submit. These are the forms you basically need to, get this process started for suing, for litigation. And, using these rules, Rule 55, Rule 301, Rule 602, 28 USC 2201. This is how you get the ball rolling. If you want more information, like I said, book a consultation. But this is just presenting it to y'all. As far as like suing Equifax and small claims court, let me give y'all an example. So what you're gonna need a copy of your statement of claim. So basically you can e-file, so you go online and fill out something. And then basically the clerks, they have to approve of your case. As soon as you fill it out, it should be approved within 5 to 10 minutes if you fill it out right, depending on, how busy they are, I guess. In my experience, like 5 minutes, it'll be approved. And then you have to get 3 copies of the marshal's entry of service document. So you have to send 3 copies of that document. So look up that document, and then you send a $50 money order to the marshals. So that's an example of suing Equifax in small claims court. And yeah, that's pretty much what it is as far as litigation and getting the process started. Any questions as far as that before I go on to the miscellaneous section? This is how you want to start the process. This is how you want to start the process of litigation. It can get really deep, but I just wanted to present it to y'all. Y'all do further research. Make sure you're understanding what the FDCPA is actually saying, and then you'll be able to get your desired result. All right, we're going to go into the miscellaneous section, and then we're going to be closing it out if y'all don't have any questions. So there's a litigation. Let me just leave that up. Okay, so there's questions. So miscellaneous. This miscellaneous information. I want to give y'all some extra laws that you can use besides Title 15 that you can study for independent study. So laws for independent study. UCC 9-210, which I mentioned earlier, request for accounting. 14 days, they have to reply, right? Request for accounting is request for an authenticated record. So them sending you a statement, that's not a validation or verification, whatever you want to call it. When it comes to discharging student loans, 34 CFR 685.215. Use that law, look it up. It's a deeper process. Book a consultation if you want to get deeper into it. 18 USC 1341. So this is a Title 18 mail fraud additional violation. Basically, if they send you a letter saying that you owe a debt, because that's considered a mail fraud. So obviously we focus on Title 15, but Title 18 also has violations you could use based off of them attempting to collect a debt from you. So just look that up and study it more. Rule 55 default judgment, that may be new for some of y'all, like I said. 28 USC 2201, creation of your remedy. Rule 601, remember I mentioned earlier, I said I'm going to tell you a law that says that these debt collectors cannot sue you. Rule 601, if a debt collector sues you, attempts to sue you, they can't sue you by law. Rule 601. So use Rule 601 in your refute of that, your conditional acceptance, whatever you want to call it. Rule 602, need for personal knowledge. This is the law that says that attorneys can't participate because they weren't there at the time of the transaction. So attorneys is only speaking on hearsay. The word, look at the word attorney, attorn. It means to attorn, so twist words. They're only operating on hearsay, right? So Rule 602, it'll get them attorneys out of here. So just remember that. 12 USC 83, banks cannot loan money. Banks cannot loan money, right? So 12 USC 83, this will be important when it comes to like dealing with those financial institutions with whatever credit card stuff you have. 12 USC 1431, banks are borrowers, you are the original creditor, right? So these are laws that you want to study independently and go from there. All right, so let's talk about disputing a traffic ticket, speeding ticket, I said. So disputing police policy officer giving you a speeding ticket. So Rule 2 is what you want to look at. Rule 2 talks about one form of action. It's basically talking about them pulling you over, trying to give you a speeding ticket is a civil action. So the whole process about disputing is a little bit deep as far as actually disputing the speeding ticket and successfully and getting it, dismissed and all that. So like I said, book a consultation if you want to get deeper into that process, but I'm here to get y'all started. a little bit more deeper than what I gave on a podcast. So you want to use Rule 2 and 15 USC 1692 as your foundation for your defense. So 1692E, right? False or misleading representation. So you want to use 1692E and Rule 2. And what you got to understand is that police officers, they are debt collectors by federal definition, right? So nothing they do can be considered criminal. You got to understand that. Nothing they do can be considered criminal. This goes back to Rule 2, one form of action. They're doing a civil action because they work on behalf of the city, which is a corporation. Register on Dun & Bradstreet. Those of y'all that know D&B, businesses are registered over there. Remember, everything is interstate commerce. So they gave you a ticket without due process. That's where the violation is, and it's a violation of the Constitution. It goes a little bit deeper, but if you look up Rule 2 and you go from there using 1692E and you send your disputes to the appropriate parties, you can definitely successfully dispute that speeding ticket appropriately. And remember, you can, because they're a debt collector, they've assumed the role of a debt collector. All those violations we talked about, that's money. So yeah, just be patient with yourself in the process and you'll be able to figure it out. All right, so some miscellaneous notes too. I want y'all to remember, sign your documents in blue ink, not black, because that means you're a dead entity. And you want a thumbprint in red ink, like I said before, because that authenticates your signature. Red ink pad authenticates your signature. You can get obviously blue pens from like Office Depot. I got a red ink pad also from Office Depot. So maybe they're at Staples too, but Office Depot, you can get all that. Remember, notarizing without the United States is 28 USC 1746, number 1. You want to quote scripture, Matthew 18:16. You want to have 2 witnesses if you want to sign without a notary. But if you want to just keep it the notary way, that's 28 USC 1746, number 2, which is signing with the United States. If your remedy exceeds 75,000, like I said, there's a further relief section in 28 USC 2202. Remember, you want to use 28 USC 2202A with the Rule 55 default judgment when it comes to getting your remedy pursuant to 1692K. Remember, we're looking at D for district courts. Best practice, send out notices to the registered agent address, like I showed you in the affidavit. This is just reminding you stuff. Invoicing, like I said, should happen after an action. What is an action? An action is they delete that item from your consumer report. An action is it's been 14 days and they didn't reply line by line, right? So that wasn't an adequate response. That is an action. That's when you want to invoice. But if you invoice before that, because you're a consumer, you're allowed to make mistakes. You're so powerful as a consumer. So don't be scared like, oh, dang, I did it wrong. All you got to do, send out an additional invoice. I made a mistake in a previous notice. This is the invoice for you, right? With litigation, you want to go after everyone involved. So that goes back to the example I told y'all with Experian, TransUnion, and Equifax. If they're all reporting that information that the debt collector is reporting on your report, right? Don't just sue the debt collector, sue all of them. And you're gonna see on the forms, they're gonna have defendant 1, it goes up to 4. So you can sue, all parties involved. And then litigation, the venue that you're gonna sue the debt collector in is where the defendant does business. This is why when it comes to litigation, when it comes to being successful with these consumer laws, you have to be good at research as well. And a lot of this research is just Googling the Secretary of State. You can even call them if you want and ask them where they do business. And yeah, look up their registered agent address. So that's pretty much it. If y'all have any questions, let me know. Some final remarks. While I give you guys a minute or 2 to ask any questions, I'm going to make some final remarks and then we're going to get out of here. Hopefully y'all got value from tonight. So some final remarks, take action. So there's a lot of information from the literacy to, litigation. I want y'all to have grace for yourselves, but take action. Don't just hear the information and be like, oh, it was all the sauce and all that, but not taking action. I want y'all to focus on taking action. Y'all took action by investing y'all hard-earned money and being here tonight. So take action by going further and actually, taking action as far as a process, whether that is sending your affidavit, whether that is going to court, whether that is booking a consultation with me just to get clarity on, what you need to do. You don't have to book a consultation, obviously, but obviously it'll make the process quicker. All right, don't get overwhelmed. Like I said, it was a lot of information presented today. Maybe what you got to do is go back to the foundation, which is understanding the literacy of the Fair Debt Collection Practices Act. We went over so many violations and things like that. So yeah, just really understand that. All right, and then I will send those that purchased the replay within 24 to 48 hours. If you did not purchase a replay and now you change your mind and you want to purchase a replay, just send me an email, a DM or something. I'll send you the link to actually purchase the replay because it was a lot of information. And I'm going to email y'all, those of y'all that's on the live class. So if you're watching this on the replay, you're not going to get this, but I'm going to email y'all the PDF FDCPA document that I showed y'all that has everything on one page. All right, so that is it for me. Does anyone want to come off mute and give a testimonial just about the process? If you're like shy or something, or if you don't want to, come off mute, what you can do, you can record your testimonial like 30 seconds or something and email it to me separately. But any questions or anyone want to come off mute and give a testimonial about their process, let me know. Let me know. I'm gonna give it a couple minutes for any questions, and then we're gonna get out of here. Let me know. Or if you want to come off mute and give a testimonial. Remember, you can, if you're shy or if you don't want to give the testimonial right now, you can record it as soon as we get off this and then just email it to me at michael@catactics.com. I hope y'all got value from tonight. I hope you learned something. One gem you can implement to help your situation. And yeah, that's basically my hope. I hope that y'all can take action and execute. Any questions? I'm gonna leave 1 minute left if y'all have any questions. If y'all have questions later, I know it's a lot of information to digest, that is something you can do. Somebody said, what did I mean about combining the affidavit? So I think your question is talking about when I said that you can, do I have the administrative thing open? Okay, I don't have it open. But basically, with the affidavit, you can send your notice and default opportunity to cure, everything just in the affidavit. Everything just in the affidavit, your debt validation, everything can be in one notice. You don't have to send it separately, like as a whole administrative process. That's what I meant. Hopefully that helps. Hopefully I answered your question. But if there are no other questions and no one wants to come off mute and give a testimonial, I hope y'all can email me a quick video testimonial. I hope y'all got value from tonight. And yeah, we'll go from there. Y'all have a blessed one. Let me stop sharing and let me stop the recording.